ಸರ್ತಿ ನೋಡೋದು ಬರ್ತಾರೆ. ಅಲ್ಲ ಸರ್, ಈಗ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋಕ್ಕಲ್ಲ, ಕಂಪ್ಯೂಟರ್ ಡಿಗ್ರಿ ಇಲ್ಲೇ ಬಂದು ಇದಾಗುತ್ತೆ ಅದು ಸೆಕ್ಷನ್
ಕತೆ ಹೇಳ್ಬೇಕಿಲ್ಲ ಕತೆ ಹೇಳ್ಬೇಕಿಲ್ಲ ನನ್ನ ಮಗ ಹಾಕ್ಬಿಡಿ ಅಂತ ಅಲ್ಲಿ ಇಟ್ಬಿಟ್ಟು ಹತ್ತು ಮಾಡ್ತಿದೆ ಅಷ್ಟೇ ಅಷ್ಟೊಂದ ಹತ್ತಿದೆ ಅಷ್ಟೇ ಯಾವುದೋ ತಂದಿಟ್ಬಿಟ್ರ ನೋಡಿ ಪರಮಾಶ್ಚರ್ಯ ಆಶ್ಚರ್ಯ ಹೊತ್ತು
ಆಯ್ತು
kindly, one matter for admission. I have moved for the third time. What has happened is
ಥರ್ಡ್ ಟೈಮ್
ಹೌದು ಡೇಟ್ ಇವತ್ತು 19 ಫೈನ್ಸ್ ಕೊಟ್ಟಿದ್ರು. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನು ಅಂದ್ರೆ ಡಿಗ್ರಿಲಿ 6 ಆದ್ಮೇಲೆ ಪೇಜ್ 57 ತಪ್ಪ ಹೊಡೆದ್ಯಾ. ದಟ್ ಇಸ್ 55 ಪೇಜ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲಿಂದ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಡಿಗ್ರಿ
ಏನ 53
ಪೇಜಸ್ ಮಿಸ್ ಆಗಿದೆ ಟೈಪಿಂಗ್ ಅಲ್ಲಿ. 6ನೇ ಪೇಜ್ ಆದ್ಮೇಲೆ 57 ಅಂತ ಹಾಕಿದ್ದಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಅದನ್ನಷ್ಟು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ನಾವು ಎಲ್ಲಿಂದ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ 55 ಪೇಜ್ ಡಿಗ್ರಿ ಇರೋದೇ ಇಲ್ಲ. ಇರೋದು 7 ಪೇಜ್ 8 ಪೇಜ್
ಪೋಸ್ಟ್ ಮಾಡಿಸಿ ಆಮೇಲೆ ನೋಡೋಣ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಮುಂದೆ ಬಂದಾಗ ಹೇಳಿದ್ವಿ ಕೋರ್ಟ್ ಮುಂದೆ ಮಾಡಿದ್ರೆ ಕಂಪ್ಲೇಂಟ್ಸ್ ವಿತ್ ಇನ್ ದಿ ಡೇ ಅಂತ ಬರೀತಾರೆ.
Post before court and Madai Kalsaked.
With your lordships, kindly one submission, my lord.
Yes, madam.
One submission, my lord. Trial court ಅಲ್ಲಿ 27th ಗೆ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಗೆ ಅಂತ ಹೇಳಿ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು ಫೈನಲ್ ಡಿಗ್ರಿ ಡ್ರಾ ಆಗ್ಬಿಟ್ರೆ ಆಮೇಲೆ RSA ನಲ್ಲಿ ನಥಿಂಗ್ ಸರ್ವೈವ್ಸ್, my lord. Before 27th. Please, oblige.
ಬಟ್ ಡೇಟ್ ನ 13th ಕೊಡ್ಬೇಕಂತ. ಮಾಡ್ಕೊಡಿ ಅಷ್ಟೇ. ಆಯ್ತು, ಕಾಮನ್ ಡೇಟ್ ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ 13th.
ಲಿಸ್ಟ್ 2
My lord,
Refer to
list
local
one,
laws.
serial number 21, 230, my lord.
ನಾನು ಪೇಜ್ ವೈಸ್ ಕರೀತೀನಿ.
List number 1 ನಲ್ಲಿ serial number 21.
ವೇಟ್ ಮಾಡಿ, ಪೇಜ್ ವೈಸ್ ಕರೆಸ್ತೀವಿ, ಆಗ ಮೆನ್ಷನ್ ಮಾಡಿ.
Mentioning from page number 3, list 1, 12, 13 to 18, 19 to 25.
21, my lord.
ಹಾ ಹೇಳಿ, ಏನ್ 21?
230 or tomorrow, my lord.
ಏನ್ 230?
2:30ಗೆ, ಯಾಕೆಂದ್ರೆ ಟೋಟಲ್ 22 ನಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ ಸೇಮ್ 21 ನಲ್ಲಿ 22ರಲ್ಲಿ 3-4 ಮ್ಯಾಟರ್ ಬಂದಿದೆ.
ಆಯ್ತು, ಮುಗಿಸ್ಕೊ ಬನ್ನಿ, ನಿಮ್ಗಾಗಿ ಇಟ್ಟಿರ್ತೀವಿ.
ಮಚ್ಚ
ಅದೇನಿಲ್ರಿ, ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದೆ, ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಮಾಡ್ತೀವಿ, ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ ಅಷ್ಟೇ.
ಮಚ್ಚ
ಆಯ್ತು, ನೀವಿಲ್ಲ ಅಂದ್ರೂ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ.
ಮಚ್ಚ
26.
ಐ ರೆಡ್ ದಿ ಪೇಪರ್ಸ್.
ಯಾವುದು?
ಯಾವ್ದು?
19 ಅಂತ.
19? ಹಾ ಹೇಳಿ, ಏನ್ ಯಾವ ಡಿಫಿಕಲ್ಟಿನೂ ಇಲ್ಲ, ಡೇಟ್ ಕೊಟ್ಟಿರೋ ಮ್ಯಾಟ್ರು. ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್, ನೋ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ನೆಕ್ಸ್ಟ್, ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದ್ರೆ ಏನ್ ಮಾಡಕ್ಕಲ್ಲ. ಐ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್. ಐ ರೆಡ್ ದಿ ಪೇಪರ್ಸ್, ಐ ವಿಲ್ ಡಿಕ್ಟೇಟ್ ದಿ ಆರ್ಡರ್ಸ್.
Serial number.
Serial number 57, madam.
ನಾನು ಪೇಜ್ ವೈಸ್ ಕರೀತಾ ಇದ್ದೀನಿ ಸರ್. 26 to 33.
It's 33, my lord, for appellant.
29.
ಹಾ ಹೇಳಿ, ಏನ್
I have filed my power yesterday, ma'am.
ನೀವ್ ಯಾರಿಗೆ?
Appellant, ma'am. NOC along with NOC Vakalat have filed yesterday.
ಸರ್ ಇವತ್ತು
Time may be granted, ma'am.
ನೋಡ್ರಿ, ಇದು ಬಂದಿದೆ ವಕಾಲತ್ತು. ಯು ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್. ಲಾಸ್ಟ್ ಟೈಮ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಆರ್ಡರ್ ಮಾಡಿದೀನಿ.
The order. Yesterday I have received the papers.
ವಾಟ್ ಎವರ್ ಇಟ್ ಮೇ ಬಿ.
Kindly have it.
ನೋ ಡೇಟ್, ನೋ ಡೇಟ್. ಲಿಮಿಟೇಷನ್ ಮೇಲೆ ಫಸ್ಟ್ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ, 3 years ಡಿಲೇ ಇದೆ. ಯು ಆರ್ಗ್ಯೂ ಆನ್ ಓನ್ಲಿ ಆನ್ ಲಿಮಿಟೇಷನ್, ದೆನ್ ಮೆರಿಟ್ ಮೇಲೆ ನೋಡೋಣ.
I have not gone through the papers, ma'am.
ಈಗ ಹೇಳ್ತಿದ್ದೀನಲ್ರಿ, ಲಿಮಿಟೇಷನ್ ಮೇಲೆ ಮಾತ್ರ ಇದೆ. ಯು ಗೋ ಥ್ರೂ ದಿ ಪೇಪರ್ಸ್, ದಟ್ಸ್ ಆಲ್. ಇಫ್ ಯು ಹ್ಯಾವ್ ನಾಟ್ ರೆಡ್, ಐ ಹ್ಯಾವ್ ರೆಡ್ ದಿ ಪೇಪರ್ಸ್, ಐ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್. ನೆಕ್ಸ್ಟ್,
Next week, any date.
ನೋ ಡೇಟ್ ಕೌನ್ಸಿಲ್, ನೋ ಡೇಟ್.
Monday, ma'am.
ಯಾವ ಡೇಟು ಇಲ್ಲ. ಐ ಹ್ಯಾವ್ ರೆಡ್ ದಿ ಪೇಪರ್ಸ್, ಐ ಸ್ಪೆಂಟ್ ಮೈ ಟೈಮ್. ಯು ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್.
I have not seen the papers, ma'am. Kindly have it on my.
ಅದರ್ವೈಸ್ ಐ ಆಮ್ ಗೋಯಿಂಗ್ ಟು ಡಿಸ್ಮಿಸ್. ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅಂತ ಇಟ್ಟಿದ್ದೀನಿ. ಅದಕ್ಕೆ ಇವನ್ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ಬರ್ಕೊ ಬಂದಿದ್ದೀನಿ.
Yeah, I agree.
ಆಯ್ತಲ್ಲ?
Yesterday I have filed
ನೋ
my
ಕೌನ್ಸಿಲ್,
power.
ಡೋಂಟ್ ವೇಸ್ಟ್ ದಿ ಟೈಮ್ ಇನ್ ದಿ ಪ್ರೀಸಿಯಸ್ ಟೈಮ್ ಮಾರ್ನಿಂಗ್.
It's 33.
ಲಿಮಿಟೇಷನ್ ಮೇಲೆ ಇದೆ, ಅದ್ರ ಮೇಲೆ ಹೇಳಿದ್ರೆ ಅದನ್ನು ಹೇಳಕ್ಕಾಗಲ್ಲ ನಿಮಗೆ. ನಾಟ್ ಆನ್ ಮೆರಿಟ್ಸ್.
So I agree.
3 years ಡಿಲೇ ಇದೆ, ಅದ್ರ ಮೇಲೆ ಏನ್ ರೀಸನ್ಸ್ ಕೊಟ್ಟಿದ್ರಿ ಓದ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. ಹಾ
It's 33, my lord, for appellants. Lords, ಇದರಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬೇಕು, my lords. Other family members left out.
ಏನ್ 33?
Serial number 33 for appellants, my lord.
ಹಾ ಏನಾಗಿದೆ?
Lords, an application was up. I need to file application.
ಏನ್ ಅಪ್ಲಿಕೇಶನ್?
Lords, other family members were not been arrayed and the plaint was rejected, my lords. Last occasion I filed an application to bring them as respondents. ಬೇಡ appellants ಮಾಡ್ಬೇಕು
ಕ್ಲೈಂಟ್
ಅಂತ.
ರಿಜೆಕ್ಟ್ ಆಗಿರೋದು ನೋ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಅಂಡ್ ಬಾರ್ಡ್ ಬೈ ಟೈಮ್ ಅಂತ.
ಇಲ್ಲ, barred by time.
ನಾಟ್ ಫಾರ್ ದಟ್ ರೀಸನ್.
No, no, barred by time ಅಂತ.
ಬಾರ್ಡ್ ಬೈ ಲಿಮಿಟೇಷನ್ ಆಗಿರೋದು. ಐ ಹ್ಯಾವ್ ರೆಡ್ ದಿ ಪೇಪರ್ಸ್.
No, lords, ಇದರಲ್ಲಿ
ಯು
limited.
ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್, ದಟ್ಸ್ ಆಲ್. ನೋ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೌನ್ಸಿಲ್. ಓದ್ಕೊ ಬಂದ ಪೇಪರ್ಸ್ ಅಲ್ಲೆಲ್ಲ ನೀವು ಟೈಮ್ ಕೇಳ್ತೀರಿ.
ಇಲ್ಲ, my lords, last occasion I
ನೋ
took-
ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ನೆಕ್ಸ್ಟ್,
34 to 42.
ಮೇಡಮ್, ಸೀರಿಯಲ್ ನಂಬರ್ 34.
ಹಾ ಹೇಳಿ ಮೇಡಮ್.
ಡಿಲೇ
34
ಕಂಡೌನ್ ಆಗಿದೆ ಮೇಡಮ್. ಡಿಲೇ ಕಂಡೌನ್ ಆಗಿದೆ.
ಡಿಲೇ ಕಂಡೌನ್ ಆಗ್ಲಿ, ಈಗ ಅಡ್ಮಿಷನ್ ಮೇಲೆ ಹೇಳಿ. ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದೆ, ಡಿಸ್ಮಿಸ್ಡ್, ಕನ್ಫರ್ಮ್ಡ್. ಅಸಿಸ್ಟ್ ಮಾಡಿ ಕೋರ್ಟಿಗೆ.
ಮೇಡಮ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ
ನೋ ಡೇಟ್,
ಮೇಡಮ್.
ನೋ ಡೇಟ್ ಮೇಡಮ್. ಅಡ್ಮಿಷನ್ಸ್ ಯಾವ್ದು ಡೇಟ್ ಕೊಡಲ್ಲ. 35 ಪೇಪರ್ಸ್ ನಾನು ಓದ್ ಬಂದಿರ್ತೀನಿ, ನೀವು ಬಂದ್ ಬೆಳಗ್ಗೆ ಬಂದಿಲ್ಲ ಟೈಮ್ ಕೇಳಿ. ಹಾ ಎವ್ರಿ ಡೇ ಇವನ್ ಮಾಡಕ್ಕೆ ಆಗ್ತಾ ಇಲ್ಲ ಅಡ್ಮಿಷನ್ಸ್. ಫೈನಲ್ ಇಯರಿಂಗ್ ರೀಚ್ ಆಗಕ್ಕಾಗಲ್ಲ, ನೀವು ಅಸಿಸ್ಟ್ ಕೊಡಲ್ಲ. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ, ಹೇಳಿ ಏನ್?
42 ನಲ್ಲಿ ಇದು ಅಡ್ಮಿಷನ್ ಗೆ
30
42.
ಹಾ ಹೇಳಿ ಏನು?
ಅಡ್ಮಿಷನ್ ಗೆ ಇದೆ.
ಹೌದು.
My lords had directed us to produce the certified copy of the order sheet. That was a direction. ಯಾಕೆಂದ್ರೆ 3 sheet was left blank by the trial court.
ಸೂಟ್ ಏನೋ ಸೂಟ್ಸ್ ಫಾರ್
Suit for specific performance and the purchase. And the purchase.
ಸೇಲ್ ಡೀಡ್ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ.
ನಮ್ಮ ಸ್ನೇಹಿತರು ಮಾರನೇ ದಿನನೇ ಅಪ್ಲೈ ಮಾಡಿದ್ರು ಮಾಗಡಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ. But they have not given us.
ಅದಕ್ಕೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ಅದು ಅದರಲ್ಲಿ our written statement is taken
ನೋಡೋಣ,
off.
ಏನಾರು ಇದ್ರೆ ನೋಡೋಣ, ಆಮೇಲೆ ಇಲ್ಲ. ನೋ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ನೆಕ್ಸ್ಟ್,
43 to 47, 48 to 54, 55 to 60.
57 ಮೇಲೆ
57 ಹೇಳಿ ಏನು?
ನಮ್ಮ ಸೀನಿಯರ್ ಅವ್ರ ಅಂಕಲ್ ತೀರೋಗಿದ್ದಾರೆ. ನಮ್ಮ ಅಗ್ನಿಹೋತ್ರಿ ಸೀನಿಯರ್ ಅವ್ರ ಅಂಕಲ್ ತೀರೋಗಿದ್ದಾರೆ, ಯಂಗರ್ ಅಂಕಲ್.
ಹಾ ಅದರ್ ಸೈಡ್ ಹೇಳಿದೀರಾ? ರಾಘವೇಂದ್ರ ಎನ್ಆರ್ ಗೆ ಪಿಬಿ ಅಜಿತ್ ಅಂತ ಯಾರು ಇನ್ನೊಬ್ರು ಇದಾರಲ್ಲ, ಅವ್ರಿಗೆ ಹೇಳಿದೀರಾ? ತಗೊಳ್ಳಿ. ನೀವು ಪ್ರಾಕ್ಸಿನಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ.
ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ನೀವು ಇದ್ದೀರಾ? ಮತ್ತೆ ಅಸಿಸ್ಟ್ ಮಾಡಿ ಕೋರ್ಟ್ಗೆ ಅಷ್ಟೇ.
ಅವರೇ
ತಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ 6 Adjournment on the ground that uncle of the council on record, Keshav R. Agnihotri, passed away. And also informed, ನೀವು ಯಾರಿಗ್ರಿ? R1 ga? Raghavendra. And counsel for R1 is also present and says no objection, and council undertakes to intimate counsel for R2 and R4. List this matter on 5/12.
61 to 63. List 1. Orders matter serial number 1.
List 1 na?
List
Attack list 1. List 2 ilva?
List 2. Serial number 1.
Madam, allowed.
ಎಲ್ಲದು ನಿಮ್ದೆ ಲೋಕ ಅದಾಲತ್ಗೆ ನಿಮ್ದು ಹೋಗುತ್ತೇನ್ರಿ?
ಅದನ್ನೇ AG ಬರ್ತಾರೆ ಸಬ್ಮಿಟ್ ಮಾಡ್ತಾರೆ ಸರ್.
ಲೋಕ ಅದಾಲತ್ಗೆ ಎಂತ ಲಿಸ್ಟ್ ಮಾಡಿರೋದು ಇದು?
ಹೌದು.
ಲೋಕ ಅದಾಲತ್ ಕಳ್ಸದ?
ರೆಫರ್ ಮಾಡಿ.
ಸರ್ಕಾರದನ್ನು? ಆಯ್ತು.
1 and 2 both my lord.
ಎಲ್ಲ ಸೇಮ್ ಡೇಟ್ 13, 12.
Please.
1 to 10.
List 1. Orders matter serial number 1. Palagangadhara GS sir ಇದ್ರಲ್ಲಿ ID ಅಂತ ಇದೆ.
Perusal of unserved cover returned with postal shara as unclaimed. ID ಇದೆಯಾ? ನೋಡಿ. Notice issued against the R2 was returned with an endorsement unclaimed. And on perusal of the postal shara there is an endorsement to the effect that intimation was delivered and not claimed, and hence held sufficient against R2. Kemparaju.
Serial number 2 ಇದು ಸರ್ ಡೇಟ್ ಕೊಡೋದು. For admission ಅಂತ.
Non filing of acknowledgement. ಏನಾಯ್ತು ಹೇಳ್ರಿ? ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಕ್ನಾಲ್ಮೆಂಟ್ ಬೈ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಅಪ್ಲೆಂಟ್ ಫಾರ್ ಹ್ಯಾವಿಂಗ್ ಗಿವನ್ NOC ಅಂತ ಏನಿದೆ?
ಸರ್ ಅದು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಅವರು
ಇದರಲ್ಲಿ ಸೋಲ್ ಅಪಲೆಂಟ್ ಸತ್ತೋಗಿದ್ದಾರೆ.
ಸೋಲ್ ಅಪಲೆಂಟ್ ಡೈಡ್ ಆಯ್ತು. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನು? He has given NOC ಅಂತಿದೆ. Hence he is directed to produce acknowledgement for having given NOC ಅಂತಿದೆ.
ನಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಈಗ ಫೈಲ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸೋಲ್ ಅಪಲೆಂಟ್ ತೀರೋ ಇದ್ದಾರೆ ಸ್ವಾಮಿ 26/1/25ರಲ್ಲಿ.
ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ ಏನು? ನೀವು
ಫೈಲ್ ಈಗ ನಮಗೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದ್ದಾರೆ.
ವಕಾಲತ್ ಹಾಕ್ತೀರಾ?
ಅದೇ ಎಲ್ಲರೂ ತರಬೇಕು ಸ್ವಾಮಿ.
ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇರೋದು ಅಡ್ವೊಕೇಟ್ ಯಾರು? ಕೆಂಪರಾಜು. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನು ಯಾರು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ದು NOC ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ?
ಅದ್ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ.
ನೀವ್ ಯಾರು ಮತ್ತೆ?
ಅಲ್ಲ ನಾವ್ ಈಗ ನಮ್ಗೆ ಈಗ ಫೈಲ್
ನಿಮ್ಮ ಹೆಸರು ಹೇಳ್ರಿ ಏನು?
ಚೇತನ್ ಬಿ.
ತೊಗೊಳ್ಳಿ. ಕೌನ್ಸಿಲ್ ಶ್ರೀ ಚೇತನ್ ಬಿ submits that the sole appellant is passed away and his LRs have given wakalat. ಹೌದಾ? And going to file a necessary application along with wakalat.
Please.
And hence 2 weeks time granted. List this matter on 5/12. The registry is directed to show the name of the counsel if wakalat is filed on behalf of the LRs of appellant along with LRs.
Hearing on IA3.
Anna Mary Green. ಏನ್ರಿ ಇದು? dispensation notice to deputy commissioner. ಹೇಳಿ ಏನು?
This for dispensation of IA to the notice to the DC, my lord. It's a
Petitioner counsel files an application praying this court to dispense the notice to the deputy commissioner, and in support of the application stated that going to pay the maximum court fee na?
out. Yes,
Maximum court fee and hence notice may be dispensed, and for the reasons stated in the application and affidavit, IA is allowed and
I may
notice
be
against
permitted to
deputy
take
commissioner is
publication, my lord. Publication in Kannada
dispensed.
Prabha. Yeah, I may be permitted to take publication in Hindu and Kannada Prabha.
ಹಾಕಿಲ್ಲ? ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀರಾ? ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀರಾ?
ಇಲ್ಲ ಸುಮ್ಮನೆ.
ಮತ್ತೆ ಹಾಕಿ. Without the application, how can court pass an order?
Okay, my lord.
ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಕೇಳ್ತೀರಿ, ಯಾವ್ದ್ರಲ್ಲಿ ತಗೊಳ್ತೀರಿ, ಅದೆಲ್ಲ ಡೀಟೇಲ್ಸ್ ಕೊಡಿ.
ಆಯ್ತು.
List this matter on 5/12.
4. Party GS.
Paper publication in respect of R5 and R6.
ಇದರಲ್ಲಿ they have not taken the notice.
ಎಷ್ಟು 3 ಸರಿ ತಗೊಂಡಿದ್ದೀರಾ?
ಹೋಗಿದೆ ಸರ್, 3
ತಗೊಳ್ಳಿ.
ಸಲ ವಾಪಸ್ ಬಂದಿದೆ.
Heard on IA number 1/25 wherein prayer is sought to take out the paper publication in ಯಾವ್ದು ಪೇಪರ್ ಯಾವ್ದು ಹೇಳಿ? ಸಂಯುಕ್ತ ಕರ್ನಾಟಕ Bangalore edition against R5 and R6 and for the reasons stated in the accompanying application of affidavit, IA is allowed and permitted to take out the notice on or before 3/12 and date is fixed for the appearance of the R5 and R6 on 5/1/2026.
5. Nagaraj, yes.
ಏನ್ರಿ ಇದು recalling 3/9/25 dismiss ಆಗಿದೆ.
LS application has been filed, my lord. Death report ಮಾಡಿರಲಿಲ್ಲ.
Dismiss ಮಾಡ್ಬಿಟ್ರ? Pending consideration of IA
Submission ಕೊಟ್ಟಿದ್ದೀರಾ? Submission ಇದೆ ಅಲ್ವಾ?
1 and 2. Given 2 weeks time to comply with office objections and list this matter on
5/12.
3 ಸರಿ ಬಂದಿದೆ ಮೇಡಮ್. ಕೋರ್ಟ್ ಇವ್ರ ಮುಂದೆ ರಿಜಿಸ್ಟ್ರಾರ್ ಮುಂದೆ 3 ಸಲ 1 2 3 2 weeks time granted to comply with office objection subject to payment of cost of rupees 500 payable to the so and so, failing which appeal stand dismissed for non-compliance of office objections.
ಇಲ್ಲಿ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅವೈಲೇಬಲ್ ಇರಲಿಲ್ಲ.
ಮತ್ತೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ.
ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅವೈಲೇಬಲ್ ಇರಲಿಲ್ಲ.
ಕಾಸ್ಟ್ ಕಟ್ಟಿದ್ರಾ?
ಕಟ್ಟಿದೆ ಮೇಡಮ್.
ಯಾವಾಗ?
ಕಾಸ್ಟ್ ಪೇಡ್ ಆಗಿದೆ.
ಯಾವಾಗ ಕಟ್ಟಿದ್ರಿ ಕಾಸ್ಟ್?
29/2/2024 ಮೇಲೆ 29/2/2024 ಅಲ್ಲೇ ಕಾಸ್ಟ್ ಪೇ ಆಗಿದೆ.
ಕಾಸ್ಟ್ ಕಟ್ಟಿ ಯಾಕೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಲಿಲ್ಲ ನೀವು?
ಅಲ್ಲ ಇಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ವಿ ಮೇಡಮ್, ಅಲ್ಲ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅವೈಲೇಬಲ್ ಇರಲಿಲ್ಲ.
ಏನ್ ಸಬ್ಮಿಷನ್?
Now it's decided in the telecourt, my lord, ಡೆತ್ ಬಗ್ಗೆ ಏನು ರಿಪೋರ್ಟ್ ಮಾಡಿರಲಿಲ್ಲ, ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರಲಿಲ್ಲ.
Respondent number 1 and respondent number 2 differs in the cost title of RE and OS clarify ಅಂತ ಹೇಳೋದು.
ಅದೊಂದೇ ಸಬ್ಮಿಷನ್ ಬಾಕಿದ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇಲ್ವಾ? ಮತ್ತೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೋರು ಏನ್ ಸಬ್ಮಿಷನ್ ಹೇಳ್ರಿ? ಫಸ್ಟ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಗೆ prayer para to be stated correctly in IAS and delay days to be stated in IA number 2 of 25.
ಅದು ಡೆತ್ ರಿಪೋರ್ಟ್ ಬಗ್ಗೆ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅವೈಲೇಬಲ್ ಇಲ್ಲ ಮೇಡಮ್. ನಾವು ಈಗ ಸಿಕ್ಕಿದೆ, ಇದು ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಡಿಲೇ ಕಂಡೋನೇಷನ್
ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೀರಾ?
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ.
ಆಯ್ತು. 2 weeks time granted pending consideration of IAS 2 weeks time granted. List this matter on 5/12.
Yes.
Serial number 6.
Balakrishna Shastri bringing LRs of deceased R15 as R15 A and B na
Notice has to go.
ಏನಿದು ಮ್ಯಾಟ್ರ್ ಏನು?
ನೋಟಿಸ್
ಹೋದ್ಮೇಲೆ ರಿಪೋರ್ಟೆಡ್ ಆಸ್ ಡೆಡ್ ಅಂತ ಬಂದಿದ್ಯಾ?
ಹೌದು ಹೌದು
ಸರ್ ಅವ್ರು ಕೇವಿಯೇಟ್ ಸರ್.
ಇಲ್ರಿ ಕೇವೇಟಾರ
ನೋಟಿಸ್ ಇಲ್ಲ, ಕೇವಿಯೇಟ್ ಹೋಗಿ ನೋಟಿಸ್ ಆರ್ಡರ್
ಈಗ ಕೇವೇಟ್ ಹಾಕಿದ್ರು ಅವರು,
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ ಮತ್ ಪೋಸ್ಟ್ ದಿ ಅಡ್ಮಿಷನ್ ಅಷ್ಟೇನೆ. ಕೇಸ್ ಇದ್ರೆ ಮಾಡೋಣ, ನೋಟಿಸ್ ಇಲ್ದವ್ರು ಯಾಕೆ ಮಾಡೋದು?
ಪ್ಲೀಸ್
ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ ಆನ್ 5/12.
7.
Recalling the order dated 13/10/25. Arvind C. Desai ಹೇಳ್ರಿ ಏನು?
ಆ ಡೇಟಿಗೆ ಪೋಸ್ಟ್ ಆಗಿತ್ತು ಸರ್, ಗೆ ಹುಷಾರಿಲ್ಲ, ವ್ಯಾರಿಕೋಸ್ ವೆನ್ ಸರ್ಜರಿ ಆಗಿತ್ತು.
ಎಷ್ಟು ಸರಿ ಲಿಸ್ಟ್ ಆಗಿತ್ತು ಹೇಳಿ? ಲಿಸ್ಟ್ ಎಷ್ಟು ಸರಿ ಆಗಿತ್ತು ಮ್ಯಾಟರ್? ನಾನೇನ ಮಾಡಿದೀನಿ ಆರ್ಡ್ರು, ಡೀಟೇಲ್ ಆರ್ಡರ್ ಬರ್ದಂಗಿದ್ದೀನಿ ನೋಡಿ. Matter is listed for admission. The counsel for the appellant sought time in the morning session and this court declined to grant time. On perusal of the order sheet, though this appeal was filed in 2023, even listed for admission on several occasions, the appellant's counsel did not assist the court for admission. On 3/9/25, this court noted that none appears for the appellant. However, adjourned the matter on 22/9/25 and on 22/9/95 on behalf of the appellant time was sought. Right. However, this court granted time to list the matter in the third week of October 25 and accordingly matter is listed before the court today. And instead of assisting the court, counsel for appellant again sought time in the morning and when the same is refused in the afternoon at 3:29 PM, ella time kuda bardide, no representation. On perusal of the records, RS is filed against the concurrent pending of the dismissal of the suit and same is confirmed by the appellate court and hence no grounds. ಹೇಳಿ.
Maybe recalled my lordship
Huh?
and fixed it date for admission.
fixed
ಅವರೇ
date?
ಬಂದು ಅಡ್ರೆಸ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ.
25,000 ಹಾಕ್ತೀನಿ ಕಾಸ್ಟ್ ಆಗ್ಬೋದಾ? ಅಲೋ ಮಾಡ್ತೀನಿ.
ಅವರಿಗೆ ವ್ಯಾರಿಕೋಸ್ ವೆನ್ ಸರ್ಜರಿ ಆಗಿದ್ರಿಂದ ಆ
ನನ್ಗೆ
ಡೇಟ್
ಗೊತ್ತಿಲ್ಲ ರೀ, ಮೂರ್ ಸರಿ ಡೇಟ್ ಓದ್ನಲ್ಲ ನಾನೀಗ ನಿಮ್ಮ ಆರ್ಡರ್ ಶೀಟ್ ಎಲ್ಲ
ಸೀನಿಯರ್
ಕೊಟ್ಟು
ಅಫಿಡವಿಟ್ ಹಾಕಿದೀವಿ.
ಅಫಿಡವಿಟ್ ಓದಿದ್ನಲ್ಲ 3 ಸಲ, ಒಂದ್ ಸಲ ಅಡ್ಮಿಷನ್. ಎಷ್ಟ್ ಸರಿ ಬರ್ಬೇಕು ಅಡ್ಮಿಷನ್ಗೆ? ಎಷ್ಟ್ ಸರಿ ಟೈಮ್ ಕೊಡ್ಬೇಕು? ತೊಗೊಳ್ಳಿ. ಏನ್ ಹೇಳಿ? 25,000 ಕಾಸ್ಟ್ ಕೊಡಂಗಿರ ಹಾಕ್ತೀನಿ ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್.
ಇಟ್ ಮೇ ಬಿ ಪಾಸ್ಡ್ ಓವರ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್.
25 ಸರಿ ಅಡ್ಮಿಷನ್ ಬರ್ಬೇಕು ಕೋರ್ಟ್ ಮುಂದೆ ಕನ್ಕರೆಂಟ್ ಇದ್ದಾಗ ಹೊಸವರು ನೋಡಿ. ಕಾಸ್ಟ್ ಕೊಡಂಗಿದ್ರೆ ನೋಡೋಣ, ರೆಸ್ಟೋರ್ ಮಾಡೋಣ. ಮಂಜುನಾಥ SV recalling the order dated 14/10 ಹೇಳ್ರಿ. ಅವ್ರು ಹೇಳ್ಬೇಕು, ನಿಮ್ದಲ್ಲ. ನಿಮ್ದು ಏನಾರು ಇದ್ರೆ ಕೇಳೋಣ. ಏನ್ರಿ? held up in some other court ಬಿಟ್ಬಿಡಿ. ನಾನು ಯಾವತ್ತು ಒಂದೇ ಸರಿ ಯಾವ ಕೇಸಲ್ಲೂ ಡಿಸ್ಮಿಸ್ ಮಾಡಲ್ಲ. ನಿಮ್ದು ಚರಿತ್ರೆ ಬರ್ದಿದ್ದೀನಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ. ಹೌದಾ? ಹೇಳಿ. Matter is called twice in the morning and also in the afternoon and there is no representative. The order sheet discloses that in the previous occasion, learned counsel for the appellant sought time on the ground that the arguing counsel is not well. In spite of an opportunity is given, the same is not utilized. Hence the appeal is dismissed. ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? 5,000 ಕಾಸ್ಟ್ ಹಾಕಿ. ಯಾಕೆ? ಎಸ್ ಸರ್ ಇರಿ, ನಿಮ್ದು ಆರ್ಡರ್ ಶೀಟ್ ಒಂದ್ ಫೈಲ್ ಆಗಿದೆ. ಕೋರ್ಟಿಗೆ ಅಪೀಲ್ ಹಾಕ್ತೀರಿ, ಸೆಕೆಂಡ್ ಅಪೀಲು ಇದ್ ಮಾಡೋದಿಲ್ಲ, ಬರೋದಿಲ್ಲ. ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಎಷ್ಟು ಸರಿ ಲಿಸ್ಟ್ ಆಗಿದೆ ಕೋರ್ಟ್ ಮುಂದೆ? 23 1 2 ಕಂಪ್ಲೈನ್ಸ್ಗೆ 2. ಆಮೇಲೆ ನಾನೇ ಪೋಸ್ಟ್ ಮಾಡಿದ್ದೀನಿ 23/6/25 ಲಿಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ ಅಲಾಂಗ್ ವಿತ್ IA. Counsel for the appellant seeks time on the ground that is not keeping well. Must issue notice against the respondent on IA number 100. Main registry is directed to secure the records of the trial court as well as the first appellate court. ಆಯ್ತು. ಮತ್ತೆ needful said to have been done.
Reasonable cost may be imposed.
Yes sir, ಇದೆ 25 ಸಲ ಬಂದಿದೆ ಕೋರ್ಟ್ ಮುಂದೆ. 25,000 ಹಾಕ್ತೀನಿ. ಬೇಡ ಓಕೆ ಅಂದ್ರೆ ಸರಿ. 5,000 ಹಾಕಿ. 5,000 ಎಲ್ಲ ಇಲ್ಲ. ಏನ್ ತೊಗೊಳ್ಳಿ ಮ್ಯಾಟರ್ ಏನ್ ನೋಡ್ರಿ. ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಏನ್ ನೋಡಿ. ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಮತ್ತೆ ಇನ್ನೇನು ತೊಗೊಳ್ಳಿ. ಏನು ಹೇಳ್ಬೇಕು ಹೇಳಿ?
ಅಲ್ಲ ರೀಸನಬಲ್ ಕಾಸ್ಟ್ ಹಾಕಲ್ಲ. ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ.
ರೀಸನಬಲ್ 25,000 20 ಸರಿ ಬಂದಿದೆ ಕೋರ್ಟ್ ಮುಂದೆ.
ಬೇಡ
ಫ್ರಮ್ ದ ಬಿಗಿನಿಂಗ್ ತೊಗೊಳ್ಳಿ. Heard on IA number 1/25 for recalling the order dated 14/10/25 and counsel would submit that he was held up in some other court, but records reveals that in the previous occasion also date was taken on the ground that the arguing counsel was not well and in spite of opportunity not utilized the same, and also matter was called twice in the morning and also in the afternoon, and hence the very submission that he was held up in some other court cannot be accepted, and matter was not dismissed at the first instance and it was dismissed in the afternoon session, and hence the very submission falsifies the very ground
reasonable cost
urged before this court, and hence no grounds to recall the order, and hence IA is dismissed.
Milord,
False submission ಬೇರೆ ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೆಲ್ಡ್ ಅಪ್ ಆದ, ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೆಲ್ಡ್ ಅಪ್ ಆದ ಅಂತ.
ಆಯ್ತು 25,000 ಕಾಸ್ಟ್ ಹಾಕಿ ಅಲೋ ಮಾಡಿ.
ಆಯ್ತು ತಗೊಳ್ಳಿ. ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ತೆಗೆದ್ಬಿಡಿ ಮೇಡಮ್. And however, taking note of the order sheet in entirety on several occasions, even though opportunity is given, not utilize the opportunity, and when this court said that going to allow the application, and so counsel submits that the same may be allowed on cost of rupees 25,000 and hence allowed on cost of rupees 25,000.
2 weeks time maybe.
And cost is payable in the registry within 2 weeks. And if cost is paid within 2 weeks, list this matter on 6/12 for admission.
Publish.
6/12 bada 5 alla 8/12.
Publish.
9. Sorry, 5.
ಸ್ವಾಮಿ ನೆನ್ನೆ ವಕಾಲತ್ ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ. ನೆನ್ನೆ ವಕಾಲತ್ ಹಾಕಿದ್ದೀನಿ.
ಆಯ್ತು ಹಾಕಿ ಪರವಾಗಿಲ್ಲ. ಡಿಲೇ ಇದೆ, ಡಿಲೇಗೆ ಹೇಳಿ ಏನು? 1327 days ಇದೆ. ರೀಸನ್ ಏನು ಡಿಲೇಗೆ?
ಎಲ್ಲ illiterate person.
Illiterate is not the ground counsel. In second appeal ಅಲ್ಲಿ ಏನ್ illiterate ಬರ್ತದೆ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆಗಿದೆ, ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಆಗಿದೆ, ಸೆಕೆಂಡ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟಿಗೆ ಬರುವಾಗ ಏನು illiterate?
ಇಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ?
ರೀಸನ್ಸ್ ಏನ್ ಹೇಳಿದ್ರೆ ಹೇಳಿ, ಅದೊಂದೇ ರೀಸನ್ಸ್?
ಒಂದು ನಿಮಿಷ.
ಎಲ್ಲಿದೆ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್, ಎಲ್ಲಿ ಹೇಳಿದ್ರೆ ಹೇಳಿ. In the month of April, we comes to know that my elder brother's defendant number 1 year brought some of the properties for sale by obtaining decree and confirming the same. When this our respective husbands we contacted them. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಅಪಲೆಂಟ್ಸ್?
ಇಬ್ರು ಸ್ವಾಮಿ.
ರೆವಿನ್ಯೂ ಅಪೀಲ್ ಅಂಡ್ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ರಾಮನಗರ ಇನ್ RA.
ಇಲ್ಲಿ ಮಲಾಡ್ ಇಲ್ಲಿ ಏನ್ ಮಾಡಿದಾರೆ ಸ್ವಾಮಿ, ಸಾವುಕಾರ್ ರಸೂಲ್ ಖಾನ್ಗೆ 3 ಮಕ್ಕಳು ಸ್ವಾಮಿ, 1 ಗಂಡು 2 ಹೆಣ್ಣು. ಅದು
ಬ್ಯಾಡ್ರಿ, ಡಿಲೇ ರೀಸನ್ಸ್ ಹೇಳ್ರಿ ಅಂದ್ರೆ ಬೇರೆ ಎಲ್ಲ ಹೇಳ್ತೀರಿ. ಯಾವಾಗ ನಿಮ್ ನಾಲೆಡ್ಜ್ ಬಂದಿದ್ದು, ಯಾವಾಗ ನಿಮ್ಮ ಅಪೀಲ್ ಡಿಸ್ಮಿಸ್ RA? 2018. ಹೌದಾ? After 6 years you have filed this appeal. October 2018.
ಹೆಣ್ಮಕ್ಳು ಗೊತ್ತಾಗಿಲ್ಲ ಸ್ವಾಮಿ. ಹೆಣ್ಮಕ್ಳು ಗೊತ್ತಾಗಿಲ್ಲ.
ಮಕ್ಳು ಗೊತ್ತಾಗಿಲ್ಲ ಅಂದ್ರೆ ರೀಸನ್ಸ್ ಎಲ್ಲಿ ಹೇಳಿದ್ರಿ? ಸುಮಾರು ಒಂದು ಪುಟಗಟ್ಲೆ ಬರ್ದ್ರಿ. ಎಲ್ಲಿದೆ ನಿಮ್ ಕರೆಕ್ಟ್ ರೀಸನ್ಸ್? ನಿಮ್ ಗಮನಕ್ಕೆ ಬಂದಿದೆ ಯಾವಾಗ? 22 ನಲ್ಲೇ ಬಂದಿದೆ. We state and submit our aforesaid brothers defendant number so and so to notice that suit for partition and separate possession partly decreed by senior civil judge. Our 3 eldest brothers had taken signature 4 wakalas and written statement. It appears without our consent and knowledge. Adengri wakalat signature without consent wakalat tagotara, arraying us as appellants, but it is submitted that the filing of appeal was only eyewash and there was no intention to decide or modify the judgment and decree passed so and so. Illegal will and not settlement deeds and respective children are not entitled to any so and so. We 22 ನಲ್ಲೂ ಮತ್ತೆ ನಿಮಗೆ ಗೊತ್ತಾಯ್ತು. ಆಮೇಲೂ ಏನು ಅಪೀಲ್ ಹಾಕಿದ್ರ? ಯಾಕೆ ಇಲ್ಲಿ ಅಪೀಲ್ ಆಗ್ತಲ್ಲ, ಅಲ್ಲ ಅಪೀಲ್ ಹಾಕಿದ್ರಿ? Our advocates advised us to file a separate suits seeking relief of partition and separate possession of the some of the properties which are not included in the schedule in OS number 14 of 22 and the scheduled properties in OS number 14 of 22. Believing the advice of the advocates, we filed separate suit for declaration, partition and separate possession and injunction. Another suit for OS number 133 of 22 before the Senior Civil Judge in University Chanpatna. Both suits are pending for before the respective courts. We came across advocate at Bangalore and highly advised us to file an appeal. ಏನು reasons ಎಲ್ಲ? Everything is in your knowledge.
ಕೆಲವು ಪ್ರಾಪರ್ಟೀಸ್ ಬಿಟ್ಟಿರ್ತಾರ ಸ್ವಾಮಿ, ಬೇರೆ ಸೂಟ್ ಹಾಕ್ಲಿ ಅಂತ ಯಾರೋ ಹೇಳಿದ್ರು.
ಆಯ್ತ್ರಿ, ಅಪೀಲ್ ಹಾಕೋದ್ ಬಿಟ್ಟು ಇನ್ನೆರಡು ಸೂಟ್ ಯಾಕೆ ಹಾಕ್ತಿರಿ? Third, this matter is listed for admission on A number 1 of 24 and there is a delay of 1227 days in filing the second appeal. The reason assigned in support of the application is that when they came to know about the dismissal of the first appeal in 2022 April, the advocate advised to file a separate suit and accordingly they filed a suit in OS number 228 of 22 and also another suit OS number 133 of 22 and those two suits are pending. But in 2024 when they met advocate at Bangalore advised to file a second appeal and hence this second appeal and there is a delay. And also in support of the affidavit, in paragraph number 3, it is stated that other persons, other brothers had taken signatures on 4 vakals and written statement. It appears without their consent and knowledge they filed the vakalat in RA, arraying them as appellants, and filed an appeal, and the same was also an eyewash, and there was no any intention to set aside or modify the judgment and decree. And having considered these reasons, and also looking into the material on record, first appeal was dismissed with order dated 27th day of October 2018, and present second appeal is filed in 2004 after lapse of 6 years. Having considered the reasons assigned, even though they are having the knowledge about the same in 2022, instead of filing the appeal, it is sworn to that they have filed 2 other suits, and the fact that they are having the knowledge about the order passed by the first appellate court dismissing the same was within their knowledge. And further government that in 2024 an advice was made to file an appeal, and those reasons assigned cannot be accepted, and the reasons are not sufficient reasons, and each day delay has to be explained by the appellants, and when such being the case, I do not find any ground.
My lord, one submission, my lord. All Pardhanashin ladies, my lord.
Condone the delay, and hence no ground is made out to condone the delay of 1327 days, since they themselves have filed the appeal before the first appellate court and not pursued the matter diligently, and only with an intention to condone the delay makes the allegation against other brothers that they have taken the signature without their consent, and without the consent the appellants cannot sign the wakalat to file the appeal and also to file written statement, and the said statement cannot be believed. And hence IA is dismissed. Accordingly, the second appeal is dismissed. Next,
10. Harish H.
Harish HV. Hmm? 878 days delay.
Divergent findings.
Hmm.
ಇದರಲ್ಲಿ last date I tried my level best to secure some documents, my lord, where she is aged lady and husband, my lord, had a sugar and
ಏನ್ರಿ ಇದು?
ಒಂದು that's on 25/5/23
Left leg.
wound ಏನೋ ಆಗಿ ಇದಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಇದೊಂದು ತಮ್ಗೆ ಅವ್ರ ಲೆಟರ್ ಬರ್ದಿದೆ, ಲೈಕ್ ಫರ್ದರ್ ಅಫಿಡವಿಟ್ ದೇ ಹ್ಯಾವ್ ಸೆಡ್, and even medical certificate they have produced. My lord, what has happened is though it's a
ಇದೇನ್ರಿ ಈ ತರ ಲೆಟರ್ ಎಲ್ಲ ತಗೊಬಂದು ಕೋರ್ಟ್ ಹಾಕೋದು?
my lord, I also said, I also told them that it's like a further affidavit, my lord. They have said that
affidavit format ಅಲ್ಲಿ ಹಾಕ್ಬೇಕು, not like writing a letter to the court.
I would remove that, lordships. I am extremely sorry, my lord. I would remove that.
You are an,
But
you are an officer of the court.
I got it. I got
Also,
lordships.
you are placing the said letter
I will
court
take it back, my
along
lord.
with your memo.
I will take it back, my lord.
Whether party can write a letter directly to the court,
My lord, through the
and you are placing the same before the court.
it is explaining the why, my lord, the delay that the husband has got a gangrene, my lord.
ಹಾಗೇನಾರ ಇದ್ರೆ ನೀವು ಬೇಕಾದ್ರೆ ಅಡಿಷನಲ್ ಅಫಿಡವಿಟ್ ಹಾಕಿ.
I will file
ಮತ್ತೆ
the same thing, my lord. I will file affidavit evidence.
ಅದ್ ಮಾಡೋದ್ ಬಿಟ್ಟು ಲಾಸ್ಟ್ ಟೈಮ್ ಮೋಸ್ಟ್
Divergent.
ಕೊಡಿ ಮೇಡಮ್.
Last time that's what your lordships had advised me to, I mean, directed me to produce a record, lordships. These 3 records.
Place on record the medical records of her husband who was suffering from gangrene. ಹೇಳಿ ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಗ್ಯಾಂಗ್ರೀನ್ ಅಂತಂದ್ರೆ ಅದಕ್ಕೆ ಕೊಡಿ ದಾಖಲೆ ಅಂತ ಹೇಳಿ.
ಅದು ಇದು ಫಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂಡ್ ಥರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಏನದು ಫಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಏನಿದೆ? ಒಂದು ಸ್ಲಿಪ್. ಆ
ಸ್ಲಿಪ್ ಅಲ್ಲಿ ಸೂಚರ್ಸ್ wound ಆಗಿ he has
fallen down and 8 times sutures wound ಹಾಕಿದ್ದಾರೆ ಅಂತ ಇದೆ. And secondly, my lord, ಈ medical certificate also based on that they are given.
ಅಲ್ರಿ, ಸಿ ಇಸ್ ದಿ ಪಾರ್ಟಿ ಇನ್ ದಿ ಅಪೀಲ್.
Yes, sir.
ಆಯ್ತು, ಗಂಡನ್ ಗ್ಯಾಂಗ್ರೀನ್ ಆದ್ರೆ ಈಕೆಗೆ ಏನ್ ಬಂದು ಅಫಿಡವಿಟ್
then my lord, my affidavit averments may be seen.
If she is suffering from that ailment, then it could be accepted.
Any member of the family, my lord, it is
Member of the
her
family
bounden
ಆದ್ರೆ
duty. Page 112, my lord, para 3 and 4, my lord. That too, it's a divergent findings.
ಅಪೀಲ್ ಯಾವಾಗ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ? ಏನ್ ಸೂಟ್?
My lord, suit is for partition. Partition is dismissed. And in the appeal, my lord, it is allowed partly. Though, my lord, it is given a finding that it's a joint family properties. However, certain properties are, my lord, as not given a share in the properties. Main properties at Tumkur and other properties.
1/8 share in this A schedule property, item number 4.
Some of the properties they have.
Item number 1 to 16, 18.
And many, though, my lord, once they come to conclusion that, my lord, it's a joint family properties, and it's a only son, and she's a daughter. My lord, then, my lord, entire thing will be inured, and only, my lord, the first appellate, the trial court, my lord, dismisses in its entirety, holding that it's not joint family property. The first appellate court, my lord, holds that it's a joint family property, but, my lord, gives in a share, and a gift given by the father, my lord, has been accepted. When it's a joint family property, my lord, he couldn't have given a gift to the entire extent, not to his share. That is a finding, my lord, which is being challenged.
Judgment ಆಗಿ ಡೇಟ್ ಯಾವ್ದ್ರಿ?
My lord, judgment is on 3/1/2022. My lord, 22 onwards only, my lord, he fell.
ನಿಮ್ಮ ಅಪೀಲ್ 2.25 ವರ್ಷದ ಮೇಲೆ.
878 days delay, my lord.
ಹೌದು.
And 2022 onwards, my lord, he fell ill, he had a gangrene and all that has been stated. Para 2 and para 3 and 4, my lord, I have stated that.
3 ಓದೇ ಹೇಳಿದ್ದು ಲಾಸ್ಟ್ ಟೈಮ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡಿ ಅಂತ. ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡಿ ಅಂತಂದ್ರೆ ಯಾವ್ದೋ ಡಾಕ್ಟರ್ ಹತ್ರ ಯಾವ್ದೋ ಸ್ಲಿಪ್ ಬರ್ಸ್ಕೊ ಬಂದಿದ್ದೀರಿ.
ಅದಾದ್ಮೇಲೆ
ಸಾರಿ ಮೇಡಮ್, ಅದೇನೋ ಸ್ಲಿಪ್ ಬರ್ಕೊ ಬಂದಿರಿ.
ಅಲ್ಲ, one more document ಇದಕ್ಕೆ ಹೋಗಿರೋದು
ಟ್ರೀಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲಿದೆ?
they have
ಟ್ರೀಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಕೊಡ್ಸಿ.
they have taken treatment in the native. Even that day also, my lord, 2023 ಅಲ್ಲಿ ಇದನ್ನ ಪಾಂಪ್ಲೆಟ್ ತಗೊಂಡಿದ್ದಾರೆ. ನಾಟಿ ವೈದ್ಯರು ಏನು ಇದನ್ನ ಕೊಡೋದಿಲ್ಲ. ಆ ಡೇಟನ್ನು ಇದು ನಾನು ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ ನೋಡಿ, 8/6/24. ಡ್ಯೂರಿಂಗ್ ದಟ್ ಟೈಮ್, my lord.
ಅಲ್ಲ ರೀ, ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಕೊಡಿ ಅಂದ್ರೆ ನೀವು ಈ ತರ ಒಂದು ಇದನ್ನ ಹಾಕೋ ಬಂದ್ರೆ
ಫಾರ್ ಟೇಕಿಂಗ್ ನೇಟಿವ್ ಮೆಡಿಸಿನ್, my lord,
ಆಮೇಲೆ ಇದೊಂದು ಸ್ಲಿಪ್ ಬರ್ಸ್ಕೊ ಬಂದು ತಂದು ಕೋರ್ಟ್ಗೆ ಹಾಕಿದ್ರೆ ಟ್ರೀಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ಸ್ ಎಲ್ಲಿದೆ ರೀ?
My lord, one more record which I have produced, page number
ಯಾವುದು ಇಲ್ಲ ಇಲ್ಲಿ.
ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಂತ ಇದೆ ಅದರಲ್ಲಿ. ಅದಾದ್ಮೇಲೆ ಗ್ಯಾಂಗ್ರೀನ್ ಆಗಿ that they went in and they have taken treatment, my lord. Otherwise, throughout, my lord, they have contested.
ಅದು ಏನು ಸೆಲ್ಫ್ ಫಾಲ್
suturing ಆಗಿ that he is a diabetic.
ಮೆಡಿಕಲ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನೋ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದು ಇನ್ ಬಿಟ್ವೀನ್ ದಿ ಪೀರಿಯಡ್ ಫ್ರಮ್ 25/5/23 to 10/6/23.
My lord, 23.
Self fall and wound with swelling, suturing. ಅಷ್ಟು ಬಿಟ್ರೆ ಏನೇನೇ ಇಲ್ಲ.
My lord,
8 stitches.
That went in for gangrene and he took a native medicine is the thing, my lord. On merits, my lord, we have a very good case.
ಆಯ್ತ್ರಿ, ಅವ್ರು ಬಿದ್ದಿರೋದು 23 ನಲ್ಲಿ,
my lord,
ಕೇಸ್ ಆಗಿರೋದು 22 ಜನವರಿಯಲ್ಲಿ.
1.5 year, my lord, or 2 years.
This certificate is also after 1.5 year. ನೀವೇನು ಈ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಿ?
My lord, that slip, my lord, they have not taken the slip. The slip is taken long back. 25/5/23 only they have taken the slip, my lord.
ಹೌದ್ರಿ, ಅದು ಅಷ್ಟೇ. ಅವ್ನು ಬಿದ್ದಿರೋದೇ 23ರಲ್ಲಿ. ನಿಮ್ ಕೇಸ್ ಡಿಸ್ಪೋಸಲ್ ಆಗಿರೋದು ಯಾವಾಗ? 3/1/22ರಲ್ಲಿ. 1.5 ವರ್ಷದ ಮೇಲಿನ ದಾಖಲೆ ನೀವು ತಂದು ಕೊಟ್ಟಿರೋದು.
Even prior to it, she says that, my lord,
ನೀವು 2 ಸ್ಲಿಪ್ ಹಾಕಿರೋದು ಅದೇನೆ. 23.
Further affidavit, my lord, whatever she has said, I can.
ಹಾಕಿದ್ರು ಏನು ಉಪಯೋಗ ಬರಲ್ಲ. ತೊಗೊಳ್ಳಿ.
But on
This
merits-
court heard the matter in the previous date on 4/11/25 and having considered the averments made in the affidavit in para 3, wherein it is sworn to that her husband developed gangrene and took 1 year, 1.5 year to 2 years for its cure. And also she was suffering from joint pain due to dengue fever and hence could not file the affidavit. And this court directed to place on record the medical records of the husband who was suffering from gangrene.
But I'll remove that.
The council
affidavit.
produced memo along with 2 documents. One document dated 25/5/23 issued by the administrative medical officer PSC Gondihalli Madugiri Taluk, which also discloses that he had suffered cut lacerated wound over left leg, first finger. No other significant injury and patient is stable. And this document is also after 1.5 year of the judgment passed by the first appellate court. And another certificate is dated 14/11/25, wherein also medical certificate shows that he took treatment on 25/5/2023 to 10/6/23 and advised to take him rest. And this document also corollary to the first document that discloses a cell fall and wound with suturing was done. And having taken note of these 2 documents will not come to the aid of appellant in support of the averments made in the affidavit in paragraph number 3. The judgment was passed on 3/1/2022 and this appeal was filed on 24/10/2024. And
Hope
having
you-
considered the material on record, the first appellate court allowed the appeal and granted the relief in respect of plaintiff and defendant, granting 1/8 share in the A schedule item number 4 and suit B schedule item number 1 to 16, 18 and land measuring 1 acre 18 guntas in suit item number 19 by way of partition and separate possession. And it is not the case of the appellant that the appellant is not having the knowledge about the order passed by the first appellate court and having the knowledge also, and also the reasons assigned in the affidavit with regard to the husband was suffering from gangrene and already clarified that it was a case of self-fall and sustaining injury, that too after 1.5 year of passing of an order by the first appellate court, and no explanation from the date of passing of an order till the husband sustained injury after 1.5 year. And hence I do not find any ground to condone the delay of 878 days. And it is settled law that each day delay has to be explained properly and without any sufficient cause. Question of condoning the delay of 878 days doesn't arise, and hence no ground is made out to condone the delay, and hence IA is rejected. Consequently, second appeal is dismissed.
I shall remove that, sorry.
ಅದಿನ್ನೇನು ಉಪಯೋಗ ಬರಲ್ಲ.
I'll take
ರಿಮೂವ್
it
ಮಾಡಿದ್ರು
out.
ಒಂದೇ ಇಟ್ಕೊಂಡ್ರು ಒಂದೇ. ಆಯ್ತು.
11.
Next.
Ramesh Kher.
2, 3, 5, 6 days.
But a grave injustice has been caused in this, my lord, your lordship may kindly peruse page para 29, my lord, of the judgment. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ,
Judgment ಬಿಟ್ಬಿಡಿ, ನಿಮ್ delay ಹೇಳಿ first.
delay
Apex court says don't see the merits, first you see the delay reasons. ಶಿವಮೊಗ್ಗ ಕೇಸ್ ಓದಿದಿರಿ ಅಂತ ಕಾಣುತ್ತೆ.
para 4 and 5, para 4 and 5.
ಹೇಳಿ delay ಹೇಳಿ. para 140, 141, 142 ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ ಮೆರಿಟ್ ನೋಡಕ್ಕೆ ಹೋಗಬೇಡಿ ಅಂತ.
ಇದರಲ್ಲಿ ಈ ಕೇಸಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ ಅಂದ್ರೆ ಸೆಕ್ಷನ್ 6 ಅನ್ನ ಮಿಸ್ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿ ಬರ್ದಿದ್ದಾರೆ.
Condonation of delay.
para 4 and 5. I have
2356 ದಿವಸ ಡಿಲೇ. ಏನ್ ರೀಸನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಿ?
ನೋಡಿ ಇದೆಲ್ಲ ಇದು ಸಿಸ್ಟರ್ಸ್ ಫೈಲ್ ಸೂಟ್ ಫೈಲ್ಡ್ ಬೈ ದಿ ಸಿಸ್ಟರ್ಸ್. ಊರಲ್ಲಿ ಏನೋ ಎಲ್ಡರ್ಸ್ ಸೆಟಲ್ ಮಾಡ್ತೀವಿ ಅಂತ ಸ್ವಲ್ಪ ಹಂಗೆ ಪ್ರೊಲಾಂಗ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ಒಂದು ಏಜ್ ಫ್ಯಾಕ್ಟರ್, ಇನ್ನೊಂದು ಎಲ್ರು ಏಜ್ಡ್ ಲೇಡೀಸ್ ಅಂಡ್
ಕೋರ್ಟಿಗೆ ಬರಕ್ಕಿಂತ ಮುಂಚೆ ಸೆಟ್ಲ್ಮೆಂಟ್, ಕೋರ್ಟಿಗೆ ಬಂದು ಎರಡು ಕಡೆ ಆದ್ಮೇಲೆ ಮತ್ತೇನ್ ಸೆಟ್ಲ್ಮೆಂಟ್?
ಇಲ್ಲ, ಎರಡು ಕಡೆ ಡೈವರ್ಜೆಂಟ್ ಫೈಲ್.
ಅದೇನೆ ಎರಡು ಕಡೆ ಆದ್ಮೇಲೆ ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ ಮಾಡೋಂಥದ್ದು ಏನಿರ್ತದೆ ಅಂತ ನೀವು ರೀಸನ್ ಕೊಟ್ರದ ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದೀನಿ ನಾನು.
ಪ್ಲೀಸ್ ಅಲ್ಲ, ಇದು ಸಿಸ್ಟರ್ಸ್ ಫೈಲ್ ಮಾಡಿದ್ದು ಸೂಟು para 29 may kindly be perused. Para 29 page 37.
ರೀಸನ್ ಡಿಲೇಗೆ ಹೇಳ್ರಿ ಅಂದ್ರೆ ನೀವು ಬೇರೆ ಏನೋ ಹೇಳ್ತಿರಲ್ರಿ?
ನಾನು ವಾಟ್ ಐ ವುಡ್ ಲೈಕ್ ಟು ಸಬ್ಮಿಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಅನ್ನೋದು ಗ್ರೇಟ್ ಇಂಜಸ್ಟಿಸ್ ಇಸ್
2356 ದಿವಸ ಡಿಲೇಗೆ ಹೇಳಿ ಅಂದ್ರೆ
ಅದೇ ಸೆಟ್ಲ್ ಆಗುತ್ತೆ ಅಂತ, ಸೆಟ್ಲ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ಎಲ್ಡರ್ಸ್ ಪ್ರೊಲಾಂಗ್ ಮಾಡಿದ್ರು ಸ್ವಾಮಿ. ಹಾಗಾಗಿ
ಏನ್ ಡೈವರ್ಜೆಂಟ್ ಏನಿಲ್ಲ, ಮಾಡಿಫೈ ಮಾಡಿದಾರೆ ಅಷ್ಟೇನೆ. 1/4 ಶೇರ್
ಅಲ್ಲಲ್ಲ, ಬರೀ
ಸಪರೇಟ್ ಪೊಸಿಷನ್ ಓವರ್ ದಿ ಸೂಟ್ ಶೆಡ್ಯೂಲ್
ಇಲ್ಲ, ಬರೀ ಗಂಡು ಮಕ್ಳಿಗೆ ಅಷ್ಟೇ ಶೇರ್ ಕೊಟ್ಟಿದ್ದಾರೆ. Para 20, that's why my lord, your lordship may kindly peruse page 20, para 29 my lord, page 37. ಅದರಲ್ಲಿ
37
page para 29 my lord. ಇಲ್ಲಿ ಜಡ್ಮೆಂಟ್ ಇದು ಆಕ್ಚುಲಿ ವಿನಿತಾ ಶರ್ಮಾ ಜಡ್ಮೆಂಟ್ ಪ್ರಕಾರ ಇದು ತಪ್ಪು ಸ್ವಾಮಿ. your lordship, and since the ruling so and so.
ನೀವು ವಿನಿತಾ ಶೆಟ್ಟಿ ಜಡ್ಮೆಂಟ್ ಬಂದ್ಮೇಲೆ ಅಪೀಲ್ ಹಾಕೋ ಬಂದಿದ್ದೀರಿ, ಅಲ್ಲಿವರೆಗೂ ಸುಮ್ಮನೆ ಇದ್ರಿ. ಇಲ್ಲಿ ಜಡ್ಮೆಂಟ್ ಆಗಿರೋದು ಯಾವಾಗ್ರಿ? ಇದು 2016 ಅಲ್ಲಿ.
16
ಮತ್ತೆ ಯು ಕೆಪ್ಟ್ ಕ್ವೈಟ್ ಇಲ್ಲ
ಅಲ್ಲ, ಈವನ್ ಪ್ರಯರ್ ಆದ್ರೂನು
ಫೈಲ್ 9 ವರ್ಷದ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕಿದೆ.
ಅಲ್ಲ, ಇಲ್ಲಿ ಫಾದರ್ ಅಲೈವ್ ಆಗಿರ್ಬೇಕು ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ ಸ್ವಾಮಿ. ಹಾಗಾಗಿ
ವಾಟ್ ಎವರ್ ಇಟ್ ಮೇ ಬಿ ಡಿಲೇಗೆ ಹೇಳ್ರಿ ಅಂತಂದ್ರೆ ನೀವು ಮೆರಿಟ್ಸ್ ಹೇಳ್ತಾ ಇದ್ದೀರಿ.
totally share is denied my lord.
What is the appellant counsel?
Even though I'll file
on IA number 1 of 24, and there is a delay of 2356 days in filing the present second appeal. The impugned judgment and decree was passed on 12th day of April 2016.
My lord, I'll file better.
And appeal is filed in 2025, almost after 9 years. And in support of the application, reason assigned also in para
4 and 5.
For that they are the rustic villagers and illiterates, and they have approached the elders in the village requesting to advise the respondents oblique defendants to give their share, and they have taken some time, stating that they will consider their request to give their share. And in spite of the said assurance was given, they did not come forward to give the share, and they are very ignorant about the law of limitation prescribed for filing the appeal, and they have not approached the lawyer to file an appeal in anticipation of the settlement among themselves. And there was no any coordination among them. And on the guise of settlement, they did not approach the advocate, and admittedly trial court decreed the suit and the same is reversed in the appeal. And delay in filing the appeal is not intentional or deliberate. Having considered the judgment was passed in the month of April 2016 and present second appeal is filed on 9/12/2025. After 9 years, present appeal is filed. And reason assigned is also that they have approached the elders of the village and they assured that they are going to settle the issues. And the fact that when they filed the suit before the trial courts claiming the partition and the same was granted, and subsequently and the same is modified, the very theory of promise to settle the issue after the two court proceedings is cannot be believed. And apart from that, except stating that they have approached the elders in the village, not stated any other reasons, and not the case of the appellant that they are not having any knowledge about the judgment passed in 2016. Only reason assigned is that they have approached the elders and assured that they are going to settle the matter, and having considered the inordinate delay in filing the second appeal, I do not find any ground to condone the delay. The apex court in the judgment reported in 2025 in Shivamma case categorically held that a lethargic persons cannot be encouraged by condoning the delay. And apart from that, specifically mentioned in paragraph number, specifically held in paragraph number 140, 141, 142, that merits of the case cannot be decided unless satisfied with the reasons mentioned in the delay application, and in the absence of any sufficient cause for condoning the delay, and each delay is explained by the appellant, question of considering the matter and merits doesn't arise, and hence I do not find any ground to condone the delay of
Share in immovable property has been-
2,356 days in filing the appeal, and hence the application is dismissed. Consequently, appeal is also dismissed.
Admission matter 12.
ಇಲ್ಲಿ ಪಾಸ್ ಆಗೋದಿಲ್ಲ ಆಫೀಸ್ ಬರ್ತಾರೆ ಆಸ್ ಐ ಸೆಡ್ ಇನ್ ಲಾಸ್ಟ್ ಅಪಿಯರ್
Pass over.
ಕಾಂಪ್ರಮೈಸ್
30. N.R. Raghavendra.
Complaint, my lord. Divergent finding, my lord.
Dismissed to reverse to observe
Reverse,
to
yes, my
owner,
lord. Shoot filed by the respondent is
deliver the possession.
dismissed and also seeking for declaration and position in respect of shoot property.
Records ಬಂದಿದಲ್ಲ?
Admittedly,
ಹೇಳಿ ಏನು?
admittedly, the shoot properties belongs to the husband of the plaintiff, appellant here, my lord. He has purchased in the year 1989. Sale deed, two registered sale deed, my lord. The appellate court, the trial court, after upset the written statement and also pleadings, rightly held that the plaintiff is not pro the case and also not in possession of the shoot property, dismiss the shoot. But the appellate court reversed the judgment regarding only on ground that the original document, that is sale deed in the year 89, in the custody of plaintiff, and also that they have executed GPA and also affidavit, unregistered GPA, unregistered affidavit, my lord. That is the tricks, my lord. Read the operative.
ಅದ್ರ ಬೇಸಿಸ್ ಮೇಲೆ ಸೇಲ್ ಡೀಡ್ ಇದೆಯಾ?
Sale deed, subsequently, prior to that, the appellant husband sold the property in favor of appellant here, my lord. Prior to, subsequently, they have filed shoot against me. Prior to that, ಅದಕ್ಕೆ ಮೊದಲೇ ನಮಗೆ ಆಗಿದೆ, ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆ, as per exhibit D22, my lord.
ಆಗಿದೆ ರೀ, ನಿಮ್ಮವ್ರು ಮತ್ತೆ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ಮೇಲೆ ಅಫಿಡವಿಟ್ ಎಲ್ಲ ಮಾಡ್ಕೊಟ್ಮೇಲೆ
that is not purely fixed the stamp.
ಅದ್ರ ಮೇಲೆ ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆಯಾ ಅಂದೆ? ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಹೋಲ್ಡರ್, ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ಹೋಲ್ಡರ್ ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ಟಿದಾನ?
ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ ನಮ್ಗೆ ನಮ್ ಗಿಫ್ಟ್ ಡೀಡ್ ಮಾಡಿದ್ರು ನಮ್ಮ ಹಸ್ಬೆಂಡ್, ಆಮೇಲೆ ಅವ್ರು ಮಾಡಿರೋದು.
ಅವ್ರಿಗೆ ಮಾಡಿದ್ರೇನ್ರಿ?
ಅವ್ರು ಮಾಡಿದ್ದಾರೆ. That is the
P1 and P2 are the sale deeds of
exhibit P1, P2 sale deed.
ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ಟವ್ರು ಯಾರು? ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ
ಹಸ್ಬೆಂಡ್.
Power of attorney ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ.
Power of attorney
one site is executed by power of attorney, the another site is executed by a purchaser, namely
my lord, Parvatama, that is husband Virendra Kumar. GPA executed in one sale deed NT ಹೆಸರಿಗೆ ಮಾಡ್ದ, ಇನ್ನೊಂದು ಸೇಲ್ ಡೀಡ್ ಮುನಿಯಪ್ಪ ಮಾಡ್ಬಿಟ್ಟು ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗ್ಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಗೈನ್ ಮುನಿಯಪ್ಪ ಅವ್ರ ಕಡೆಯಿಂದ ಇವ್ರು ಇದಾಗಿದೆ. ಎರಡನೇ ಸೇಲ್ ಡೀಡ್, ಟೂ ಸೇಲ್ ಡೀಡ್.
Heard the appellant counsel and also the counsel appearing for the respondent. And at the first instance, trial court dismissed the suit. And in the appellate court reversed the same and held that plaintiffs are the absolute owner and also directed to deliver the possession. And in view of divergent petition, finding, matter requires reconsideration. Admit the following substantive question of law arises for the consideration of this court.
Actually, in fact,
ಮಾಡಿದ್ದೀರಾ ಸ್ವಾಮಿ?
admit ಆಗಿತ್ತು,
Last
but
hearing
that is
ಅಲ್ಲಿ
not not in the.
Question of law ತಾವೇ ಫ್ರೇಮ್
ಅಲ್ಲ,
ಮಾಡಿದ್ದೀರಾ?
ತಮ್ಮ ಮುಂದೆ ಅಲ್ಲ, ಅರ್ಲಿಯರ್ ಪ್ರೊಸೀಡಿಂಗ್ ಆಫೀಸರ್ ಬಂತು, ಬಟ್ ಅದನ್ನ
Substantive question of
ಮಾಡ್ಬೇಕು. By mistake
ಇವತ್ತು ಅಡ್ಮಿಷನ್ ಬಂದಿದೆ.
ಅಡ್ಮಿಷನ್ ಅರ್ಲಿಯರ್ ಆಗಿಲ್ಲ, ಬಟ್ ನೋಟ್ ಆಗಿಲ್ಲ. ಬಿಫೋರ್ ನಿಮ್ ತಮ್ಮ ಮುಂದೆ ಅಲ್ಲ, 16/4 ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲೇ ನೋಟ್ ಆಗಿಲ್ಲ.
ಎಲ್ಲಿದೆ ನಿಮ್ದು ಅಡ್ಮಿಟ್ ಆಗಿರೋದು?
ಅಲ್ಲಲ್ಲ, ಇನ್ಫ್ಯಾಕ್ಟ್ ನಾವು ಇಬ್ಬರೇ ಇದ್ವಿ, ಡಿಕ್ಟೇಷನ್ ತಗೊಂಡ್ರು, ಅದು ನೋಟ್ ಆಗಿಲ್ಲ, ಬೈ ಓವರ್ ಸೈಟ್ ಆಗಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಅಗೈನ್ ಅಡ್ಮಿಷನ್ ಅಂತ ಬರ್ತಾ ಇದೆ.
ತಗೊಂಡ್ರು ನೋಟ್ ಆಗ
16/4/2024 ಮೇಲಾಡ್, ಆಮೇಲೆ ಈಗ 2 ಸಲ ಬಂತು, 6/6/25 ಅಲ್ಲಿ ಬಂತು. ಆ ಟೈಮಲ್ಲಿ ಅಡ್ಮಿಟ್ ಆಗಿ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಕ್ವಶನ್ ಆಯ್ತು, ಬಟ್ ಅರ್ಲಿಯರ್ ಪ್ರೊಸೀಡಿಂಗ್ ಸಾರಿ ಡಿಕ್ಟೇಷನ್ ಆಗಿಲ್ಲ. ತಿರುಗಿ ಅಗೇನ್ ಅವತ್ತೇ ನಾನು ಸಬ್ಮಿಷನ್ ಮಾಡಿದೆ, ಬಟ್ ಅದು
ಸಬ್ಸ್ಟಾಂಟಿವ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ನಿಮ್ ಪ್ರಕಾರ
ದೇರ್ ಇಸ್ ನೋ ಇನ್ ದ ಆರ್ಡರ್ ಶೀಟ್. 16/4/2025
ಅಲ್ಲ
ಆರ್ 6/6/25 ಎರಡು ಡೇಟ್ ಅಲ್ಲೂ ಬಂದಿತ್ತು ಸರ್. ಅವರು ಇದ್ರು, ಆಮೇಲೆ ಅವ್ರು ಲೇಟ್ ಆಗಿದ್ರು, ಆಮೇಲೆ ಆಲ್ರೆಡಿ ಇಶ್ಯೂ ಅಡ್ಮಿಟ್ ಆಗಿ ಎಲ್ಲ ಆಗಿತ್ತು, ಬಟ್ ವೈನೇ ಅವು ಸರ್ ಮೇಲಾಡ ಅಗೇನ್. ಬಟ್ ದಟ್ ಆರ್ಡರ್ ಶೀಟ್
16/4/25
ಮೇಡಮ್, 16/4/25 ಒಂದು, ಮತ್ತೆ 6/6/25 ಎರಡು ಡೇಟ್ ಅಲ್ಲಿ.
16/4/25 ಯಾವ್ದು ಡೇಟ್ ಇಲ್ಲ.
6/6/25 ಮಾಡೋದು ಸರಿ.
15/4/25 ಇದೆ, 6/6/25 ಇದೆ.
ಅದು ಆ ಡೇಟ್ ಅಲ್ಲಿ
6/6/25 ನಾನೇ ರೀ ಮಾಡಿರೋದು.
ತಮ್ಮಂದೆ ಅಲ್ಲ ಹಂಗಾದ್ರೆ ಸರಿ ಸರಿ
ರಿಸೀವ್ಡ್ ಅಂತ ಆರ್ಡರ್ ಇದೆ.
ಹೌದು, ಅದಕ್ಕೆ ಪ್ರೀವಿಯಸ್
ಆದ್ಮೇಲೆ ಬಂದೇ ಇಲ್ಲ ಮ್ಯಾಟರ್.
ಅದು ಪ್ರೀವಿಯಸ್ ಡೇಟ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ, ತಮ್ಮಂದೆ ಅಲ್ಲ, ಬೇರೆ ಇವ್ರು ಬೈ ಮಿಸ್ಟೇಕ್ ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ನೋಟ್ ಆಗಿಲ್ಲ, ಅದು ಅಡ್ಮಿಷನ್ ಇದು ಬಂದಿಲ್ಲ.
ಆಫ್ಟರ್ ಸಮ್ಮರ್ ವೆಕೇಶನ್ ಅಂತ 15/4/25
ಅದು ನೋಟ್, ಅದು ಬೇರೆ ಕೇಸ್ ಆಕ್ಚುಲಿ ಅದೇನಾಯ್ತು ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ, ಇಬ್ರು ಇದ್ವಿ, ಅಡ್ಮಿಟ್ ಆಯ್ತು. ಆಯ್ತು ಸರ್,
ಅಡ್ಮಿಟ್ ಅವ್ರು ಹೇಳಿದ್ದಕ್ಕೆ. The following substantive question of law arises for the consideration of this court. Whether the first appellate court committed an error in reversing the finding of trial court in declaring the plaintiff as absolute owner and directing to deliver the possession of the plain scheduled property to the plaintiff based on the documents of power of attorney, affidavit and sale agreement as valid which are
and by virtue of P1
marked as exhibits P series and also by virtue of exhibit
two shell deeds
P1 and P2 na
P1 and P2
P1 and P2 records are already received and no need to file paper book. List the matter for final hearing on date kodi madam
8/12.
8/12 14
We are Raghunathan, 14%.
My lord, I am the appellant, I am party in person. This is a matter of domestic inquiry where the principles of natural justice thing has not been followed. They are not given the proposed punishment and appeal is not given. On that I appeal. That's all the case, nothing else. And I voluntarily gave appeal. Even after 13 years, they are not disposed it.
Suit of the plaintiff is hereby dismissed.
Both the trial court and the first appellate court, they dealt only on the inquiry proceedings, whereas I have been talking beyond the inquiry, the next stage. Inquiry, the domestic inquiry contains two portions. Getting inquiry officer report, first portion. Second portion, after that, the implementation portion. I am talking on the second portion.
You have participated in the inquiry proceedings also.
Yes, my lord.
And even you have admitted your lapses.
No, lapses is not admitted.
Para 24 nodi.
No, the annexure C.
Copy of the same was given to the plaintiff for his explanation. The plaintiff by representation dated 11/8/2011 accepted the lapse of his part in availing the medical facilities. The plaintiff also requested the pardon him and closed the issue as a special case. Based on the evidence and documents on record, the inquiry committee has given its report. The inquiry report is not amenable to the judicial intervention on this court while exercising civil jurisdiction cannot intervene in the administrative and disciplinary action of the defendant, as it is the prerogative right of the defendant number one to take action against the erring employee for proven acts of misconduct. That is the paragraph number 24.
Yes, Your Honor. After
And
the
you have
matter
also
is,
filed an appeal. Appeal is also pending.
yes, I have filed appeal. It was 3 times I given appeal. 3rd February, 9th February. Then after retirement on March 23, I gave. March 13. For that, I got a reply telling that you give the reply, the appeal. I gave the appeal. Even after 13 years, it was not disposed. They said, as and when the disciplinary appellate authority clears, we will inform you. That is continuing like this only. My problem is running from 2009. When I went on official duty to Chikmagalur, Tarikere to conduct the inquiry.
All has been considered in the inquiry report.
Yes, sir. And this is
Also, you have filed an appeal.
after talking to the management, they said, you admit the case. I said, no, sir, I will not admit. I will give apology letter. Accordingly, only I gave the apology letter. Annexed D1 and D1A. There, the dismissal authority accepted my contention and he said, yes, close the issue by warning letter, which they did not implement. And again, the DA is giving order and they went to other authorities.
Admitted the lapses and also prayed the authority to pardon you.
Yes, yes. I asked apology. They said, give apology. Admit the case. I said, no, I will not admit.
Right to accept it or not? But they have not accepted your
No, they accepted.
apology.
The DA has accepted. Then he has given his intention, telling that I propose to issue a warning letter and close the matter because of the merits what I submitted to him. He is aware what the case is. On that DA's order, other authorities are not entering. Vigilance and HR, they are not accepting. They went to the chairman. Chairman said issue. He is not the person to interfere in the matter. DA is giving the order after considered order after hearing. This is not implemented. DA's order can be challenged in appeal, provided they give an appeal provision. They are not given the appeal provision. Voluntary appeal given, that also not considered.
You have filed an appeal. Appeal is pending consideration. That is the.
But 13 years is pending, Your Honor.
Observation by the trial court. That is
At this stage, it was there. Even today, it is not disposed of.
Can madam ಕೇಳಿ civil suit hang, how can you file such civil appeal? You are seeking the relief to declare the same as null and void. Inquiry report is null and void.
Yes, sir, my lord.
As well as mandatory relief is there.
And
One is
also
as
the
the mandatory.
mandatory relief.
Civil court has no jurisdiction to sit on the inquiry as appellate authority because it is a jurisdiction of my management, which I also don't question. Yes, you have a right to issue charge sheet, conduct, hang me upside down inside the premises. But follow the procedure. Fundamental rights is, it's a settled question of law. A.R. Antale versus R.S. Naik and another. No prejudice need to be proved for enforcement of fundamental right. That itself is a violation. So also the principle of natural justice. It makes act nullity. And with all that plus our own rule says, we'll have to give second show cause notice, propose
You
punishment.
have participated in the proceedings,
Yes, Your Honor.
in the inquiry proceedings.
Yes, Your Honor.
And also you have given an explanation.
Yes, my lord.
Wherein you have admitted that.
It is not during the inquiry. After the inquiry, given instead of apology, admitting the thing, I gave it as apology letter.
That's what. Now how can you contend that no procedure was followed and the principles of clear violation of principles of natural justice?
There's a
Once you
late.
participated and also you have given an explanation.
Yes, my lord. The rule says, after the inquiry, we will have to propose a punishment as a second show cause. Aduk madilla.
You are the same in the appeal, that's all. You are the same in the appeal, that's all.
Yes, I appeal, but it's not, the appeal is not disposed even after 13 years.
ಅದಕ್ಕೇನ್ ಮಾಡೋಣ ಇಲ್ಲೇನ್ ಮಾಡ್ಬೇಕು?
That's why I come to honorable
Civil
court
suit ಅಲ್ಲಿ.
before your lordship.
Opportunity is given, no principles, violation of principles of natural justice.
ನನ್ಗೆ ಕೊಡ ಏನು ಕೊಟ್ಟಿಲ್ವಲ್ಲ, they not heard me, they not given anything.
ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು ನೀವು, ಇಲ್ಲಿ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. Principles of natural justice is followed and given an opportunity to you in participate in the inquiry and thereafter also you have given representation admitting your lapses,
Exhibit
and
D1.
also requesting them to pardon you. And now how can you plead that no principles of natural justice?
The enquiry portion ends with enquiry, only one last submission, Your Honor. Enquiry has a two portion. Getting enquiry report is the first portion ends. Second portion is administrative thing, where you let give second show cause notice. This is a proposed punishment. You can appeal against that to so and so. That portion is gone. That if that is gone,
That is
I
also-
can't go to labor court or a tribunal.
It is
For
also
me,
met by the appellate court in paragraph number 27, the ground which you have urged. Told. This matter is listed for admission. I heard the counsel, I heard the party in person, and also the counsel appearing for the respondent. This second appeal is filed against the concurrent finding. The factual matrix of case of the plaintiff before the trial court while seeking the relief of declaration to declare that punishment order dated 29/9/2011 issued by disciplinary authority as null and void, and also sought for mandatory injunction to provide the consequential relief. It is the specific pleading before the trial court that plaintiff was engaged as a permanent employee of Messrs. BML Company from 30/9/1974 to 30/11/2012 in various capacities, and finally superannuated as senior manager within bracket HR from the Mysore complex of the company with effect from 30/11/2012. Prior to his retirement from the Mysore complex, the plaintiff was transferred from the marketing division of the company at its KFG production unit during March 2003, and ever since then the plaintiff is staying at Mysore along with his wife, who is a paralytic attacked patient. By virtue of experience and qualification, the plaintiff was functioning as one of the most successful officer in HRD, was assigned to be the inquiry officer of domestic inquiries in the various units of the company. When plaintiff assigned to conduct two domestic inquiries at Messrs.
Vignan, VIGNYAN.
Vignan Industries Limited, Tharikere, Chikamagaluru district. A system concerns of Messrs. BML Limited, bracket close. During 16th to 18th July 2009, and subsequently based on the summons received from the court, he was again deputed to adduce evidence before the Labour Court Chikmagaluru. While on the official assignment at Chikmagaluru, the plaintiff was infected with chikungunya and was suffering from
on and off.
Then on and off July 2009 and 14 August 2009 and on 15/8/2009. The complaints of server joint pains and fever got aggravated, and finally when he became unbearable, he visited the Aditya Adhikari Hospital, Mysore, where he was admitted as an inpatient around 4 p.m. for further medical management. In view of lack of food and bathing facilities at the hospital during the night, the plaintiff, with the permission of the doctor of the hospital, used to meet these two requirements by visiting his house at Vijayanagar, Mysore. And after reasonable control of the infection, the plaintiff got himself discharged from the hospital on 17/8/2009. One of the vested interest in the organization, the vigilance officer, who had to encounter receipt of advisory letter from the plaintiff, masterminded fabrication of the hospitalization of the plaintiff and got a memorandum issued to the plaintiff on his imaginary grounds, which, in spite of vehement challenges by the plaintiff, was ultimately ensured that the plaintiff is awarded the punishment at the fag end of his career. It is contended that as part of his dedicated efforts with an aim to get maximum efforts from all his subordinates, the plaintiff did report about the poor performance per se of one of his subordinates and disciplinary action against her husband who was reported upon by security department for involving in clandestinely taking out company material, were all not to the taste of their kith and kin, who occupied post of importance at corporate level, by virtue of promotion, and did not get the due consideration he deserved from the authorities concerned. It is also the contention that plaintiff did participation fully in the inquiry conducted against him and cooperated to the full without seeking permission of any adjournment. It is contended that at the time of receipt of the memorandum itself, it was noted that conducting of an inquiry against the plaintiff was noted as a foregone decision, even without waiting for receipt of the reply of the memorandum, which in fact was factually and convincingly replied. The disciplinary authority simply conveyed the decision of other vested interests at his order, without complying with the laid down requirements of issue of second show cause notice and extending the appeal provision. In the instant case, it is desired to submit that the vigilance officer, who played the role of complainant, the only prosecution witness, has also played a role in deciding the punishment to be awarded and decision making in the case. Since the inquiry held against the plaintiff was dealt as an inquiry from vigilance, it is also contended that in his defense, he has produced the oral evidence of the director of the hospital, the chief of BML HRD of Mysore complex, and the assistant manager within bracket security, BML, Mysore. Besides producing 35 documents evidences his defense, whereas, the defendants relied on one uncorroborated evidence of the investigating officer only. Due to the efforts of the plaintiff with higher ups, he was advised to submit a letter for pardoning him, and accordingly a letter dated 11/8/21 was submitted, which was also not acted upon for unknown reasons. Further, due to the repeated humiliations, encountered in the day-to-day base working in the same place, the plaintiff was constrained to take an extreme step of opting to go out of the organization by using premature retirement option, and accordingly submitted an application dated 7/11/2011, which was also turned down, quoting reasons from vigilance angle, hence the application was filed. The defendant appeared through his counsel and filed written statement. And defendant number 2 and 3 were placed ex parte. The first defendant denied all objections, all averments made in the suit, and contend that suit to be rejected as its threshold. Reliefs claimed by the plaintiff are pertaining to the service conditions, and the plaintiff has raised certain ineligible and untenable claims after retirement from service. It is contended that civil court is precluded from enforcing claims pertaining to the service conditions of the employment. Hence, it is contended that suit is liable to be dismissed. It is also contended that when the inquiry was initiated against him, he participated in the said inquiry and availed opportunity to defend the charges. The inquiry committee submitted its report on 6/5/2011 and found that the plaintiff is guilty of the charges leveled against him. And copy of the report was given to him and sought for explanation. The plaintiff, with a representation dated 11/8/2011, accepted the lapse of his part in availing the medical facilities. Also requested to pardon him and close the case as a special case, and contend that the inquiry report is not amenable to the judicial intervention, and this court, while exercising civil jurisdiction, cannot intervene in the administrative and disciplinary action of the defendant number 1. And the same is a prerogative right of the defendant number 1 to take action against him. It is contended that matter was of a vigilance case, the CVO recommended punishment of either censure or withholding increment of pay with or without cumulative effect in accordance with the provisions of CDA rules of the company. The management approved the punishment of withholding one increment with cumulative effect with order dated 29/9/2011. The plaintiff has undergone the punishment imposed. The first defendant submits that after a lapse of 4 months from the date of issuance of punishment order, the plaintiff submitted a plea requesting to rescind with the punishment imposed and reimburse rupees 5,031 towards medical treatment at Aditya Adhikari Hospital. The action of the defendants against the plaintiff is well within the service law applicable to the plaintiff, and hence suit is not maintainable. The trial court, having considered the grounds which have been urged in the defense as well as in the plaintiff governments, framed the issues and allowed the parties to lead evidence, and plaintiff himself examined as PW1 and got marked document exhibit B1 to 22. On the other hand, HR of the defendant company examined himself as DW1 and got marked document exhibit D1 to 14. The trial court, having considered both oral and documentary evidence, that is pleadings as well as defense as well as oral and documentary evidence, taken note of that plaintiff participated in the said inquiry and availed the opportunity to defend the charges, and an inquiry report is also submitted. And also, when the plaintiff realizes his mistake, has given the representation dated 11/8/21 and accepted the lapse of his part in availing the medical facilities and also requested to pardon him. And hence, trial court also taken note that the inquiry report is not amenable to judicial intervention. And this court, while exercising civil jurisdiction, cannot intervene in the administrative and disciplinary action of the defendant number 1, as it is the prerogative right of the defendant number 1 to take action against the erring employee for proven acts of misconduct. The trial court also taken note of the averments made in the plaint, and he did participated in the inquiry conducted against him. And in his affidavit and cross-examination, the plaintiff admitted that the appeal which was challenged, the award of punishment is still pending, and the same is noted in paragraph number 22, and comes to the conclusion in paragraph 33 that when the plaintiff fails to establish that there is a violation of principles of natural justice by defendants on conducting domestic inquiry against the plaintiff, there is no question of declaring the punishment orders dated 29/9/2011 issued by the disciplinary authority as null and void and dismiss the suit. Being agreed by the said finding, an appeal is filed before the court, and the appellate court also having reassessed the oral and documentary evidence and also considering the grounds which have been urged, extracted in paragraph number 11 and formulated the point in paragraph number 14, whether the trial court has committed an error in decreeing this suit without considering the evidence, and whether it requires interference, as the finding of the trial court is capricious and against the material on record. And the first appellate court, also having reassessed the material available on record, comes to the conclusion that trial court has not committed an error, and also taken note of the reasoning given by the trial court, particularly in paragraph number 27 to 29, and also in paragraph number 24, the exhibit P10, letter written by the Deputy General Manager HR to the plaintiff, and also the letter written by the plaintiff to the Deputy General Manager in terms of exhibit P11 and 12, and also taken note of exhibit P13 and 14. And also taken note of, except relying upon document exhibit P18, the plaintiff has not produced medical documents to show that he was under treatment, nor produced any document to show that one of the vested interest in the organization, the vigilance officer who had encountered receipt of advisory letters from the plaintiff masterminded fabrication of the hospitalization of the plaintiff and got a memorandum issued to the plaintiff on his imaginary grounds. And all these factors were taken note of by the first appellate court. And when the ground is also urged with regard to the violation of natural justice comes to the conclusion that no such circumstances is found, even with regard to the contention of second show cause notice to him. The appellate court taken note of the same that in the plaint, that is not the ground which has been pleaded in the pleadings, and any such submission without pleadings does not arise for consideration, and hence affirm the judgment of the trial court. Being agreed by the concurrent finding, the present second appeal is filed before this court, and in the grounds which have been urged in the second appeal would contend that the impugned judgment and decree passed by the trial court in dismissing the suit of the plaintiff on 15/3/2011 is not based on the sound principles, and also the same is capricious. And counsel also, one party in person also would vehemently contend that trial court is not justified in dismissing the suit on the ground that there are no sufficient ground and there is no any violation of principles of justice. And first appellate court also committed an error in not considering the same in a proper perspective. The respondent counsel would vehemently contend that it is not in dispute that an inquiry is ordered, and also in the inquiry he participated, and also given his representation, admitting his lapses, and also requested the authority to pardon him and closed the same as a special case. And the same also taken note of by the trial court in paragraph number 24. And also trial court comes to the conclusion that admitted that appeal was pending, and the same is discussed in para 32. And also in paragraph number 33 also comes to the conclusion that principles of natural justice is not violated, and hence suit is not maintainable, and appellate court also considered the same while reappreciating the grounds which have been urged. Having heard the party in person and also the counsel appearing to the respondent, and also the very grounds which have been urged in the original suit, it is very clear that an inquiry is ordered, and the appellant also participated in the said inquiry, and also even copy of the report is also furnished to him, and he also gave the representation, and the same was also taken note of by the trial court in paragraph number 24, wherein also he admitted his lapses and also request was made to pardon him, considering the same as a special case, and the same is not disputed by the counsel appearing with the appellant for having given such representation. And in order to prove the factum that there was a clear violation of principles of natural justice, nothing is placed on record. And also taken note of, he has participated in the inquiry proceedings conducted against him. And also in his affidavit and cross-examination, he categorically admitted that appeal which was challenging the award of punishment is still pending. And admission made in the plaint and evidence become judicial admission, and it has evidentiary value. And in view of the admissions, he had given the full opportunity to defend himself, and hence comes to the conclusion that there is no any violation of principles of natural justice by the defendants with regard to the inquiry is concerned. And when such finding is given by the trial court, considering the evidence and admission on the part of the plaintiff and the very contention of the counsel that trial court has committed an error and not considered the material on record cannot be accepted. The first appellate court also, having considered the grounds which have been urged in the appeal, even extracted the grounds which have been urged in paragraph number 11 of the appeal memorandum, and also framed the point for consideration in paragraph number 14, and reassessed both oral and documentary evidence, particularly even the documents which have been placed before the trial court. In paragraph number 23, documents which have been relied upon, and also the opportunity was given, and the same is also extracted, and also except producing document exhibit P18 that plaintiff has not produced medical documents to show that he was under treatment, not produced documents to show that one of the vested interest in the organization the vigilance officer who had encountered receipt of advisory letters from the plaintiff. Masterminded fabrication is alleged, and the same is not been established, and also comes to the conclusion that even principles of law was considered in paragraph number 27 to 29, and even with regard to the contention that second notice is concerned, no such second notice was given, and the same was not pleaded in the plaint, and also not led any evidence, and in the absence of pleadings and evidence, the same cannot be considered, and all these grounds could be urged before the appellate authority, and admittedly the appeal is pending, and party in person would submit that the same is not yet disposed of, and hence the very contention of the counsel appearing to the appellant and the same cannot be considered in this civil proceedings. And the only ground which has been urged before the civil court is that there is a clear violation of principles of natural justice. And having taken note of admission on the part of PW1, the court comes to the conclusion that given full opportunity to defend himself, and when such being the case, question of invoking the civil jurisdiction with regard to the punishment is concerned to declare the same as null and void when the opportunity was given doesn't arise, and hence I do not find any ground to admit and frame substantive question of law, and both have been considered by the trial court and appellate court, the facts as well as question of law, and hence no merit to admit and frame substantive question of law. In view of the discussions made up, I pass the following order. Second appeal is dismissed.
My lord, can I make a small final submission?
Really?
I am not asking for justice. I am fighting against injustice. ನಾನು ಡಿಸಿಪ್ಲಿನರಿ ಅಥಾರಿಟಿ ನನಗೆ ವಾರ್ನಿಂಗ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ, ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿಲ್ಲ. ನಾನು ವಾಲಂಟ್ರಿ ಅಪೀಲ್ ಕೊಟ್ಟೆ, ಮಾಡಿಲ್ಲ. 13 ವರ್ಷ ಇಟ್ಕೊಂಡು ಇನ್ನೂ ಮಾಡಿಲ್ಲ. ನಾನು ಬಂದು ಕಂಪನಿಗೆ ಯಾವ ಲಾಸ್ ಮಾಡಿಲ್ಲ. 5,031 ರೂಪಾಯಿ ನನ್ನ ಕೈಯಿಂದ ನಾನು ಕೊಟ್ಟಿದ್ದೇನೆ, ಕಂಪನಿ ಕೊಟ್ಟಿಲ್ಲ. ನನ್ಗೆ ಆಗಿರೋ ಸಿಕ್ನೆಸ್ ಡ್ಯೂರಿಂಗ್ ಅಂಡ್ ಇನ್ ದ ಕೋರ್ಸ್ ಆಫ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ನನ್ಗೆ ರಾಯಲ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಕೊಡ್ಬೇಕಾಯ್ತು. ಐ ಆಮ್ ಟ್ರೀಟೆಡ್ ಲೈಕ್ ಎ ಬೆಗರ್. 39 years ಸರ್ವಿಸ್ ಮಾಡ್ಬಿಟ್ಟು when I should come like a king. One second, last line.
ಏನ್ ಮಾಡ್ಬೇಕು?
ಇಲ್ಲ, I just put my head down in shame and came. No, I am only requesting, ನನ್ಗೆ injustice ಆಗಿ ರಿಮೂವ್ ಮಾಡ್ಕೊಡಿ, ಬೇರೆ ಏನೂ ಕೇಳ್ತಾ ಇಲ್ಲ.
ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಕ್ ಬರಲ್ಲ ಅದು. ನಿಮ್ ಕೇಸ್ ಏನು, ಪ್ರಿನ್ಸಿಪಲ್ಸ್ ಆಫ್ ನ್ಯಾಚುರಲ್ ಜಸ್ಟಿಸ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬೀನ್ ಮೆಟ್ ಅಂತ. ಬಟ್ ಅದಕ್ಕೆ ಮೆಟೀರಿಯಲ್ ನೋಡುವಾಗ ನೀವು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದಿರಿ, ಎಲ್ಲ ಮಾಡಿದಿರಿ, ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಕೊಟ್ಟಿದಿರಿ, ಪಾರ್ಡನಿಂಗ್ ಕೇಳಿದಿರಿ, ಎಲ್ಲ ಮಾಡಿದಿರಿ. ಅವ್ರು ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ, ಅದು ನಿಮಗೆ ಪನಿಷ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ದಟ್ ಯು ಕ್ಯಾನ್ ಅರ್ಜ್ ಇನ್ ದಿ ಅಪೀಲ್, ದಟ್ಸ್ ಆಲ್.
When the proceedings was going on, my letter was not acted. Subsequently, they themselves produced annexed D1 and D2, where Dismissal authority has already given order.
Raghunathn avare, nam scope is very limited.
I accept your honor. I politely accept. This one more order for me.
You urge the same in the appeal, that's all.
50. Sriram T. Nayak.
Sriram T. Nayak.
It's injunction suit partly decreed, RA dismissed. Plaintiff and defendants are family members. 1967 partition deed. Adjacent properties are allotted to each other. There is a common wall in between and one well, which is the crux of the dispute. Injunction suit nalli it is decreed that the well can be used.
B schedule property ಕೊಟ್ಟಿದ್ದಾರೆ.
Yes. So what happened? The common wall. A common wall ಮಧ್ಯದಲ್ಲಿ dilapidated condition ಆಗಿ ಅದು ಬಿದ್ದೋಗುತ್ತೆ. So what we do, the plaintiff constructs a wall in his land. The defendants ಆ wall ಮೇಲೆನೆ construct ಮಾಡ್ಬಿಡ್ತಾರೆ without leaving any setbacks. A complaint has been given and evidences also were produced before the court. That is not considered, not leaving proper setback and damaging the wall. That particular part which the prayer was sought, that is dismissed. The same has been confirmed in the appeal. Photographs are produced. ನನ್ನ ಜಾಗದಲ್ಲಿ ನಾನು ಕಟ್ಕೊಂಡಿರೋದು, ಅವ್ರು ಸೆಟ್ ಬ್ಯಾಕ್ ಬಿಡದೆ ಅದನ್ನ ಕಟ್ಟಿ ಡ್ಯಾಮೇಜ್ ಮಾಡಿ ಅದು ಬಿದ್ದೋದ್ರೆ ನಂದು ಪೂರ್ತಿ ಮನೆ ಬಿದ್ದೋಗುತ್ತೆ.
ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಅಡ್ಮಿಷನ್ ನೋಡಿ, ಪ್ಯಾರಾ 16 ಅಲ್ಲಿ. You don't have any exclusive right.
I don't have any exclusive right on the wall.
ಸುತ್ತುಗಳ ಮಧ್ಯೆ ಮರದ ಹಲಿಗೆಗಳು ಇದ್ದವು. ಹಿಸೆಯ ಕಾಲದಲ್ಲಿ ಮರದ ಹಲಿಗೆಗಳನ್ನು ತೆಗೆದು ಗೋಡೆಯನ್ನು ಕಟ್ಟಲು ನಿರ್ಧಾರ ಆಗಿತ್ತು ಎಂದರೆ ಸರಿ, ಹೌದಾ?
ಆದ್ರೆ ಅದನ್ನ
ಇಬ್ಬರು
ತೆಗೆದಿರ್ಲಿಲ್ಲ.
ಸಮಖರ್ಚು ಮಾಡಿ ಗೋಡೆ ಕಟ್ಟಬೇಕು ಎಂದು ಹಿಸಾಬ್ ಪತ್ರದಲ್ಲಿ ನಮೂದು ಇದೆ ಎಂದರೆ ಸರಿ.
ಕರೆಕ್ಟ್ ಕರೆಕ್ಟ್ ಕರೆಕ್ಟ್. ಅದ್ರಲ್ಲಿ
ನನ್ನ
ಏನಾಗಿದೆ?
ಮತ್ತು ಪ್ರತಿವಾದಿಯ ಮಧ್ಯೆ ಇದ್ದ ಮರದ ಹಲಿಗೆಗಳ ಗೋಡೆಯು ನನಗೆ ಮಾತ್ರ ಸೇರುತ್ತದೆ ಎಂದು ಬರೆದಿಲ್ಲ.
ಕರೆಕ್ಟ್.
ನನ್ನ ಮತ್ತು ಪ್ರತಿವಾದಿಯರ ಸ್ವತ್ತುಗಳ ಮಧ್ಯೆ ಇರುವ ಗೋಡೆಯಲ್ಲಿ ಇಬ್ಬರಿಗೂ ಹಕ್ಕಿರುತ್ತದೆ. ದಟ್ ಈಸ್ ಯುವರ್ ಅಡ್ಮಿಷನ್.
ಹೌದು. ಆದ್ರೆ
ಪ್ರತಿವಾದಿಯರು ತಮ್ಮ ಸ್ವತ್ತಿನಲ್ಲಿ ಮನೆ ಕಟ್ಟಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿ.
ಅವ್ರು ಅದ್ರಲ್ಲಿ ಕಟ್ಟಿರೋದು ಸರಿ, ಎಲ್ಲ ನಾನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಇವಾಗ ಏನಾಗಿದೆ, ಮಧ್ಯದಲ್ಲಿ ವಾಲ್ ಬೌಂಡ್ರಿ ಬಿದ್ದೋಗಿದ್ದನ್ನ ಯಾರು ಅದನ್ನ ನರೇಟ್ ಮಾಡಿಲ್ಲ. ಆ ಬೌಂಡ್ರಿ ವಾಲ್ ಬಿದ್ದೋಗಿದ್ದನ್ನ ನಾನ್ ರೀಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡಿದೀನಿ. ಅದ್ರ ಮೇಲ್ಗಡೆ ಕಟ್ಕೊ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಎಲ್ಲೂನು ಯಾವ್ದೇ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ನಲ್ಲಿ ಅಲೋ ಮಾಡ್ಲಿಲ್ಲ. ಇಫ್ ದಟ್ ಬೌಂಡ್ರಿ ವಾಲ್ಸ್ ಫಾಲ್ಸ್ ಅಗೇನ್, ಇಟ್ ವಿಲ್ ಬಿ ಆನ್ ಮೈ ಪ್ರಾಪರ್ಟಿ. ನಾನ್ ಪರ್ಮಿಷನ್ ತಗೊಂಡು ಎಲ್ಲ ಮಾಡಿ ಆಸ್ ಪರ್ ದ ಗವರ್ಮೆಂಟ್ ನಾರ್ಮ್ಸ್ ಓನ್ಲಿ ಐ ಹ್ಯಾವ್ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಮೈ ಬಿಲ್ಡಿಂಗ್. Now it is not said in the partition deed that they can construct over the wall itself directly their building. If they would have taken prior permission, ಇಷ್ಟು ಸೆಟ್ ಬ್ಯಾಕ್ ಬಿಟ್ಟು ಅವ್ರು ಕಟ್ಟಿದಿದ್ರೆ ನನಗೆ ತೊಂದರೆನೇ ಇರ್ಲಿಲ್ಲ. ಅವ್ರ ಜಾಗದಲ್ಲಿ ಅವ್ರು ಕಟ್ಕೊಂಡಿದ್ದಾರೆ, ಇಲ್ಲ ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇಲ್ಲ. ಆದ್ರೆ ಇಟ್ ಇಸ್ ಆನ್ ದ ಬೌಂಡ್ರಿ ವಾಲ್ ಇಟ್ ಸೆಲ್ಫ್. I produced the photographs also before the lower court. My dispute is only this, Marat. ಆ ಬೌಂಡ್ರಿ ವಾಲ್ ಮೇಲೆ ಅವ್ರು ಕಟ್ಕೊಳ್ಬಾರ್ದಾಗಿತ್ತು ಅಷ್ಟೇ. ಆ ವಾಲ್ ಬಿತ್ತು ನನಗೆ ಡ್ಯಾಮೇಜ್ ಆಗುತ್ತೆ ನನ್ನ ಪ್ರಾಪರ್ಟಿಗೆ.
But ನಿಮ್ಮ admission is very clear.
It is only with respect to the boundary wall which was available during the time of 1967.
ಹೌದು.
Only that particular part has been extracted in the judgment of the original suit. I agree there is a boundary wall in between. ಪಾರ್ಟಿಷನ್ ಆಗಿರೋದು ನಾನು ಒಪ್ಕೋತೀನಿ, ಇಬ್ರಿಗೂ ಅದ್ರಲ್ಲಿ ರೈಟ್ಸ್ ಇದೆ, ನಾನು ಒಪ್ಕೋತೀನಿ. ಬಟ್ ದಟ್ ಡಸ್ ನಾಟ್ ಗಿವ್ ದೆಮ್ ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ ರೈಟ್ ಟು ಬಿಲ್ಡ್ ಆನ್ ದ ಬೌಂಡ್ರಿ ವಾಲ್ ಇಟ್ಸೆಲ್ಫ್ ವಿದೌಟ್ ಟೇಕಿಂಗ್ ಪ್ರಯರ್ ಸ್ಯಾಂಕ್ಷನ್ ಫ್ರಮ್ ದ ಗವರ್ಮೆಂಟ್ ಅಥಾರಿಟೀಸ್.
ಅವ್ರು ಕಟ್ಕೊಂಡಿದ್ದಾರೆ ಅನ್ನೋದಕ್ಕೆ ಏನ್ ಮೆಟೀರಿಯಲ್ ಪ್ಲೇಸ್ ಮಾಡಿದ್ರಿ ನೀವೇನು?
ಫೋಟೋಗ್ರಾಫ್ ಗಳನ್ನ ಕೊಟ್ಟಿದೀವಿ ಸ್ವಾಮಿ.
ಫೋಟೋಗ್ರಾಫ್ಸ್
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಎಲ್ಲಿದೆ? ಅದೆಲ್ಲಿ ಮಾರ್ಕ್ ಆಗಿದೆಯಾ?
ಮಾರ್ಕ್ ಆಗಿದೆ, ಎಕ್ಸಿಬಿಟ್ ಆಗಿ ಮಾರ್ಕ್ ಆಗಿದೆ.
ಆಗಿದೆಯಾ?
ಹೌದು. ಫೋಟೋಗ್ರಾಫ್ಸ್
certified copy tax register obtaining building construction, certified copy of obtaining building construction permission, certified copy of the complaint given to CMC. ಎಲ್ಲಿದವಲ್ಲ? ಯಾವ ಫೋಟೋನು ಇಲ್ವಲ್ರಿ?
ಸರಿ,
ಡಿಮ್ಯಾಂಡ್ ರಿಜಿಸ್ಟರ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಏನು ಇಲ್ವಲ್ಲ?
Well, a date may be fixed, Marat. I'll produce the photographs also.
ಈಗೇನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಿ? ಇನ್ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ
That's a mistake done by the
ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ?
No, I'll at least just show it.
ಅದಕ್ಕೇನೆ ನಿಮಗೆ
to show my bona fide.
ನಿಮಗೆ ಎ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟಿಲ್ಲ, ಬಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟಿದ್ದಾರೆ ರಿಲೀಫ್. ದಟ್ಸ್ ಆಲ್.
ಹೌದು ಹೌದು.
So this matter is listed for admission. I heard the counsel appearing for the appellant. This appeal is filed against the concurrent finding by the plaintiff against granting the relief in respect of only B schedule property is concerned. And the relief with regard to restraining the defendants from causing any sort of construction on the northern side of the wall of plaintiff as alleged is declined. The same is declined only based on the reasoning of the trial court considering the admission on the part of the PW1 which has been extracted in paragraph number 16. And hence it is clear that the said common wall belongs to the plaintiff and defendant, and the same is located in between both the property of the plaintiff and defendant. And also categorical admission was given that the defendants have constructed the house in their property. And also the trial court taken note of the right which was given to the plaintiff in terms of the partition deed of the year 1967 with regard to the well is concerned, and hence granted the relief in respect of well is concerned, that is which is more fully described as the B schedule property for drawing of water. Being agreed by the said declining to grant the relief, The second appeal is filed before the appellate court. The appellate court also having considered the grounds urged in the appeal memo, formulated the point whether the trial court has erred by declining the relief of restraining from causing any sort of construction on the northern side of the wall by the respondents. And having considered the both oral and documentary evidence, reassessed the same in paragraph number 18 and taken note of the plaintiff is relying on a complaint which is marked as Exhibit P5, which was made to the municipality by the plaintiff that defendant number 1 and 2 are trying to repair the wall without obtaining the permission from the municipality. Only on the basis of the complaint which was made by the plaintiff against the defendant number 1 and 2 to the municipality, the court cannot come to conclusion that the wall is exclusively belongs to the plaintiff, as there are no substantial evidence to support the same, except mere self-serving affidavit of the plaintiff. There are no oral or documentary evidence available on record to substantiate that the wall has been constructed by the plaintiff and it exclusively belongs to him. The appellate court also taken note of the recital of document Exhibit P1 in paragraph number 20, and so also taken note of the evidence of PW1 and also the evidence of DW1, and comes to the conclusion that trial court has not committed any error in appreciating both oral and documentary evidence and confirm the judgment of the trial court and dismiss the appeal. Being agreed by the said concurrent finding of both the courts, the present appeal is filed by the appellant, plaintiff, contending that the very approach of both the courts are erroneous and committed an error in holding that certified copy of the partition deed produced at Exhibit P1 was not taken note of while considering the material and record, and committed an error in considering the building construction permission obtained by the plaintiff has not been included the disputed wall, and hence this court has to admit and frame substantive question of law. Having heard the appellant counsel and also on perusal of material, particularly the relief claimed in the plaint as well as the evidence available on record and the evidence of PW1 and answer given in the cross examination, he categorically admits that there is a common wall and common wall belongs to both of them and both of them are having exclusive right in respect of the common wall is concerned. And also categorical admission was given that defendants have constructed the house in their property. And the same is narrated in paragraph number 16 and comes to the conclusion that there is no need of much discussion on this aspect and the plaintiff cannot claim that the said wall is exclusively belongs to him and the same is a common wall, and hence declined to grant the relief. And the appellate court also having reassessed the material available on record comes to the conclusion that trial court has not committed any error, and particularly taking note of document Exhibit P1 recitals which is discussed in paragraph number 20 of the judgment of the appellate court, nowhere laid a foundation for production of the certified copy of the document either in their plaint or in the chief examination. And particularly when the admission is given and Exhibit P1 is not having evidentiary value if it is taken just for the sake of discussion. There is an averment in Exhibit P1 that the party to the partition deed has to build the wall in between the property, contributing equally. And the same is also admitted by the PW1 in the cross examination. And when such material is considered by the both trial court as well as the appellate court, and when the plaintiff is not having any exclusive right in respect of the said common wall, rightly declined to grant the relief. And hence I do not find any ground to admit and frame substantive question of law both question of fact and question of law are considered by the both the courts, and hence not a case to invoke section 100 of CPC. In view of the discussion made up, I pass the following order. Second appeal is dismissed.
C. S.V. Prakash, Kumara KG.
It is a defense appeal, my lord. Defendant number 2 is the decree holder, specific performance of decree in respect of 10 guntas of land. And execution was pending. Without considering all these aspects, the injunction, decree of injunction has been granted to the plaintiff. In this case, the
Suit for bare injunction, you have admitted the possession of the plaintiff. Go to paragraph number 11.
My lord, thing is that even the GPA, alleged GPA has not been seen, not produced. So at least
Perusal of the evidence of the DW1 in his cross examination, the defendant is also admitted the possession of the plaintiff. But only the contention of the defendant is that earlier the original owner executed exhibit D2, the sale agreement in respect of the suit shall property. And by filing the suit for specific performance, the suit came to be decreed in favor of the plaintiff. However, the present suit is for the relief of bare injunction based on the possession. Whereas the exhibit P1 to P10 clearly discloses the exclusive lawful possession of the plaintiff over the suit shall property. And defendant also admitted the possession of the plaintiff over the suit shall property. Therefore, possession of the plaintiff is established, and also in perusal of the evidence placed on record, it is clearly established that plaintiff duly purchased the suit shall property by registered sale deed dated 22/12/2011 from one Mansoor Altaf, who is the power of attorney holder of the original owner of the property. And perusal of exhibit D1 of the decree is clearly disclosed that present defendant is nothing to do with the plaintiff, as the present suit is not related to the suit. Your admission is the possession, exclusive possession of the plaintiff. What else required? Exhibit P1 to 10 also they produced.
Also decree holder of to the extent of 10 guntas.
ಆಯ್ತು ನೀವು ಹೋಲ್ಡರ್, ಬಟ್ ಇದಕ್ಕೆ ಈ ಪ್ರಾಪರ್ಟಿ ಏನಿದೆಯೋ ಅದಕ್ಕೆ ನೀವು ಅಡ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ. ಅಡ್ಮಿಷನ್ ಇದ್ಮೇಲೆ ಮುಗಿದೋಯ್ತು. ಇನ್ ಕೇಸ್ ಆಫ್ ಸೂಟ್ ಫಾರ್ ಇಂಜಂಕ್ಷನ್ ಸೂಟ್ ಅಲ್ಲಿ
Only to defeat my claim, it has all been created, my lord.
ಅದು ಹೇಗೆ ಆಗ್ತದೆ?
GPA after execution of the agreement, my lord, 2005 agreement. And the alleged sale is of the year 2011.
ಅವರಿಗಿದೆ ಅಗ್ರಿಮೆಂಟ್ ಇದೆ, ಡಿಗ್ರಿ ಆಗಿದೆ. Exhibit P1 to 10 also produced before the court evidence the fact that there was a sale deed. That is license issued by the Gram Panchayat.
Specific performance passed in the 2009.
Taxpayer receipt, ಖಾತಾ extract ಎಲ್ಲಾನು ಹಾಜರುಪಡಿಸಿದ್ದಾರೆ.
And execution is pending in the year 2010, my lord.
ಯಾವ ಎಕ್ಸಿಕ್ಯೂಷನ್?
Specific performance, my lord.
ಬಟ್ ನಿಮ್ಮ ಪೊಸೆಷನ್ ನೀವು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ ಡಿಫೆಂಡೆಂಟ್ DW1 ಅಲ್ಲಿ ಕ್ರಾಸ್
At least
ಎಕ್ಸಾಮಿನೇಷನ್.
the decree, the impugned decree could have been passed subject to the result of execution, my lord.
ಅದಕ್ಕೂ ನೀವು ಅಡ್ಮಿಷನ್ ಕೊಟ್ಮೇಲೆ ಇನ್ನೇನು ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ತೊಗೊಳ್ಳಿ, ಏನಿಲ್ಲ. Heard the appellant counsel and also the counsel appearing for the respondent. This matter is listed for admission, and the second appeal is filed against the concurrent finding. The suit is filed for the relief of permanent injunction, and only the plaintiff has to establish his possession. And trial court also, while considering the admission on the part of DW1, comes to the conclusion that DW1 categorically admitted the possession of the plaintiff, and the same is discussed in paragraph number 11. Only contention of the defendant was also taken note of that original owner executed exhibit D2, the sale agreement in respect of the suit share property, and by filing the suit for specific performance, the suit came to be decreed in favor of the plaintiff. However, the present suit is for the relief of bare injunction based on the possession, and also even consider the document exhibit P1 to 10, which clearly discloses the exclusive lawful possession of the plaintiff and hence granted relief of permanent injunction. Being agreed by the said finding, an appeal is filed in RA 80 of 2017, and appellate court also, having considered both oral and documentary evidence in keeping the grounds which have been urged. And also the defense number 2 also taken while considering the case of the appellant in paragraph number 22 with regard to the sale agreement in her favor in respect of the land measuring 10 guntas in the aforementioned survey numbers. And he had not performed the agreement, and therefore she had also filed a suit for specific performance. And the same was decreed as per Exhibit D1. However, the present suit has been filed by the plaintiff for the relief of permanent injunction based on possession. The documentary evidence produced by the plaintiff, coupled with the admission of the defendant number 2, clearly discloses that plaintiff is in possession and enjoyment of the property and established his possession over the social property by producing both oral and documentary evidence, and hence confirmed the judgment of the trial court. Being agreed by the concurrent finding, second appeal is filed before this court. The main contention of the counsel appearing for the appellant that both the courts have committed an error in granting the relief of permanent injunction and not exercise the power under Order 41, Rule 31 of Code of Civil Procedure. And plaintiff totally failed to do the possession. And first appellate court also failed to appreciate the entire material on record. And also would contend that both the courts acted without jurisdiction in granting decree of permanent injunction against the second defendant, notwithstanding the sale deed obtained by the plaintiff from the GPF holder of the first defendant is hit by doctrine of lis pendens embodied under Section 52 of the Transfer of Property Act. And hence this court has to admit and frame substantive question of law. The counsel appearing for the respondent would vehemently contend that the trial court in a suit for bare injunction taken note of the possession and the same has been admitted, and documents which have been produced also clearly discloses that plaintiff is in possession, and hence rightly granted the relief of permanent injunction. Having heard the appellant counsel and also the counsel appearing for the respondent, and in a suit for bare injunction, it is settled law that court has to take note of whether the plaintiff establishes his possession as on the date of filing of the suit. The trial court also, having considered both oral and documentary evidence in detail discussed in paragraph number 11, that DW1 in the cross-examination categorically admitted the possession of the plaintiff, and also taken note of the defense of the defendant pertaining to the document of Exhibit P2, the sale agreement, and also taken note of when the suit is filed for the relief of permanent injunction based on the possession, court has to look into the documents, and Exhibit P1 to 10 clearly discloses the exclusive lawful possession of the plaintiff over the suit shell property, and also defendant admitted the possession of the plaintiff over the suit shell property, and hence granted the relief. And appellate court also reassessed both oral and documentary evidence and taken note of the same in paragraph number 22 while discussing the case of the appellant also, and the present suit is also filed for the relief of permanent injunction, and based on the possession only suit is filed. Documentary evidence produced by the plaintiff coupled with the admission on the part of the defendant number 2, which discloses that the plaintiff is in possession and enjoyment of the suit shell property, confirm the same. When both the courts have taken note of oral and documentary evidence, especially the admission on the part of DW1 in the cross-examination, admitting the possession of the plaintiff, the very contention of the counsel appearing for the appellant that both courts have committed an error, and also pressing of Section 52 lis pendens doesn't arise in a case of suit for bare injunction when the possession of the plaintiff is admitted by the defendant who has been examined as DW1, and hence both question of fact and question of law is considered by the trial court that the plaintiff has proved his case with regard to the possession as on the date of the suit. The plaintiff is in possession considering the document Exhibit P1 to 10, and hence not a case to invoke Section 100 of CPC to admit and frame substantive question of law. In view of the discussions made up, I pass the following order. Second appeal is dismissed. 17 Prasad case. Divergent finding. Issue notice and call for records. Is this matter on 17/12, madam?
Yes, yes. 17/12. 18.
Also same order. Dismissed, reversed and granted. 19.
19.
Sudraya M.
For the appellant, my lord, kindly have it on tomorrow or the day after. Short accommodation.
Huh. ಹೇಳಿ.
Tomorrow or day after tomorrow, my lord.
Counsel date given matter ಹೇಳಿ. ಇಲ್ಲ ಅಂದ್ರೆ adjournment or date cost. Suit for declaration. Declaration or 10,000, injunction or 5,000. ಯಾವ್ದು ಬೇಕು?
ನಾಳೆಗೆ at least.
Choice is yours.
Notice.
Tomorrow, my lords. Kindly have it on tomorrow.
Choice is yours ಅಂತ. ಎಲ್ಲ ಅಡ್ಮಿಷನ್ಸ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ನೀವೇನು ಆನ್ಸರ್ ಕೊಟ್ಟಿದ್ದೀರಿ ಅದನ್ನ. ಪ್ಯಾರಾ 20, 22, 23, 19 and dismiss the suit.
Kindly have it on tomorrow.
ಹೇಳಿದ್ನಲ್ಲ.
ನಾಳೆಗೆ ಹಾಕೊಳ್ಳಿ.
ಡಿಕ್ಟೇಟ್ ಮಾಡ್ಲಾ ನಾನೇನೆ? ನಿಮ್ದು ಏನಾದ್ರು ಹೇಳೋದಿದ್ರೆ ಕೇಳ್ತೀನಿ.
ನಾಳೆ ಸ್ವಲ್ಪ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದೆ ಅದಕ್ಕೆ. There is a inconvenience today, my lord.
The appellant counsel seeks time and this matter is listed by giving the date for admission, and in spite of date is fixed for admission seeks time, and hence on cost of rupees 5,000 list this matter on 5/12. Cost is payable within 1 week from today at registry. Next, ಹೇಳಿ.
20.
ಇದು ಮೋಸ್ಟ್ಲಿ ನೆನ್ನೆ ಇನ್ಯಾವುದೋ ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ ಮೇಡಮ್, ಸಿಮಿಲರ್ 4-5 ಇದೆ.
ಸಿಮಿಲರ್ ನಾಲ್ಕು ಮ್ಯಾಟರ್.
ಏನು ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಇಶ್ಯೂ ನೋಟಿಸ್ ಮಾಡ್ಬೇಕಲ್ಲ?
11/12.
11/12.
ಮೊಬಿಲೈಸ್.
21. ಪಾಸ್ವರ್ಡ್. 21 ಅಲ್ಲಿ. ಪಾಸ್ವರ್ಡ್ ಅದು ಆಮೇಲೆ
ಆಯ್ತು. ಪಾಸ್ ಓವರ್ ಏನು ಬೇಕಾಗಿಲ್ಲ, ಕೊಡಿ. ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದೆ. ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಂಡ್ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್. List this matter on 17/12.
22.
Pass over.
23.
23. Pallava R. Manmohan PN.
May I kindly pass over.
Dismissed, confirmed. Pass over.
I appear for respondent in this matter. Lordship, I am the caveat respondent. Copies have not been served on.
ಕೊಡ್ರಿ, ಕಾಪೀಸ್ ಕೊಡ್ರಿ ಅವರಿಗೆ. ಅಪೀಲ್ ಮೆಮೊ ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಕೇವೇಟರ್ ನೋಡಿ.
Yes, my lord.
ಕೊಡಿ. ಪಾಸ್ ಓವರ್.
24.
This matter, the defendant's appeal, my lord. The plaintiff is my brother. Plaintiff number 1 and defendant number 1 are brothers. He's filed a suit for eviction and injunction on the basis of a decree that was passed in another suit, OS number 155 of 2009, which I had filed for partition. In that suit, there were divergent findings. With respect to one house property, my share was decreed. And in appeal, that decree was set aside. That has come before this honorable court in RSA number 89 of 2018, which came to be admitted on 24/4/2024. But before the appeal was admitted and a stay order was passed in that matter, the appeal in the eviction suit, both the trial court and the first appellate court dismissed the suit. Decreed the suit of eviction on the ground that there was no stay in RSA 89 of 2018. Here, what has happened, my lord? The plaintiffs and the plaintiff number 1 and defendant number 1 are brothers. Plaintiff number 1 in these proceedings claims that he has purchased one property under a sale deed of the year 1974 from his father. Whereas, if my lord would just permit me to hand on the order passed in RSA 89 of 2018. The reason that appeal came to be admitted.
Adala stay idea.
Adinal stay there. I'll say this for me. If my lord would see paragraph 2, it says learned counsel for the appellant referring to paragraph number 9 of the written statement submits that defendant number 1, that is the plaintiff herein, had admitted the business that he had carried on with the father of the plaintiff and defendants, and also admitted that item number 2 of the suit schedule property was purchased by the father of the plaintiffs and defendants. She further submits that defendant number 1 had however contended that in the year 1974, he purchased the suit item number 2 of the suit schedule properties from his father. Referring to the same, learned counsel submits that there is material enough on record to show that item number 2 of the suit schedule properties is also the joint family property purchased from the earning of joint family business, which according to her has been lost sight of by the first appellate court. So therefore, my lord, what has happened is this
Second appeal file ಮಾಡಿರೋದು ಯಾರು?
ಈ ಕೇಸಲ್ಲಿ ಸೆಕೆಂಡ್ ಎರಡಲ್ಲಿನೂ ನಾನೇ ಅಪೆಲೆಂಟ್ ಇದ್ದೀನಿ. ಅದರಲ್ಲಿ ಐ ಆಮ್ ದ ಪ್ಲೇಂಟಿಫ್ ಇನ್ ದ ಸೂಟ್, ದೇರ್ ಆರ್ ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ಸ್. ಇದರಲ್ಲಿ ಫಾಲೋಯಿಂಗ್ decree in the first appeal, and because of the fact that as on that date this appeal had not been admitted, RSA 89 had not been admitted, the suit for eviction came to be decreed. Now my lord would only see, the plaintiffs in the eviction suit have admitted that I am in possession of an extent of 270 square feet, 18 feet by 15 feet in the northeast portion of the house property.
That is the reason only order to deliver the possession in favor
My
of
lord,
him.
but the point is I am in possession, and the fact is he's claiming under a sale deed which he claims my father is
Like there was a delay of 400 days in filing.
My lord, the fact of the matter is that the appellants are senior citizens, they are unlettered.
Senior citizen ಗೆ exemption ಇಲ್ಲ madam.
ಇಲ್ಲ ಆಯ್ತು ಸ್ವಾಮಿ, but the point is they're really genuinely extremely illiterate, my lord.
ಅದೊಂದು ಹೇಳಿರೋದು ಬಿಟ್ರೆ ಬೇರೆ ಏನೋ reason ಹೇಳೇ ಇಲ್ಲ.
ಇಲ್ಲ ಇದು
I am a senior citizen and was suffering from serious illness due to the which there is a delay. ಅದೊಂದೇ reason ಹೇಳಿರೋದು.
ಸ್ವಾಮಿ ಅದು they are very unlettered people. ಇದರಲ್ಲಿ ಏನಾಯ್ತು ಅಂದ್ರೆ ಇದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕೊಂಡಿದ್ರು, ಅದು ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಆಯ್ತು.
ಏನ್ ಕೊಡಬೇಕು reason ನೋಡಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಒಂದು because RSA 89 of 2000, my fortunes will rise or fall on RSA 89 of 2018.
Maybe madam, here in this case there is a delay, on the delay 404 days which has not been explained.
May I be permitted to file a better affidavit?
I can throw this second appeal.
May I be permitted to file a better affidavit, my lord, please? I mean, my most respectful submission. Avaga execution hakidru.
At least while preparing the affidavit, you should apply your mind.
Yes, Swami, adenaitandre execution number 20 of 2023 alli delivery warrant agoyittu. Alli police bandidvaga manege possession ತಗೊಳ್ಳಕ್ಕೆ that point legal
ಆಯ್ತು, ಏನು ಡಿಲೇ ಇತ್ತಲ್ವಾ ಆಲ್ರೆಡಿ
ಸ್ವಾಮಿ?
ಏನು ಈ ಕೋರ್ಟ್ ನಲ್ಲಿ ಡಿಲೇ ವಿತ್ ಡಿಲೇ ಇದ್ದೇನೆ ಸ್ಟೇ ಏನಾದ್ರು ಕೊಟ್ರಾ? ಇಲ್ಲ
ಇಲ್ಲ, ಈ RSA 89 of 2018 ಅಲ್ಲಿ ಸ್ಟೇ ಇತ್ತು. ಏನಾಯ್ತು ಆ ಆರ್ಡರ್ ಅಲ್ಲಿ ಡೀಟೇಲ್ಡ್ ಆಗಿ ಬರ್ದಿದ್ದಾರೆ.
Appellant counsel seeks time to file better affidavit in support of IA number 1 of 24. List this matter on 5/12.
Deeply obliged.
5 Sachin BS, Sanat Kumar Shetty.
Good for possession.
ಏನಾಯ್ತ್ರಿ?
Please, my lords, in the previous occasion has directed to secure the instruction regarding how much time is required to vacate the premise. Admittedly, I am the tenant, my lords. ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅವರು ಪ್ಯಾರಲಿಸಿಸ್ ಆಗಿದೆ ಅವರಿಗೆ.
98 ಇಂದ proceedings ನಡೀತಾ ಇದೆ.
Please, that is
HRRP was filed
2012. earlier on.
ಹೌದು, HRRP ಹಾಕಿ ಅದು jurisdiction ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಸೂಟ್ ಹಾಕಿದ್ರು.
ಆಮೇಲೆ ಎಜೆಕ್ಟ್ಮೆಂಟ್ ಸೂಟ್, ಈಗ ಎಜೆಕ್ಟ್ಮೆಂಟ್ ಸೂಟ್ ಆಯ್ತು. ಹೇಳಿ ಈಗ ಏನಾಯ್ತು?
Please, I may be permitted to seek time, my lords. That's it, my lords, for the period of 6 months. Because the reason is
ಬೇಡ ಸ್ವಾಮಿ, ಯಾಕೆಂದ್ರೆ
ಬಟ್ ರೆಂಟ್ ಕೊಟ್ಟಿಲ್ವಲ್ಲ ನೀವು? ರೆಂಟ್ ಕೊಟ್ರಾ?
Rent, my lords.
ಕೊಡಿ, ಆಮೇಲೆ ನೋಡೋಣ, ಕನ್ಸಿಡರ್ ಮಾಡೋಣ ಅಂತ ಹೇಳಿದ್ದೆ. ನಿಮ್ ಟೈಮ್
Please, my lords.
36,400 ರೆಂಟ್ ಇದೆ.
Please, my lords.
ಈಗ 2,500 ರೂಪಾಯಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ.
ಎಕ್ಸಿಕ್ಯೂಷನ್ ನಲ್ಲಿ another brother, the sibling has intervened and now obstruction petition is under consideration. Now in this appeal another sister intervened and she was impleaded. Now one by one they are.
ರೆಂಟ್ ಕೊಡ್ದಲೆ ಬಾಡಿಗೆ ಅಂಗಡಿ ಕೊಡ್ದಲೇನೆ ನೀವು 6 ತಿಂಗಳು ಟೈಮ್ ಕೊಡ್ತಾರೆ.
ರೆಂಟ್ ಕೊಡ್ತಾ ಇದಾರೆ ಅಂತೆ.
ಎಲ್ಲಿ ಕೊಡ್ತಾ ಇದಾರೆ? ಇಲ್ಲ
ಕೊಡ್ತಾ ಇದಾರೆ ಅಂತ ಹೇಳಿದ್ರು.
ಇಲ್ಲ, ಆರ್ಡರ್ ನಲ್ಲಿ ನೋಡಿ ಮಾಡಿದ್ದಾರೆ.
Please, my lords.
2,000 ಕೊಡ್ಬೇಕು ಫ್ರಮ್ ದ ರೇಟ್ ಆಫ್
500, my lords.
2,500 ಅಂತ ಮಾಡಿದಾರ್ರಿ ಫಸ್ಟ್.
Please, that was reduced to, that is the claim of the
and is directed to pay arrears.
Please,
ಹೌದಾ?
Please.
Now that is appeal ಅಲ್ಲಿ mostly 500 ಮಾಡಿದ್ದಾರೆ.
Please, my lords, because that was the admitted rent, my lords, from us.
Admitted rent 500 ರೂಪಾಯಿ ಕೊಡಿ ಅಂತ appeal ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ.
Please, my lords.
ಬಟ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 2,500 ಮಾಡಿದ್ದಾರೆ.
Please, my lords.
ಹೌದಾ?
please.
ಆ ರೆಂಟೇ ಕೊಟ್ಟಿಲ್ವಲ್ಲ?
That we preferred appeal.
ಅರಿಯರ್ಸೇ 36,400 ಇದೆ.
Please, my lords. That we will pay, my lords.
ಯಾವಾಗ ಕೊಡ್ತೀರಿ ಹೇಳಿ?
But only the thing is, my lords, possession, my lords, let me be.
ಅದ್ ಕೊಡಿ, ಆಮೇಲೆ ಟೈಮ್ ಕೇಳಿದ್ರೆ ಅದಕ್ಕೆ ಸಪರೇಟ್ ರೆಂಟ್ ಕಂಟಿನ್ಯೂ ಆಗದಾರೆ.
Please, my lords.
ಅದನ್ನೇ ಕೇಳಿ ಹೇಳಿದ್ ನಾನು ನಿಮಗೆ ಮೊನ್ನೆ.
Please, my lord, I have secured the instructions with regard to the same.
Okay, dismiss ಮಾಡೋಣ, ಬಿಡಾವಾಗ ಸರಿ ಆಗ್ತದೆ.
My lords, will be comply with the rent, my lords, within the end of this month, my lords, the arrear rent. But my lords, subject to the days of continuation in the possession, my lords, 6 months time.
6 ತಿಂಗಳಿಗೆ ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಬಾಡಿಗೆ? ಹೊಸ ಫ್ರೆಶ್ ಬಾಡಿಗೆ?
My lords may fix the rent, my lords. My lords may fix the rent, because my lords, fact is this, ಯಾಕಂದ್ರೆ ಅವರು ಪ್ಯಾರಲಿಸಿಸ್ ಆಗಿದ್ದಾರೆ, ಹೆಂಡತಿ ಮಾತ್ರ ನೋಡ್ಕೊಳ್ತಾ ಇರೋದು, ಮಕ್ಕಳು ಕೂಡ ಇದ್ದಾರೆ. ಸೊ ಹಾಸ್ಪಿಟಲ್ ಬಿಲ್ಸ್ ಇದೆ.
ಪ್ರಿಮೈಸಸ್ ಏನು ಹೇಳಿ?
Please, my lords.
ಅಪ್ಟಿರೋದು ಪ್ರಿಮೈಸಸ್.
Premises
ಮುಲ್ಕಿಯಲ್ಲಿ.
Please, my lords.
ಮುಲ್ಕಿ is also a grown up city.
ಮಂಗಳೂರಿಂದ ಹೊರಗಡೆ ಬಂತದು, ಮಂಗಳೂರಲ್ಲ.
ಹೊರಗಡೆ ಬಂದ್ರು ನಾನು ನೋಡಿದೇನ್ರಿ ಮುಲ್ಕಿನ, ಹೇಳಿ.
Please, my lords, please, my lords.
ನೀ ಹೇಳಿ ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಅಂತ?
ಚಪ್ಪಲ್ ಅಂಗಡಿ ಇರೋದು ಇವ್ರದ್ದು, ಸ್ಯಾಂಡಲ್
ಚಪ್ಪಲಿ ಅಂಗಡಿ.
ಹೌದು, ಅಷ್ಟೇ ಇರೋದು.
ಅಕಾರ್ಡಿಂಗ್ ಟು 98 ಇಯರ್ಸ್ ಇಂದ ಅವರು ಹೋರಾಟ ಮಾಡ್ತಾವ್ರೆ ಅಂತ.
Please, that is true only.
27 ವರ್ಷ ಆಯ್ತು.
Please, my lords, that is true. That is true, my lords.
ಎಷ್ಟು ಕೊಡ್ತೀರಿ ನೀವು ಹೇಳ್ಬಿಡಿ ಬೇಗ. ಈಗ ಅದರ್ವೈಸ್ I will fix 10,000. ಮತ್ತೆ ನಿಮಗೆ ಟೈಮ್ ಬೇಕಲ್ಲ?
ಟೈಮ್ ಅಗತ್ಯ ಇಲ್ಲ, ಯಾಕಂದ್ರೆ ಇನ್ನೊಬ್ರು ಅಬ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿ ದಟ್ ಈಸ್ ಪೆಂಡಿಂಗ್. They are buying time.
ಬರೋದಿಲ್ಲ. Please, my lords may pass over. I will seek one instruction from the client for the final amount, my lords. Then, my lords, if they agree, my lords, and otherwise, my lords may take the. Please, my lords, oblige.
ಹೇಳಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಇವತ್ತು ಡಿಸ್ಮಿಸ್ ಆಗ್ತದೆ.
Please, please.
ಕೇಸಲ್ಲಿ ಏನಿಲ್ಲ.
26 ಎಚ್ ಸಿ
ಶಿವರಾಮ್. ಇದೇನು ಡಿಸ್ಮಿಸ್ ಟು ರಿವರ್ಸ್ ಟು ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್ ಗ್ರಾಂಟೆಡ್. Call for records and issue notice. This matter on 8/12.
Yes.
27.
Nagaraj M.
Sir, I appear for the appellants.
Dismiss, confirm, not last time, not well.
Lord, suit for permanent injunction. And what has happened, my lord, during the trial, the plaintiff, after leading evidence, my lord, she has not subjected to cross-examination. Though she was present initially, it was closed, and thereafter application was filed and she was recalled. Thereafter, she did not appear, and since, my lord, there was no cross-examination, my lord, our evidence was not taken on record. My lord, the appellate court, my lord, though we sought for remand of the matter, court said, my lord, there is a cloud over the title of the plaintiff, and therefore, my lord, the suit for bare injunction is not maintainable. My lord, now my submission, my lord, that I may be permitted to, my lord, to file a comprehensive suit, and so that, my lord, I may.
ಅಷ್ಟೇ. That's what already observed. Anantala Sudhakar case apply ಮಾಡಿ.
Yes, my lord.
Then there is a cloud on the title, you can file a comprehensive suit ಅಂತ ಮಾಡಿದ್ದಾರೆ.
Yes, my lord, I may be permitted to go file a comprehensive suit. Para 24, 23 and 24.
ಯಾಕೆ ನೀವು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹೋಗ್ಲಿಲ್ಲ?
My lord, she was during that time, my lord, she was not keeping well, my lord. For a long time, she was not well anta. That was my instruction. And therefore, my lord.
Good. This matter is listed for admission, and I heard the counsel appearing to the appellant. This second appeal is filed against the concurrent finding. The factual matrix of case of the plaintiff before the trial court while seeking the relief of permanent injunction. It is contended that suit property is ancestral property of the plaintiff, and the same was acquired by his grandfather by name Sri Pujappa. He was in possession and enjoyment of the same, and he died leaving behind plaintiff's father by name Muninarayanappa. The father was in possession and enjoyment of the settled property, and during the lifetime of the said father and grandfather, they have never sold the suit property. The plaintiff succeeded to the suit property after the death of his father, and plaintiff is in exclusive possession of the suit property, and defendants have no right for the suit property, and defendant causing interference, and hence without any other alternative filed the suit for the relief of permanent injunction. The defendant appeared and filed the suit. The defendant appeared and filed the written statement. After receiving the suit summons, contending that the land bearing serial number 11 measuring 2 acres 34 guntas situated at Sambarugi the Kavalu village, Nandi Hogli, Chikballapur Taluk, belongs to one Nanjundaya, son of Venkatachalaya. He acquired the same under a grant. It got order dated 1984. Under the provisions of Village Office Abolition Act, the said Nanjundaya sold entire land in favor of MP Ramareddy on 3/10/1996. In turn, Ramareddy and his sons sold the land to an extent of 2 acres in favor of defendant under a sale deed dated 22/6/2000. All the revenue records stands in the name of the defendant, and the defendant is in possession and enjoyment of the suit property, and he is raising the crop. First of remaining extent of 34 guntas sold by MP Ramareddy in favor of Muni Krishnappa and Muniappa to an extent of 17 guntas each. First of the serial number 11 measuring 2 acre 34 guntas ported and assigned new number 11/1 to an extent of 34 guntas. Serial number 11/2 to an extent of 2 acres. Since the date of purchase, the defendant and aforesaid Muni Krishnappa and Muniappa are in possession and enjoyment of the respective properties. Further, prior to the purchase by the defendant and others from Ramareddy, the original owner Nanjundaya mortgaged the property to an extent of 34 guntas in favor of Muniappa and Doddan Narayanamma under registered mortgage date 14/3/1985. The defendant filed suit against Muniappa alias Pilla Jaggappa, Akkayamma, Manjunath and Mariappa in OS number 193 of 2005 for the relief of permanent injunction, and same was decreed. During the pendency of one suit, one TM Srinivasa and others have filed application to plead them as defendants, and the same was dismissed. After decree, the present defendant filed execution petition number 5 of 2008, accordingly obtained the direction to police for protection of the defendant with regarding scheduled property. The said order was challenged in MA 6 of 2008 and challenged the order passed by Tahsildar in HOA 3 of HR 3.27 of 1975. So 27 of 95. The said appeal was also dismissed. Others have filed WAP and the same also dismissed. They also filed an appeal before the Deputy Commissioner in HOA CR number 21 and 22 of 2010-11 against the present defendant and others. Same also dismissed. The suit of OS number 27 of 15 also contested and dismissed. Now the plaintiff, by instigating the above persons, filed the false suit and hence prayed the court to dismiss the same. The trial court, having considered both oral and documentary evidence, comes to the conclusion that plaintiff claims that property is a self-acquired property. But when he was examined, he did not subject for cross-examination and suit was dismissed. The same is challenged before the appellate court, and appellate court also, having considered the material and record, comes to the conclusion that when there is a dispute with regard to the title is concerned and taken note of the judgment of the apex court of Anantula Sudhakar's case and dismissed the appeal, and also an observation is made that PW1 did not tender for cross-examination, no value attached to the evidence of PW1. And trial judge rightly answered the same, and no grounds are made out. The counsel appearing to the appellant before this court would submit that the PW1 could not be able to tender for cross-examination before the trial court, and also when the relief is sought for remand the same to the trial court, and appellate court also confirmed the same, and counsel would submit that when there is an observation by the appellate court with regard to the title and cloud on the title, appellant oblique plaintiff may be permitted to file a comprehensive suit seeking the relief of declaration without considering the matter and merits, and in view of the said submission and also the observation made by the first appellate court pressing into the service of the judgment of Anantala Sudhakar case, it is appropriate to give liberty to the appellant to file a comprehensive suit. With this, full stop. With this observation, second appeal is disposed of.
Much.
28. We are Balraj.
For adjournment, my lord. Short accommodation may kindly be given because due to my illness, I could not able to address the arguments. The concurrent findings are there.
Fifth plaintiff is declared as absolute owner by virtue of registered sale deed dated 16/9/2003. If deed subsequent to the said sale deed.
First is a gifted, first is a sale deed, my lord, thereafter gifted.
ಅದನ್ನೇ ಹೇಳ್ತಾರೆ.
But contention of the plaintiff, she has not executed the GPA in favor of the first defendant. She has and to prove that, my lord, she has not entered into the witness box.
Both sale deeds are cancelled, sale deed as well as the gift deed.
And additional issues were framed at the time of arguments. No opportunity.
What is that additional issue?
Additional issues at page number, my lord. Page number 60.
The defendant proved that the fifth plaintiff executed an unregistered general power of attorney.
And affidavit by receipt of rupees 70,000 by handing over the
possession of suit property in favor of the first defendant. That they are the bona fide purchaser of the suit for value. Accordingly, the suit to be dismissed against them.
Additional issues framed at the time of passing the judgment, my lord. And
evidence available is already let the evidence.
There is no evidence at all, my lord. To prove the additional issue number 1, there is no evidence at all. And this is not the contention of the defendants also, or plaintiffs.
Nim contention ಏನು?
The fifth plaintiff had executed the GPA in favor of the first defendant.
ಆಯ್ತು, GPA produce ಮಾಡಿದ್ರಾ?
GPA produce ಆಗಿದೆ.
ಮಾಡಿದಿರಿ?
ಮಾಡಿದ್ದಾರೆ.
ಅದಕ್ಕೇನು ಫೈಂಡಿಂಗ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ನವರು?
ಫೈಂಡಿಂಗ್ಸ್ ನಾವು ಪ್ರೂವ್ ಮಾಡಬೇಕಾಗಿತ್ತು ಅಂತ ಹೇಳಿ ಅವರು ಹೇಳುದು.
ನೀವೇ ಪ್ರೂವ್ ಮಾಡಬೇಕು. ನೀವು GPA
the contention of the plaintiff, the first defendant forged the signature of the plaintiff and got the executed the stated in the name of the defendant 23.
Unregistered power of attorney ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ. And also affidavit was also executed by receiving an amount of 72,000 by handing over the possession of the scheduled property. ಅಂತ ನಿಮ್ಮ
Therefore, my lord, the additional issues framed at the time of
passing. Your defense,
yes, please. But additional
issues frame.
Additional issue frame ಮಾಡಿರತಕ್ಕಂತದ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡಬೇಕಾದ್ರೆ, but there is no opportunity.
After framing of the issues, the plaintiff were asked to prove the issues.
Additional issues framed at the time of passing the judgment. There was no opportunity, my lord.
Defendant GPA holder of defendants got examined as defendant number.
ಈ ಇಶ್ಯೂ ಪ್ರೂವ್ ಮಾಡ್ಲಿಕ್ಕೆ ನನಗೆ ಎವಿಡೆನ್ಸ್ ಕೊಡಬೇಕಾಗುತ್ತೆ.
ನೀವು DW 2 and 3
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಇಶ್ಯೂ ಫ್ರೇಮ್ ಮಾಡಿರತಕ್ಕಂತದ್ದು ಜಡ್ಜ್ಮೆಂಟ್ ಟೈಮ್ ಅಲ್ಲಿ.
ಸರಿ ರೀ, ನಿಮ್ ಡಿಫೆನ್ಸ್ ಅಂಡ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ
by defense is that the plaintiff number 5 executed the unregistered GPA and based on
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದಿರಲ್ವಾ?
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹೇಳಿಲ್ಲ ಅವರು, ಫೋರ್ಜರಿ ಮಾಡಿದ್ದಾರೆ.
ನಿಮ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ನೀವು ಪ್ಲೀಡ್ ಮಾಡಿದಿರಾ? ಇಲ್ಲ.
ಹೌದು, ಪ್ಲೀಡ್
ಮಾಡಿದಿರಿ. ಅದಕ್ಕೆ
ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಬಟ್ ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳ್ತಕ್ಕಂಥದ್ದು ಕ್ರಿಯೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ಬಟ್
ಅಲ್ಲ, ನೀವು ಏನೋ ಇಶ್ಯೂಸ್ ನ ಆಮೇಲೆ ಫ್ರೇಮ್ ಮಾಡಿದ್ರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಮಾಡುವಾಗ ಅಂದ್ರಲ್ಲ, ದಟ್ ಈಸ್ ಬಿಕಾಸ್ ಆಫ್ ಯುವರ್ ಡಿಫೆನ್ಸ್. But you have already laid an evidence in terms of your written statement.
ನಾನು ಈ ಇಶ್ಯೂ ಮೇಲೆ ಅಲ್ಲ, ಇದು ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮಾಡಿದೆ. ಶಾರ್ಟ್ ಅಕೌಂಟ್ ಮಾಡಿ ಎಲ್ಲಿ ಸರಿ ಇಲ್ಲ ಅಂತ ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ. ಅದರೊಳಗೆ ನಾವು ಯಾವಾಗಲೇ ಮಾಡ್ತೀವಿ.
So the appellant counsel seeks time on the ground of ill health. This matter on 5/12.
29.
Kindly have it on Monday, man.
Counsel, non-prosecution dismissal ಇಟ್ಟಿದ್ದೀವಿ.
Yes, yesterday, my lord, I have filed my NOC ವಕಾಲತ್.
ಆಯ್ತು, ನಾ ಹೇಳಿದೆ ಲಿಮಿಟೇಷನ್ ಅಂತ.
ಹೌದು, yes.
ಲಿಮಿಟೇಷನ್
Kindly have it on Monday.
ಏನ್ ಲಿಮಿಟೇಷನ್ ಏನ್ ರೀಸನ್ಸ್ ಕೊಟ್ಟಿದ್ದೀರಿ ಹೇಳಿ.
My lord, kindly have it on Monday.
ಆವಾಗಲೇ ಹೇಳಿದೀನಿ, ಮತ್ತೆ ಟೈಮ್ ಕೊಡಿ. ಕೌನ್ಸಿಲ್
I will not seek any further adjournment, my lord. Kindly have it on Monday.
ಇದೆ, ನಾನು ಓದಿದ್ದೀನಿ, ಹೇಳಿ ನೀವು. 3 years ಲಿಮಿಟೇಷನ್ ಇದೆ ಫೈಲಿಂಗ್ ಆಫ್ ದಿ ಅಪೀಲ್.
Yesterday I filed my ವಕಾಲತ್, man. That is the reason.
ವಕಾಲತ್ ಹಾಕಿ.
As last chance, my lord, kindly have it on Monday.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿಲ್ಲ, ಲಿಮಿಟೇಷನ್ ಮೇಲೆ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು.
It is
ಬೆಳಗ್ಗೆಲ್ಲೂ ಕೂಡ ಹೇಳಿದೆ. Now also I am reiterating the same.
Agreement. Kindly have it on Monday, my lord. I will not seek further adjournment.
Para 13 ಹೋಗಿ reasoning ಕೊಟ್ರದ್ first appellate court now.
I have to go. I have also engaged my lord services of
Considering the
senior counsel,
material
my lord.
services on record in OS number 230 of 2013, the trial court was decreed the suit and granted decree in plaintiff so and so so and so. It appears that appellant has filed the present appeal after finality of the suit before the trial court. Moreover, no satisfactory grounds are shown to condone the delay. Even there is no surrounding supporting evidence to believe the appellant. At this stage, it is relevant to refer the decision of the so and so where a case has been presented in the court beyond limitation, the appellate has to explain the court as to what was the sufficient cause, which means an adequate and enough reason which prevented him to approach the court within limitation. Negligent for want of bona fide as so and so so and so. No court should be justified in condoning such an inordinate delay by imposing any condition whatsoever. The application to is to be decided only within the parameters laid down by the principle laid down in the judgment of the so and so. No sufficient cause is shown. ಅಷ್ಟೇ. In the present case on hand, there is a delay of 5 years, 2 months, 10 days. The only contention raised by the appellant was that he was not feeling well, but no documents have been produced before this court. Five years, ಮತ್ತೆ delay ಆಗಿದೆ ಕೊರೋನಾ ಪ್ರೆಸಿಡೆಂಟ್ ಸರ್ವಿಸ್.
I have not gone through the papers, my lord. Kindly have it on Monday, my lord, and Monday I'll address my lord.
ಕೌನ್ಸಿಲ್ ಎಷ್ಟು ಸರಿ ಹೇಳಿದ್ರಿ ನಿಮಗೆ?
ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ I have also engaged the services of senior counsel, my lord.
Once you have engaged the senior counsel, he must be present before the court.
My lord, yesterday brief was handed over.
Maybe.
Even he needs some breathing time, my lord, to prepare for arguments. Kindly have it on Monday. I'm asking for only 3 days, my lord, not even asking for a longer date.
Judgment 2016. Appeal in 21. 5 years. Third, this matter is listed for admission, and in the previous date of hearing, this court made an observation that matter was heard in the morning session, and when the learned counsel for the appellant was unable to convince this court, directed him to bring the senior counsel. Both junior counsel and senior counsel are absent in the afternoon. However, in the ends of justice, one more opportunity is given. If the learned counsel for the appellant doesn't appear on the next date of hearing, the appeal will be dismissed. Today, the counsel Sri
Rupesh Kumar. Rupesh Kumar.
Rupesh Kumar submits that he had filed wakalat ಯಾವಾಗ ಹಾಕಿದ್ರಿ?
ನಿನ್ನೆ ಹಾಕಿದ್ರು.
Yesterday on behalf of the appellant with NOC and seeks time. In the morning session itself, this court made it clear that there was an inordinate delay when the appeal was filed before the first appellate court. That delay of more than 5 years, and excluding the period of COVID, it was more than 3 years. And submit his argument with regard to the delay is concerned. Even when the matter is reached at 12:56 also, the counsel, except paying the time, even not bother to look into the reasons of delay is concerned, and again seeks time on the ground that senior counsel is engaged in the matter, and seeks time, and hence on cost of rupees 5,000 list this matter on 5/12. Cost is payable within 1 week from today at registry.
30. We are Vijay Prakash.
ಏನೆಲ್ಲ ಬರೀ ನಾಟ್ ವೆಲ್ಲು ಇವೆ.
Appear for the appellant, my lord. Concurrent finding, dependent appeal, my lord. Now is ready, 2 sisters ready to relinquish it, my lord. Kindly refer to mediation, my lord. Partition suit decreed and appellate is confirmed, my lord.
Decreed 4/8 share ಅನ್ನ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇಬ್ರು ಸಿಸ್ಟರ್ ಸ್ಟಡಿ ಇದಾರೆ ಅಂತ ಅದ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಮೇಲೆ ಇಬ್ರೇನೋ ಇಬ್ರು ಸಿಸ್ಟರ್ ಸ್ಟಡಿ ಇದಾರೆ ರಿಲಿಂಕ್ವಿಶ್ ಡೀಡ್ ಮುಗಿಯಕ್ಕೆ.
ರಿಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಡೀಡ್ ಬರ್ಕೊಡಕ್ಕ.
ಬರ್ತಂತೆ. ಬಟ್ ಮೀಡಿಯೇಷನ್ ಮೇಲೆ ಒಂದ್ ಸಿಸ್ಟರ್ ಮಾತ್ರ ಡಿನೈ ಮಾಡ್ತಾ ಇದಾರೆ. ಅವ್ರಿಗೂ
ನೀವ್ಯಾರಿಗೂ ಅಪೇರ್ ಆಗೋದು?
1 to 4 ಮೇಲೆ.
1 to 4 ಎಲ್ಲರಿಗೂ ಅಪೇರ್ ಆಗ್ತೀರಾ?
1 to 4 ಮಾತ್ರ.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಚಾನ್ಸಸ್ ಇದೆಯಾ?
ಇಲ್ಲ ನನ್ಗೇನು ಆತರ ಇನ್ಸ್ಟ್ರಕ್ಷನ್
ಇಲ್ಲ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
ರೆಡಿ ಇದಾರೆ ಅಂತ
ರೆಡಿ ಅವ್ರು ಇಲ್ಲ ಅಂತ ಅಂದ್ಮೇಲೆ ನೀವೇನ್ ರೆಡಿ ಇದೆ ಅಂತ ಹೇಳಿ
ಸೆಕ್ಷನ್ ಇಲ್ಲ
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಕೌನ್ಸಿಲ್.
ರೆಫರ್ ಟು ಮೀಡಿಯೇಷನ್ ಮೇಲೆ ಸೆಟಲ್ ದಿ ಮ್ಯಾಟರ್ ಮೇಲೆ
ಹೇಳಿದ್ನಲ್ರಿ ಮೀಡಿಯೇಷನ್ ಯಾವಾಗ ಅಂದ್ರೆ ಇಬ್ರು ಸೈಡ್ ಒಪ್ಪಿಗೆ ಇದ್ರೆ ಮಾತ್ರ. ಕೇಸಲ್ಲಿ ಏನಿಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ ನೀವು ಹೇಳಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ನಿಮ್ಮ ಕಂಟೆನ್ಷನ್ ಏನಿದೆ 16 ಹೇಳಿ ಬರೆಯೋಣ ಅಂದ್ರೆ ನೀವು ಅದಕ್ಕೂ ರೆಡಿ ಇಲ್ಲ.
2001 ಮೇಲೆ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಫಾದರ್ ಆಫ್ ವಿಲ್ ಮೇಲೆ ಇನ್ ಫೇವರ್ ಆಫ್ ಡಿಪೆಂಡ್ ನಂಬರ್ 1 will but what court not considered my exhibit P24 my lad will my lad
ಆಯ್ತು
will examine the attesting witness and witness my exhibit
that is your defense
my lad will not consider the both court my lad both court also not consider my examine the DW 3 and 4 my lad
additional issue number 7 was answered as negative ಹೌದಾ?
Additional issue my lord mother against the second will my lord first will item number 1 father executed will item number 2 mother also executed will in favor of the first dependent my lord already item number 2 is sold in
issue number 3 and 7 both are answered negative re
my lord will not proved my lord will is not proved and worthy both my lord exam the
both the will
opportunity ಮೇಲೆ kindly refer to mediation ಮೇಲೆ settle the ಇಬ್ಬರು ಸಿಸ್ಟರ್ ಸ್ಟಡಿ ಇದಾರೆ ಅಂತ ಸೇರಿ
ಹೇಳಿದ್ನಲ್ರಿ ಅವ್ರ ಅದರ್ ಸೈಡ್ ಡಿನೈ ಮಾಡ್ತಾ ಇದಾರೆ ನೀವು ಮತ್ತೇನಿದು
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎನಿ ಡೇಟ್ ಮೇಲೆ
ಮತ್ತೆ ಡೇಟ್ ಕೊಡ್ಬೇಕು ನೋ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್
ಪಾರ್ಟಿನೇ ಬಂದಿಲ್ಲ ಇಬ್ಬರು ಸಿಸ್ಟರ್ಸ್
issue number 3 and 7
ಫಸ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಮೇಲೆ
ಅದು unregistered will
my lord my father is executed unregistered will in favor 2001 my lord father died in 2002 mother also executed item number 2 in favor of the will 2008 self
Page 25 ಅಲ್ಲಿ ಮಾಡಿದಾರೆ ನೋಡಿ discussion. Trial court ಅಲ್ಲಿ in detail. Even son is not able to identify the signature of the father during the course of evidence. ಒಂದು ರಿಜಿಸ್ಟರ್ಡ್ ವಿಲ್ ಇನ್ನೊಂದು ಅನ್ರಿಜಿಸ್ಟರ್ಡ್ ವಿಲ್.
Recently, my 2002, my execute father registered will all equal say 5 members, 1/5 say. First will without cancellation, my lord, revocation. Second will execute father.
ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ಓರಲಿ ಗಿಫ್ಟೆಡ್ ಅಂತಾರೆ. ಇಲ್ಲಿ ವಿಲ್ ಅಂತಾರೆ.
ಅಲ್ಲ ಪ್ಲಾಂಟಿಫ್ ಒಪ್ಕೊಂತಾರೆ.
ಪ್ಯಾರಾ 20 ಪೇಜ್ ನಂಬರ್ ಇಂಟರ್ನಲ್ ಪೇಜ್ ನಂಬರ್ 12 ಅಲ್ಲಿ ಥರ್ಡ್ ಲೈನ್ ಅಲ್ಲಿ the learned counsel dependent one suggested PW1 that parents have orally gifted the suit property ಅಂತಾರೆ. ಇಲ್ಲಿ ವಿಲ್ ಅಂತಾರೆ. which is contrary to his defense ಅಂತ. ಅದು ಬಿಲ್ಲುದು ಅಷ್ಟೇ ಅಡಿಷನಲ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ 2023 ಅಲ್ಲಿ ಹಾಕುವಾಗ ಆ ಬಿಲ್ಲು ಡಿಫೆನ್ಸ್ ತಗೊಂಡ್ರು. ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ 2009 ಅಲ್ಲಿ ಹಾಕ್ತಾರೆ, ಆಗ್ಲೂ ಬಿಲ್ ಬಗ್ಗೆ ಏನು ಹೇಳೋದಿಲ್ಲ. ಈವನ್ 2018 ಅಲ್ಲಿ ಹಾಕ್ತಾರೆ, ಆಗ್ಲೂ ಹೇಳೋದಿಲ್ಲ.
ಏನಿಲ್ಲ, nothing.
ಪ್ಯಾರಾ 34 ಅಲ್ಲೂ ಹೇಳ್ತಾರೆ, ಇಟ್ ವಾಸ್ ಸಜೆಸ್ಟೆಡ್ ಟು PW1 that our parents have gifted the suit properties to oral gift ಅಂತಾರೆ in favor of defendant number 1 ಅಂತಾರೆ.
Third, this matter is listed for admission. I heard the counsel appearing to the appellant and also the counsel for the respondent. The factual matrix of case of plaintiffs before the trial court while seeking the relief of partition and separate possession. It is contended that the plaintiffs and the first defendant are the children of late N. Nanjundappa and Srimati Puttrajamma, who is the second defendant herein. The plaintiffs and first defendant are in joint possession and enjoyment of the plain scheduled properties as co-partners, and they have inherited the property from their father. The plain scheduled property was acquired by N. Nanjundappa, the father of the plaintiff and first defendant, through a registered sale deed in the year 1972-73. Under the out of the joint family nucleus, and he was in possession and enjoyment of the said property along with his children during his lifetime. The entries in revenue records were also accepted in favor of Nanjundappa by virtue of the sale deed. During his last days, N. Nanjundappa executed a registered will dated 26/6/2002 in favor of the plaintiffs and first defendant, allotting 1/5 share each to his children. The will is duly registered and Nanjundappa is no more. After his death, plaintiffs and first defendant have succeeded the property and they are in joint possession. It is also the case of the plaintiff that the property bearing Janjar number 424, measuring to an extent of east to west 30 feet, north to south 40 feet, is belongs to Srimati Putra Jamma, who is the mother of the plaintiffs and defendant. After her death, the plaintiffs and defendant are having equal right. Title interest over the scheduled property. They are entitled for a share. However, the defendant colluding with the Panchayat authority without consent of the plaintiffs, defendant transferred the kata in his name without having any legal right. So defendant number 1, after getting the kata in his name, he alienated the schedule item number 2 in favor of proposed defendant without having any legal right. Were registered sale dated 9/4/2018. And plaintiffs are also having a right over the schedule item number 2 property. And alleged sale deed executed by defendant number 1 in favor of defendant number 3 is not binding upon the plaintiffs. In spite of request was made for amicable partition, did not come forward to give share and refused to give share to the plaintiffs. And hence suit is filed for the relief of partition. The defendant number 1 filed written statement denying the entire averments of the plaintiff. And however admitted the relationship between the parties. Denied the joint possession and they are the co-partners. And contended that Nanjundappa has executed an unregistered will in favor of defendant number 1 and 2 while he was in sound state of mind. And as a result, he became the absolute owner of the property. And also the will was executed on 28/2/2001 in favor of defendant number 1 and 2. As per the will, kata and mutation was obtained in their name. The defendant number 2 also executed a will in favor of the defendant number 1 on 28/3/2008. And defendant number 2 is also no more. The item number 1 was also continued in the name of defendant number 1 and he and his family members are in peaceful possession and enjoyment of the property. With respect to the item number 2, claims that the same is the self-acquired property of defendant number 2 and defendant number 2 was acquired the same under registered sale deed. And in view of the pleading of will, the trial court framed the issues and also the pleadings of the plaintiff framed the issue number 1 and 2. Issue number 1 and the first defendant, whether he proves that scheduled properties are self-acquired properties of his father Nanjundappa, and also the execution of will by Nanjundappa and also the mother. That is particularly issue number 3 and 7. And so also the sale deed. And trial court, having considered both oral and documentary evidence, comes to the conclusion that plaintiffs have proved the social properties are ancestral and joint family properties partly, and also first defendant proves that social properties are self-purport properties of Nanjundappa as contended by defendant number 1, but answered the issue number 3 and 7 as negative, that plaintiffs defendants have not proved the will executed by the father as well as the mother, and granted the relief of partition. A 4/5 share in respect of item number 1 and 2 properties. Being agreed by the same, an appeal is filed in RA number 97 of 23. And the appellate court also having reassessed both oral and documentary evidence in keeping the grounds which have been urged, formulated the point and answered the same as affirmative in coming to the conclusion that trial judge has not committed any error, and taken note of the material on record, particularly defendant number 1 never disclosed about the exhibit D4 will till failing of IA number 5 on 9/12/2022. And when he has not disclosed the exhibit D24 will deed for such a long time, it creates the doubt. And so also in respect of other will, also comes to the conclusion that both the wills are not proved by the defendant, and trial court taken note of the evidence available on record and justified in allotting equal share to the plaintiffs and defendant number 1 in the suit properties. The sale made during the pendency of restoration of petition also will not bind the rights of the plaintiffs in any manner. Being agreed by the concurrent finding, present second appeal is filed before this court. The main contention of the counsel appearing to the appellant in this second appeal is that both the courts have committed an error in not considering the will which are placed before the court, and no existence of joint family, and properties are also not the joint family properties. And item number 2 of the suit schedule property being a Sridhana property of Puttarajamma, the said property being bequeathed by her in favor of defendant number 1 as per exhibit D4. And later the said property was being sold to defendant number 3. And in spite of both the exhibit D4 and D24 are proved in terms of section 63 of the Indian Succession Act and also section 68 and 69 of Indian Evidence Act, both the courts ought not to have disbelieved the document exhibit D4 and 24. And hence this court has to admit and frame substantive question of law. Per contra, the counsel appearing with respondent would vehemently contend that both the courts taken note of the evidence available on record, though PW2 not supported the case of the plaintiff, but deposed that on the date of execution of registered will dated 4/7/2002, which is marked as exhibit P28, says that he was in hurry, and at that time deceased and Nanjundappa asked him to affix his signature over the same, and he affixed his signature over the same forcibly. And also taken note of evidence of PW2. Yes, fixed his signature, but he did so in hurry at the request of deceased and Nanjundappa. PW did not deny his signature or registered sale deed marked at exhibit P28. Sale deed ಅಲ್ಲ ಅದು will madam. Will dated 26/6/2002. And other will is unregistered will. And DW1 also categorically admitted that father had purchased the property in the name of the mother. And also transfer of kata in the name of the mother. And also kata was transferred. Poti Varsu. And also taken note of the fact that property was purchased in the name of the mother by the father out of the hotel business. And also the mother was housewife. And hence disbelieved the contention that mother had executed the will. And comes to the conclusion that suit item number 2, open plot, is not the exclusive property of the deceased mother. And though plaintiffs have set up their case that suit properties are joint family properties, but at the time of acquisition of item number 1, landed property through registered sale deed dated 4/5/1972, marked at Exhibit P3, the plaintiffs were still minors as per marks cards marked at Exhibit T25 to Exhibit P29. And no joint labor could be expected from minor at the time of acquisition referred to above. And hence answered the point number 1 as partly affirmative, but they are not the joint family properties of the plaintiff, but defendant number 1. And the properties are joint family properties and not the ancestral properties as contended. And taking into note of the material available on record, granted the relief since the plaintiffs are the sisters of defendant number 1 alla?
1 my lord.
Defendant number 1. The first appellate court also having reassessed the material available on record, taken note of the will which was propounded by defendant number 1, which came into suspicious circumstances. And taken note of evidence of DW1. At one stage has raised defense that her parents have orally gifted the suit properties, and later on changed his defense that they have executed the will exhibit D4 in his favor, and hence comes to the conclusion that no hesitation to hold that defendant number 1 has failed to prove exhibit D4 and exhibit D24 by means of acceptable evidence. When both the courts have taken note of the evidence available on record, both oral and documentary evidence, and comes to the conclusion that will propounded was not proved by acceptable evidence, and the plaintiffs being the legal heirs of Nanjundappa, and also when there is a clear admission on the part of the witnesses that father had purchased the property in the name of the mother, and there is no any interstate document by the father Nanjundappa and also the mother Putrajamma. Both the trial court as well as the appellate court not committed any error in granting the share, and hence I do not find any ground to admit and frame substantive question of law as contended by the counsel for the appellant, and not a case for invoking section 100. Next.
31. It's Devendrappa.
It's in this matter, Lordships. This is the defendant's appeal, my Lordships. The suit was filed by the respondents for partition and separate possession. The appellants filed the wakalat before the trial court and filed the written statement, but they did not contest the matter and cross-examine the plaintiffs nor adduced any arguments before the trial court, and the suit was decreed in favor of the respondents 1 and 2, my Lordships. Against that, they preferred an appeal before the appellate court, my Lordships.
But there with delay of 1,257
days, my Lordships. The appellate court has held that since no reasons have been assigned for the delay in continuation of the appeal, hence the appeal has been dismissed, my Lordships. Lordships, the appellants have a good case on merits because, my lordships, before the trial court, they did not produce any documents to prove that they are, because since 30 to 40 years, they are in possession and they are maintaining the suit schedule properties.
Maintaining, but suit is only for the relief of partition and separate
Yes, my
possession, madam.
lordships. The respondents are the sisters of the appellants, my lordships. They were given in marriages long back 30 to 40 years, and they have also sold one property wherein the appellants had sold the property and given the fruits of that sale, my lordships, to the respondents 1 and 2, my lordships. But they have not produced any documents before the trial court.
ಏನು ಇಲ್ಲ madam.
Opportunity is given, my lordships.
Told. Heard the appellant counsel, this matter is listed for admission. This appeal is filed against this concurrent finding. The factual matters of case of the plaintiffs before the trial court that they are the daughters of one late Sri A. Basappa. The mother of the plaintiffs was one Srimati Veeranma, one Sri Nagendra Chari, and the defendant number 6 to 8 are the brothers of the plaintiffs. The said Nagendra Chari died intestate, and first defendant is his wife, and the defendant number 2 to 5 are his children. The mother of the plaintiffs died long back. The father of the plaintiffs, Sri Basappa, died about 25 years ago, leaving behind the plaintiffs and the defendant number 6 to 8 and a son, Sri Nagendra Chari, as his legal representatives to succeed his estate. Brother of the plaintiffs and husband of the first defendant, Nagendra Chari, died intestate about 8 years back, leaving behind 1 to 5 as his legal representatives. मतलब ಬಂತದು. The Nagendra Chari had an unmarried daughter, Kumari Dakshanamma, who also died about 3-4 years back. And social properties are the ancestral joint family properties of the plaintiffs and defendants. There was no any partition, and hence plaintiffs are entitled for 2/6 share over the social properties. Defendants have filed written statement, that is 1, 4, 6 to 8, but defendant number 2, 3 and 5 remained absent. They were placed ex parte. But main contention that the plaintiffs have come up with a false claim. They are not entitled for any share. It also contended that family property were partitioned about 30 to 40 years ago, and the parties are living separately. The plaintiffs had directed the defendants to alienate survey number 164/3A in favor of A. Parameshwarappa, and they have received the entire sale consideration amount, and they would not claim any share in the property, and hence prayed the court to dismiss the suit. The trial court, having considered both oral and documentary evidence available on record, comes to the conclusion that plaintiffs have proved the case, since the defendant, though filed the written statement, they did not choose to contest the matter, either by cross-examining or leading any defense evidence. The same is challenged before the appellate court with a delay of 1,257 days delay. And appellate court, having considered the reasons mentioned in the application and affidavit, taken note of defendants have not led any evidence before the trial court except filing of written statement, and also taken note of the relationship between the parties, and delay also not properly explained. And also the same is not substantiated by placing any material on record. And comes to the conclusion that no sufficient cause is shown. And hence dismiss the application, consequently dismiss the appeal, and hence present second appeal is filed before this court. The main contention of the counsel appearing to the appellant that the trial court committed an error in granting the relief without examining the material on record, and first appellate court also committed an error in dismissing the application on the ground of delay and not considered the matter on merits. And this court can admit the appeal and give an opportunity to the appellants to contest the matter. Having heard the appellant counsel and also the grounds which have been urged in the second appeal, and though contend that first appellate court committed an error in dismissing the application, and in order to substantiate the contention with regard to the delays concerned, except examining one of the witness as PW1 and producing the document of judgment and decree passed in OS number 138 of 2009, nothing is placed on record to substantiate their contention. And hence, appellate court comes to the conclusion that no sufficient reasons are given and explanation also not given, and in order to consider the delay of 1,257 days, the same is not explained, and each day delay ought to have been explained. The apex court also recently in the judgment of Shivamma case also categorically held that the appellant counsel first has to establish the sufficient cause with regard to the delay, and matter cannot be considered on merits, and first appellant has to satisfy with regard to the delay is concerned. And in the case on hand, when there is an inordinate delay of 1,257 days, and the same is not substantiated by placing any material on record, question of condoning the delay doesn't arise. And rightly, the appellate court dismissed the same, and hence I do not find any ground to admit and frame substantive question of law when the each day delay has not been explained and sufficient cause is shown, and hence no ground to invoke section 100 of CPC. In view of the discussions made up, I pass the following order. Second appeal is dismissed.
32, Sudhindra SC.
Appearing for the appellant, my lord. My lord, kindly have it tomorrow, my lord. Senior is held up in another court hall.
Let him be there. You assist the court.
My lord, kindly have it tomorrow, my lord.
No, madam, no adjournment.
Is held up in another court hall, my
Date
lord.
given matter, madam, or otherwise I will pass it over. He is held up in other court is not a ground to grant the adjournment. Shall I pass it over?
Pass over, my lord.
Yes.
33, Sampati.
Lord's appellant's appeal. Concurrent finding, my lords, the suit has been dismissed. Suo motu, my lords, by the trial court, taking upon itself, my lords, to find out whether the suit is maintainable filed by the plaintiff or not. My lords, may kindly take page 52, my lords, is the order, my lords. 51, my lords, is the cause title. Lordship sees that an application under order 39 rule 1 was heard, and my lords, after hearing the application, orders on IA number 1 and suo motu orders on order 7 rule 11 A and D of CPC, the court passes an order. Now, my lords, it formulates questions, and my lords may find at page 55, my lords, the questions that is formulated for a determination, where, my lords, the point number 4 is
No application is filed under
No, my
order
lords,
7
no
to 11
application
A
was-
and D.
No, my lords, no application was filed.
Whether defendants appeared or not.
No, my lords, defendant appeared, they filed written statement. They took up a contention, my lords, that the suit is not maintainable by the plaintiff. And my lords, the plaintiff does not have the locus standi to file the suit. My lords, the trial court, my lords, without hearing the plaintiff on the issue, whether, my lords, the suit is maintainable or not, while passing an order under Order 39 Rule 1 and 2, also decides that the suit is not maintainable, my lords, and dismisses it.
First appellate court also concurred the same.
Concurred, my lords, concurred, my lords.
Issue notice and call for records.
My lords, they have appeared.
Already there layer.
They have appeared, my lords.
MC.
They have appeared.
ಇಲ್ಲ ಅವರು ಕೊಡಿ.
My lords, can I just pass on the plaint, my lords?
ಬೇಡ records ಬಂದ್ಬಿಡ್ಲಿ ಯಾಕೆ ಸುಮ್ಮನೆ.
My lords, may kindly see, my lords, the prayer that was sought is for declaring that the plaintiff is the absolute owner of the suit schedule property bearing survey number 1/9, measuring about 1 acre and 4 guntas situated at so and so, declaring that the registered sale deed executed by the plaintiff's husband, Siddha Gangaya, and his mother, Lakshmamma, in favor of so and so, is dated so and so, is not. Then the third prayer, my lords, is restraining the defendant, their henchmen, their agents, or anybody authorized by them from interfering with the full possession and enjoyment of the suit schedule property. Now, my lords, the plaintiff, my lords, approached the court on the fact, my lords, that the sale deed was executed in favor of the father of the defendant in respect of property bearing survey number 1/4 and not in respect of survey number 1/9. Both survey number, my lords, 1/4 and 1/9 belong to the ancestors of the plaintiff, my lords. That's not in dispute. Then, my lords, the husband of the plaintiff also, my lords, died in the year 2012, that is prior to the institution of the suit. Now, my lords, the trial court says that the relief of declaration must have been sought by my mother-in-law or by my husband. Since they are not parties to the suit, you have no locus to file the suit.
Whether mother was alive, mother-in-law was alive?
Mother-in-law is alive, my lords, even now. My husband is
Oh,
not
even
alive.
now also?
Yes. My husband is not alive, my lords. My husband died, my lords, in 2012. Now, my lords, the observation of the trial court is, if the husband was alive, he must have challenged it. Now, my lords, it also says that under section 8, my lords, the property could have been devolved upon the plaintiff. Since the husband is alive, it has dismissed. May I just take your lordship to that portion of the observation, my lords?
ಅದರ್ ಸೈಡ್ ಇಲ್ಲ ಅಲ್ಲ ಈಗ.
Any date.
ಅಡ್ಮಿಟ್ ಮಾಡೋಣ ಅಷ್ಟೇ ತಗೊಳ್ಳಿ. ಆರ್ಡ್ ದಿ ಅಪ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ ಅಂಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಬೇರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದಾರಾ?
Sole respondent.
Sole respondent. And counsel for the cavator is absent. The counsel appearing for the appellant brought to notice of this court that the trial court, without any application under Order 7 Rule 11 A and D, while disposing of the application filed under Order 39 Rule 1 and 2, comes to the conclusion that no cause of action and the same is barred by limitation. And also submits that with regard to the cause of action and barred by limitation is concerned, no opportunity was given by the trial court while pressing into the service of Order 7 Rule 11 A and D. And the same is also a suo motu order. Having considered the submission of the appellant counsel and also on perusal of the order passed by the trial court, and the same is also confirmed by the appellate court, and matter requires reconsideration. Admit whether the courts below committed an error in invoking Order 7 Rule 11 A and D without any application on the part of the defendants, and committed an error in coming to the conclusion that no cause of action and the same is barred by limitation. That is the only.
One more substantial question.
Yeah,
my lords, what happens, my lords? There are 3 reliefs. Now, my lords, even suppose, my lords, assuming one of the reliefs, my lords, have no locus. My lords, as regards the possession is concerned, my lords, I have said I am in possession. Entire plaint, my lords, I say I am in possession. My lords, there is another relief, my lords, that's why I read the relief. To say that, my lords, I am.
ಸಂಬಂಧಪಟ್ಟಂತೆ ಈಗ ನಾವು the trial court only considered Order 7 Rule 11 A and D.
My lords, what am I?
If that order goes, automatically the relief what you have sought, that will be considered by the trial court. That's all.
My lords, my only
Second substantive question of law ಏನು according to you?
If suppose there are several reliefs, if one of the relief is maintainable, then the suit cannot be dismissed, my lords. My lord, assuming my lords what?
ಆಯ್ತ್ರಿ ಆರ್ಡರ್ 7 ರೂಲ್ 11
ಅಲ್ಲ, ಅಲ್ಲ.
ಇನ್ವೋಕ್ ಮಾಡಿರೋದೇ ಸರಿ ಇಲ್ಲ ಅಂತಂದ್ರೆ.
Correct, correct. Yes, ಸರಿ ಇಲ್ಲ, but I thought my lords.
ಅಷ್ಟೇ, that is the only
ಆಗ್ಬೋದು.
substantive question of law.
There's one application my lords for injunction filed.
ಏನು?
Not to dispossess ಅಂತ ಅಷ್ಟೇ.
ನಾಟ್ ಟು ಡಿಸ್ಪೋಸೆಸ್ ಸರ್.
ಹೌದು.
ನಿಮ್ಗೆ ಏನಾದ್ರು ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ ಆರ್ಡರ್ ಇತ್ತಾ?
ಇಲ್ಲ.
ಇಲ್ಲ. ಮತ್ತೆ ನೋಡಿ, ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಅಂಡ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಫಾರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಆನ್ 8/12. ರಿಮೈನಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ at 2:30.
Number 49, my lord.
Serial number 34.
34 ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ಇರೋದು.
Madam, ಡಿಲೇ ಕಂಡನ್ ಆಗಿದೆ ಸೀನಿಯರಿಗೆ.
ಏನ್ ಡಿಲೇ ಕಂಡೌನ್ ಆಗಿದೆ ಮೇಡಮ್? ಯಾರು ಕಂಡೌನ್ ಮಾಡಿದ್ದಾರೆ?
ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತು.
ಯಾವ ಕಂಡೌನ್ ಇಲ್ಲ ಮೇಡಮ್, ಇವತ್ತು ಫೈಲ್ ಮಾಡಿರೋದು ಇವತ್ತಿಗೆ ಅಂತ ಅಲಾಂಗ್ ವಿತ್ ಐಎ ಅಂತ ಇವತ್ತಿಗೆ ಹಾಕಿರೋದು.
ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಾಗ
ಅಡ್ಮಿಷನ್ ಅಂತ ಪೋಸ್ಟ್ ದಿ ಮ್ಯಾಟರ್ ಫಾರ್ ಅಡ್ಮಿಷನ್ ಅಂತ ಅಷ್ಟೇ. ನಾಟ್ ಜಡ್ಜ್ಮೆಂಟ್. ನೆಕ್ಸ್ಟ್ ಹೇಳಿ.
ಸೀನಿಯರಿಗೆ ಥ್ರೋಟ್ ಇನ್ಫೆಕ್ಷನ್ ಆಗಿದೆ ಮಲ್ಲಣ್ಣ.
ಆಯ್ತು, ನೀವು ಜೂನಿಯರ್ ಇದಾರಲ್ಲ ಸಾಕು. ಸೀನಿಯರಿಗೆ ಥ್ರೋಟ್ ಇನ್ಫೆಕ್ಷನ್ ಅಲ್ವಾ? ಸೀನಿಯರ್ ಇಸ್ ಆಲ್ ರೈಟ್, ಜೂನಿಯರ್ ಇಸ್ ಆಲ್ ರೈಟ್. ಅಸಿಸ್ಟ್ ದಿ ಕೋರ್ಟ್ ಕನ್ಕರೆಂಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ಹೇಳಿ.
49 final hearing.
49 ಫೈನಲ್ ಹಿಯರಿಂಗ್.
Final hearing.
ಹೇಳಿ ಏನು?
Kind of one adjournment may ba.
ನೀವ್ ಯಾರಿಗೆ?
I am for the respondents. And also I'm intimated.
ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿದಿರಾ?
ಹೇಳಿದೆ, ಬಂದಿದೆ.
ತಗೊಳ್ಳಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೌನ್ಸಿಲ್ seeks time and appellant counsel says no objection. List this matter on 8/12.
Problem.
Serial number 54. Serious. Short accommodation 54. Appellant counsel.
ಯಾವುದು?
Serial number 54.
54 ಏನಕ್ಕಿದೆ?
Final hearing.
ಅದರ್ ಸೈಡ್ ಯಾರು?
ನಾನು ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ಅಪ್ಲೆಂಟ್ ಕೌನ್ಸಿಲ್ ಸರ್ ಹೇಳಿ.
ನೀವು ಅಪಲೆಂಟ್ಗ? ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ಗೆಲ್ಲ ಗ್ರೌಂಡ್ ಇಲ್ಲ, ಎಲ್ಲಾರ್ಗೂ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್. ಏನ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಹೇಳಿ?
ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಷನ್.
ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಏನ್ ಹೇಳ್ರಿ?
ಏನ್ ತೊಂದ್ರೆ?
ನೋ ಗ್ರೌಂಡ್ ಫಾರ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್.
ಅವೆಲ್ಲ ಹ್ಮ್. ಬೆಳಿಗ್ಗೆಯಿಂದ 25 ಇದೆಲ್ಲ 25 ಹ? ಆಗಿದೆ ಸರ್, ಬೆಳಿಗ್ಗೆನೇ ಆಯ್ತು. ರೆಫರ್ ಟು ಲೋಕದಲ್ಲ ಇರೋದದು. ಹಾ, ಬೆಳಿಗ್ಗೆ 13-12. 13-12 ಬಿಫೋರ್ ಲೋಕದಲ್ಲ.
ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಆಗ್ತದೆ. ಸೀರಿಯಲ್ ನಂಬರ್ 12 ಅಲ್ಲಿ ಕಾಂಪ್ರಮೈಸ್ ಪಿಟಿಷನ್ ಪಾರ್ಟೀಸ್ ಇದೆ.
ಮಾಡೋಣ ಆಮೇಲೆ 2:30 ಆದ್ಮೇಲೆ ಮಾಡೋಣ.
ಪಾರ್ಟೀಸ್ ಇದ್ದಾರೆ. ಪಾರ್ಟೀಸ್ ಏಜ್ಡ್ ಇದ್ದಾರೆ.
2:30 ಮ್ಯಾಟರ್ಸ್ ಇದೆ ರೀ, ಅದಾದ ತಕ್ಷಣ ತಗೊಳ್ತೀನಿ
ಪ್ಲೀಸ್.
ಹಾ,
List 1, orders at 2:30, 64. Chidambara Swarup TP.
For petitioner, your lordships, this is a regular bail petition, your lordships. Totally 2 accused persons are there in the charge sheet. This petitioner is the accused number 1, your lordships. Offences are under section 302 of IPC. This petitioner was arrested on 1/2/2020, your lordships. As of today is in custody for 5 years and 9 months, your lordships. The accused number 2 obtained the bail before the charge sheet in the year 2020 only. This particular petitioner also had approached. However, your lordship was pleased to reject the same, your lordships. Now the rejected bail order can be perused, your lordships, in my additional documents filed on 21 July 2025, last 4 pages, your lordships. If I may be permitted, your lordships, I will read the operative.
First you read the earlier order.
Please, your lordships.
Para 6.
Paragraph. Having heard the respective counsel appearing for the parties and also on perusal of the material on record, it discloses that on 29/1/2020 at about 10:20 p.m. when accused number 2 and the deceased were talking by smoking, at that time accused number 1 came in auto with a machete with an intention to take away the life of the deceased and inflicted injury on the deceased and also driven the auto on him, and again he inflicted injury with the machete and committed the murder of the deceased, and hence there is a specific overt act allegation against this petitioner, and this incident was witnessed by CW2, and this court, while exercising the discretion in favor of accused number 2, made an observation that there is a specific allegation against accused number 1, that is this petitioner, and not on accused number 2. Hence it is not a fit case to exercise the discretion in favor of this petitioner, your lordships. Now, your lordships, 10 witnesses have been examined, and almost all the witnesses, your lordships, have not supported the case of prosecution. So there are key material changes, your lordships. So therefore this successive bail petition is maintainable.
What is that material?
Please, your
changes?
lordships, I request your lordships to.
Sir, CW2 is examined?
He is examined, your lordships. He doesn't support the case of the prosecution. I request your lord, if I directly take your lordships to CW2.
Page 97.
Page 97, your lordships. Relevant portion is paragraph number 2, your lordships. He states as follows. 4-5 ವರ್ಷದ ಹಿಂದೆ ನನಗೆ ಪಾಲನೇತ್ರಯ್ಯನವರನ್ನು ಭರತ್ ಮತ್ತು ಕಾಂತರಾಜ್ ಹೊಡೆದು ಹಾಕಿರುತ್ತಾರೆ ಎಂದು ತಿಳಿದು ಬಂತು. ತುಮಕೂರು ಜಿಲ್ಲಾ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ನಾನು ಮೃತ ದೇಹವನ್ನು ನೋಡಿದ್ದೇನೆ. ಆತ ಜೀವಂತವಾಗಿದ್ದಾಗ ನನ್ನೊಂದಿಗೆ ಮಾತನಾಡಿರುವುದಿಲ್ಲ. ನಾನು ಮೊಬೈಲ್ ಬಳಕೆ ಮಾಡುತ್ತೇನೆ. ನನ್ನ ಮೊಬೈಲ್ ಸಂಖ್ಯೆ so and so. ಆತ
CW2, PW3 at page 97.
Please, your lordships. 98 is the relevant portion.
Satish Kumar, you are reading 98.
Please, paragraph number 2, that's the relevant portion.
Para 2.
ಮೊಬೈಲ್ ಸಂಖ್ಯೆ so and so. ಆತ ಮೃತನಾಗುವ ಹಿಂದಿನ ದಿನ ನನಗೆ ಕರೆ ಮಾಡಿದ್ದರು. ಮೃತನು ನನಗೆ ಕರೆ ಮಾಡಿ ಎಲ್ಲಿದ್ದೀಯಾ, ಏನು ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದೀಯಾ ಎಂದು ವಿಚಾರಿಸಿದನು. ಮೃತ ಪಾಲನೇತ್ರಯ್ಯ ಮೃತರಾದ ಹಿಂದಿನ ದಿನ ನಾನು ಆತನನ್ನು ಸಿದ್ಧಗಂಗಾ ಮಠದ ವಸ್ತು ಪ್ರದರ್ಶನದಲ್ಲಿ ಕೊನೆಯ ಬಾರಿಗೆ ನೋಡಿ ಮಾತನಾಡಿಸಿದ್ದೆ. ಈ ಪ್ರಕರಣದ ಘಟನೆ ಎಲ್ಲಿ ನಡೆದಿತ್ತು ಎಂದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ನಾನು ಘಟನೆಯನ್ನು ಕಣ್ಣಾರೆ ನೋಡಿಲ್ಲ. ಮೃತ ಪಾಲನೇತ್ರಯ್ಯ ಓಡಾಡಲು ಬುಲೆಟ್ ದ್ವಿಚಕ್ರ ವಾಹನವನ್ನು ಬಳಕೆ ಮಾಡುತ್ತಿದ್ದರೋ, 1 ಮತ್ತು 2ನೇ ಆರೋಪಿಗಳು ಏನು ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರೋ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಪೊಲೀಸರು ನನ್ನನ್ನು ವಿಚಾರಣೆ ಮಾಡಿ ಹೇಳಿಕೆ ಪಡೆದಿಲ್ಲ. So as per the prosecution here, he is a eyewitness, but in his evidence, it is forthcoming that he is just a hearsay witness, and he has not at all witnessed the alleged incident, your lordships.
What about cross examination? Evidence includes chief and cross also.
Please, your lordships. In the cross examination by the prosecution, your lordships, ದಿನಾಂಕ 29/1/2020 ಸಂಜೆ 5 ಗಂಟೆ ನಾನು ದಿನನಿತ್ಯದ ವಾಚರ್ ಕೆಲಸ ಮುಗಿಸಿಕೊಂಡು ನನ್ನ ತಾಯಿ ನೋಡಿಕೊಳ್ಳುತ್ತಿದ್ದ.
Yes, madam, what you have elicited in the cross examination? ವಿದ್ಯುತ್ ದೀಪದ ಬೆಳಕಿನಲ್ಲಿ ಆಟೋ ರಿಕ್ಷಾ ನಂಬರ್ ನೋಡಿದಾಗ ಅದರ ಸಂಖ್ಯೆ ಆಗಿತ್ತು ಮತ್ತು ಆಟೋದ ಮೇಲೆ ರಕ್ತ ಸಹ ಸಿಡಿದಿತ್ತು ಎಂದು ನಾನು ಪೊಲೀಸರ ಮುಂದೆ ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೇನೆ ಎಂದರೆ ಸರಿ.
Your lordships, with respect to that, I would like to take your lordships to evidence of PW4, your lordships.
I agree. This is only the court has to appreciate the evidence.
Lordships, this particular
The very same court which recorded the evidence, consider this evidence.
The other,
chief as well as cross examination.
your lordships, the other witness, that is
Whether this court can sit and appreciate the evidence.
Your lordships,
In a bail petition.
This petition, your lordships, is in custody from past 5 years, 9 months.
Life imprisonment and also a life of a person who lost the life. Both court has to consider the both. There is a vote act against him only. That's why this court has exercised the discretion in favor of accused number 2. And accused number 1, who is this petitioner, was rejected for the reason that there is a direct evidence against him that he only inflicted the injury with machete. That's why this court rejected the same.
But this particular witness, your lordships, he has is basically an hearsay witness, your lordships.
No counsel.
Even
But
this alleged
court also to see that the cross examination answer, what the answer illustrate from him.
With respect to the auto, your lordships, I request your lordships to kindly have a look at page number 103, your
If
lordships.
he is a hearsay evidence, then why he made the statement before the police?
To
ಆಟೋ
substantiate,
ರಿಕ್ಷಾ ನೋಡಿದಾಗ ಅದರ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಆಗಿತ್ತು ಮತ್ತು ಆಟೋದ ಮೇಲೆ ರಕ್ತ ಸಹ ಸಿಡಿದಿತ್ತು ಎಂದು ನಾನು ಪೊಲೀಸರ ಮುಂದೆ ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೆ ಎಂದರೆ ಸರಿ.
your
What
lordships,
the statement he has given, portion of the statement was admitted by him, then the trial court has to appreciate the evidence, that's all.
but your lordships, I request your lordships to
ಬೇರೆ
peruse.
ಇನ್ನು ಎಷ್ಟು ಜನ witnesses ಇದ್ದಾರೆ?
Out of 37 witnesses, 10 witnesses have been examined.
Remaining ಎಷ್ಟು ದಿವಸದಲ್ಲಿ examine ಮಾಡ್ತೀರಾ ಮೇಡಮ್? He is in jail from last 5.5 years.
And moreover, this petitioner has this mouth cancer, your lordships. And this auto rickshaw also, your lordships, as per the prosecution, it was given by PW4. He was the owner and it was given to me for rent.
ನಿಮಗೆ ಫೇವರ್ ಇರೋದು ಮಾತ್ರ ನೀವು ಮಾರ್ಕ್ ಮಾಡಿದಿರಿ, ಆಯ್ತಾ?
But he himself admits that he has never given the auto to this particular
ಮಾರ್ಕ್ ಹೆಂಗ್ರಿ
petitioner.
ಮಾಡ್ತೀರಿ ಕೋರ್ಟ್ ಮುಂದೆ ಹಾಕೋ ರೆಕಾರ್ಡ್ಸ್ಗೆ ಹೌ ಯು ಕ್ಯಾನ್ ಮಾರ್ಕ್ ಇಟ್? ನಿಮ್ಗೆ ಯಾವ್ದಾವ್ದು ಫೇವರ್ ಆಗುತ್ತೋ ಅದ್ ಮಾತ್ರ ಮಾರ್ಕ್ ಮಾಡ್ಬಿಟ್ಟು ಹಿಂಗ್ ಹಾಕ್ಬಿಟ್ರೆ ಹೆಂಗೆ? Don't try to
apologize.
mislead the court.
I apologize, your lordships.
ನೋಡಿ, ಯಾವ್ದಾವ್ದು ನಿಮಗೆ ಫೇವರಬಲ್ ಆಗುತ್ತೋ ಅದು ಮಾತ್ರ ಮಾರ್ಕ್ ಮಾಡೋದು.
I apologize, your lordships.
ನಮ್ ಕಣ್ಣು ಅಲ್ಲಿಗೆ ಬೀಳುತ್ತೆ ಫಸ್ಟ್. ಎಲ್ಲಿ ನೀವು ಅಡ್ಮಿಷನ್ ಇರುತ್ತೆ ಅದೇ ನಮ್ ಕಣ್ಣು ಅಲ್ಲಿಗೆ ಬೀಳುತ್ತೆ.
I apologize, your lordships.
ಹ್ಮ್.
And
ಎಷ್ಟು ದಿವಸಲ್ಲಿ ಮಾಡ್ತೀರಿ ಮೇಡಮ್ ರಿಮೈನಿಂಗ್ ವಿಟ್ನೆಸಸ್ ಹೇಳಿ? ಡೈರೆಕ್ಟ್ ಎವಿಡೆನ್ಸ್ ಇದೆ. ರಿಕವರಿ ಇದೆಯಾ? ರಿಕವರಿ
with respect to recovery, he is also not separated the case of prosecution, your lordships.
ಆಯ್ತು,
That is a
ಬಹಳ
PW10.
ಒಳ್ಳೇದಲ್ಲ. ಇನ್ನೊಂದು 3 months ಅಲ್ಲೇ ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ ಡೈರೆಕ್ಷನ್ ಕೊಡೋಣ.
3 months, please, your lordships. 3 months.
ಇನ್ನು ಎಷ್ಟು ಜನ
Only
ಇದ್ದಾರೆ
official
ಮೇಡಮ್
witnesses.
ವಿಟ್ನೆಸಸ್? He is lying in the jail for last 5.5 years. ಯಾವಾಗ ನಿಮ್ ಎವಿಡೆನ್ಸ್ ಕಮೆನ್ಸ್ ಆಗಿದೆ ಯಾವಾಗ ಮೇಡಮ್? ಇನ್ಸಿಡೆಂಟ್ 2020. ನೀವು ಎವಿಡೆನ್ಸ್ ಕಮೆನ್ಸ್ ಮಾಡಿರೋದೇ 24ರಲ್ಲಿ after 4 years. PW1 26 to 24. Third, heard the petitioner counsel and also the additional SPP. And this court earlier dismissed the bail petition of this petitioner in criminal petition number 4353 of 2022. With order dated 3rd day of June 2022. And this court, while rejecting the bail petition in paragraph number 6, taken note of that this petitioner came in the auto with the machete with an intention to take away the life of the deceased and inflicted injury on the deceased, and also driven the auto on him, and again he inflicted injury with the machete and committed the murder of the deceased, and hence there is a specific court act against this petitioner, and this incident was witnessed by CW2, and this court also taken note of no vote act against accused number 2, and hence he was enlarged on bail. Now the counsel appearing for the petitioner would submit that CW2 is examined and he is not supported the case of the prosecution, who is only the eyewitness, and other witnesses are also examined. The counsel appearing for the state would submit that only 10 witnesses are examined and remaining witnesses to be examined, and also there is a recovery and recovery witnesses also to be examined and IO to be also to be examined, and it is a case of inflicting injury with machete, and not only inflicted the injury with the machete, and he run over the auto rickshaw on him, and then again he inflicted the injury, and court has to take note of PM report and the injuries found on the body of the victim. Having considered the submission of the petitioner counsel and also the counsel appearing for the state, there are 10 external injuries, and out of that major injuries are chop wound injuries, and PM report discloses the same. And also CW2 though turned hostile and he was cross-examined, and answer is also elicited from the mouth of CW2, who has been examined as PW3 with regard to the found blood stains in the auto rickshaw, and he made the statement before the police. And when considering the case, the trial court has to appreciate the evidence, and this court cannot sit and appreciate the evidence of the prosecution. However, taking into note of already 10 witnesses have been examined and remaining witnesses to be examined, direction is given to conclude the trial within 4 months, and also prosecution is directed to assist the trial court in conclusion of the trial within 4 months, since the accused is in the jail from last 5.5 years, and with this observation the petition is disposed of.
C5, Ganapati Bhatt.
Referring for the petition, I'm requesting for a week's time, to place entire charge sheet for that purpose. Entire charge sheet.
Petitioner counsel seeks time. ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಆಗಿದೆ ಮೇಡಮ್ ಇದರಲ್ಲಿ?
Notice ಆಗಿದೆ.
ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
And hence list this matter 2 weeks ಬಿಟ್ಟು ಕೊಡಿ. Next Wednesday.
312.
312 ಆಗುತ್ತಾ? 312 probably no sitting. 412.
Please.
412. 412. ಅಥವಾ next week ಆಗುತ್ತಾ?
Next week ಆಗುತ್ತೆ.
Next Wednesday ಗೆ ಕೊಡಿ. 10-12.
Please.
66, Dhananjay Kumar.
Hearing for the petitioner, my lord. In this matter, offence is under POSCO, my lord. Respondent 2 ಗೆ notice ಆಗಿಲ್ಲ sir.
ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ. State ಗೆ ಮಾತ್ರ
POCSO ಇದೆಯಾ?
Yes.
ನಿಮಗೆ ನೋಟಿಸ್ ಆಗಿದೆ ಮೇಡಮ್? ಫಸ್ಟ್ ಟೈಮ್ ಏನ್ರಿ ಮೇಡಮ್?
ಇಲ್ಲ, ಆಗಿದೆ.
ಆಗಿದೆ. State ಗೆ.
GP to take notice ಅಂತ ಆಗಿದೆ.
ಆಗಿದೆ.
Yes. The respondent to.
ಆಟೋಗ್ ನೋಟಿಸ್ ಆಗ್ಲಿಲ್ವಾ ಯಾಕೆ?
No.
ಅವತ್ತೇನ್ ಗೊತ್ತಾಗ್ಲಿಲ್ವಾ ಏನು? ನಮ್ಮ ಮುಂದೆ ಬಂದಿಲ್ಲ ಇದು. Office objections will be complied. Directed to take notice. Issue notice against the respondent number 2 through IO. And counsel for the petitioner is directed to furnish one more copy on the additional SPP to serve the same through IO.
Date may be given, Your Honor.
List this matter on 10/12. 10/12.
Yes.
3 ವಾರ.
Yes.
10/12.
67.
ಬಸವರಾಜು P.
Formal notice has not been ordered, my lords.
Hmm?
Formal notice order ಆಗಿಲ್ಲ.
Formal notice order ಆಗಿನಾದ್ರೆ first time ಬಂದಿದೆಯಾ?
It has come before the court on the earlier occasion by order dated 10th of November. The coordinate bench would say that it has to be, since it's a successive bail application.
Appearing for respondent, state is directed to take notice ಅಂತ ಮಾಡಿದ್ದಾರೆ.
I'll file my objections. Could be had next week, my lords.
2 months ago, my lord, we have served the copy.
ನೋಡಿ 26/9 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರೋದು.
ಒಂದು 10 volumes they have filed the petition.
ಅಲ್ಲ ರೀ bail petition.
This is the bail petition, my lords. This is the entire bail petition.
ಆಗ್ಲಿ.
ಮಾಡಿದೀನಿ. I'll file it, my lords. Monday, my lords may have it.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನವರು ಒಂದು ವಾರದ ಮೇಲೆ ಇಟ್ಕೋಬೇಡಿ ಅಂತಾರೆ.
Monday, my lords may
ನೀವು
have
ನೋಡಿ
it.
26/9 ನೋಟಿಸ್ ಆದ್ರೆ
Monday, my lords may have
ನಾವು
it.
ಇಯರ್ ಇನ್ ದ ಮಂತ್ ಆಫ್ ನವೆಂಬರ್.
November. Monday, my lords may have it, my lords. I'll serve a copy priorly so that.
Special public prosecutor 6 weeks time to file statement of objection and hence list this matter next Wednesday date ಕೊಡಿ madam. 26/11.
Please.
Please.
Admission matter 68. Vinay Kirtiyam.
There is the proposals, the elections ನಡೆದು there is a transition period ಸುಮ್ಮನೆ ಬೇರೆ ಇದು ಕಮಿಟಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗ್ತಾ ಇದೆ.
ಅಲ್ಲಿ ಹೊಸ ಕಮಿಟಿ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಗ್ತಾ ಇದೆ with respect to the second respondent. So for that reasons last occasion I gave a proposal for them. This is
ಹೊಸ ಕಮಿಟಿ ಮುಂದೆ
ಬಟ್ ನೀವು ಇಲ್ಲಿ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇಲ್ವಲ್ಲ?
ಅಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಅಂಡರ್ಟೇಕಿಂಗ್
ತಗೊಂಡ್ರು ವಿಠಲ್ ಕುಮಾರ್ ಅಂತಿದೆ ಸರ್ವ್ಡ್
ಇದೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ತಗೊಂಡ್ರು ವಕಾಲತ್ ಆಗ್ತೀವಿ ಅಂತ
ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಏನ್ ಆಗ್ತೀವಿ ಅಂತ. ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಅಪಿಯರ್ ಆಗಿದ್ರಿ, ಹೆಸರು ತೋರಿಸಿಲ್ಲ.
ಅದಕ್ಕೆ ಅವ್ರ ಹೆಸರು
ಓಂಕಾರೇಶ ಅಂಡರ್ಟೇಕ್ಸ್ ಟು ಫೈಲ್ ವಕಾಲತ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2. ನೀವು ವಕಾಲತ್ ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ ವಕಾಲತ್ ಹಾಕಿಲ್ಲ. ಅದು ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಟ್ರಾನ್ಸಿಷನ್ ಪೀರಿಯಡ್ ಇದೆ ಸ್ವಾಮಿ. ಅದಕ್ಕೆ ಹೊಸ
ಟೈಮ್ ಬೇಕಾ ನಿಮ್ಗೆ? ಟೈಮ್ ಬೇಕು.
10 days ಕೊಟ್ಬಿಟ್ರೆ
ಇಲ್ಲ 10 days ಬೇಡ 25th or 26th they called us for
ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ
ಟೈಮ್ ಕೇಳಬಾರದು ಅಂತ ಸ್ವಾಮಿ.
ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಹಾಕ್ತೀನಿ ಕ್ರಿಮಿನಲ್ ಮ್ಯಾಟರ್.
ಅಲ್ಲ 10 days
ವೆಡ್ನೆಸ್ಡೇನೇ ಸಿಟ್ಟಿಂಗ್ ಕ್ರಿಮಿನಲ್ ಗೆ. ಇನ್ ಬಾಕಿದೆಲ್ಲ RSA ಇರ್ತದೆ. ನೋಡಿ ಕೌನ್ಸಿಲ್
Yes, my lord, for the petitioner, my lord. Petitioner is accused number 3, my lord.
A3.
Yes, my lord. The only allegation against him is that he has drafted the forged agreement. He is an advocate, my lord. It had come on the last date of.
Last time ಏನೋ ಹೇಳಿದ್ವಲ್ರಿ?
Sir.
He drafted the agreement, that's all.
As per the my lord, the private complaint, there is an allegation that my lord is doubt of the complaint. But my lord filing, the police have while filing a my lord charge sheet invoking my lord 120B also my lord. There is a conspiracy between accused number 1 to 3 my lord. Therefore invoking under section 128B.
Who an accused who an advocate drafted the complaint ಏನ್ draft ಮಾಡಿರೋದು?
Sale agreement draft.
Sale agreement.
Agreement of sale.
ಆಯ್ತು, ಇವ್ರ ಪ್ರೆಸೆನ್ಸ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಸೈನ್ ಮಾಡೋರ ಯಾರು?
ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ
ಅಫೆನ್ಸಸ್ ಏನ್ ಇನ್ವೋಕ್ ಮಾಡಿರೋದು?
120B, 197, 199, 200, 208, 468, 419, 420, 465, 466, 468, 471, 475. But in the charge sheet,
what is the role of the advocate? Maybe there is an allegation in the complaint, private complaint. Alva? But then forgery na?
ಹೌದು ಅಲ್ಲ ಇದ್ರೊಳಗೆ the signature was forged by the accused number 1 and 2 but ಇದು column number 17 ಅಲ್ಲಿ ಮೇಡಮ್
ಫೋರ್ಜ್ ಮಾಡಿರೋದು ಯಾರು ಬೇರೆಯವರು ಅಷ್ಟೇ.
Accused number 1 ಅಂತ ಹೇಳ್ತಾರೆ ಸರ್. ಆಮೇಲೆ accused number 2 is the attesting witness to that agreement. And
Accused number?
Accused number 2 is the attesting witness. Accused number 2 sir. Accused number 3 has drafted it ಅಷ್ಟೇ. Accused number 2 is
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನಿದೆ? ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಎಕ್ಸೆಪ್ಟ್ ಇನ್ವೋಕಿಂಗ್ 120B.
yes
ಬೇರೆ ಏನಾರು ಇದೆಯಾ? ಎಲ್ಲಿದೆ ಚಾರ್ಜ್ ಶೀಟ್ ತೋರಿಸಿ.
column number 17 ಮೇಲೋಡ್ page number 27
ಪೇಜ್ ನಂಬರ್ 27.
ಹೌದು ಇಲ್ಲೊಂದು ಲೈನ್ ಹೇಳ್ತಾ ಸ್ವಾಮಿ ಒನ್ ಮೇಲೆ
ಲಾಯರ್ಗಳು ಯಾರು ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ನೇ ಡ್ರಾಫ್ಟ್ ಮಾಡಲ್ಲ ಆಮೇಲೆ.
ಅಲ್ಲ ದೇರ್ ವಾಸ್ ಇಲ್ಲಿ ಇದು ಏನಾಗಿದೆ ಅಂದ್ರೆ accused number 1 is also an advocate. Complainant is also
an advocate.
Yes my lord.
Complainant
is also advocate.
Complainant is also an advocate.
It is also an advocate.
My information there was a team. ಅವನು ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಮೇಲಂತೂ ತುಂಬಾ ಕೇಸ್ ಇದೆ, ಮೋರ್ ದನ್ 50 ಕೇಸ್ ಅಂತ. ಸಾಕ್ಷಿ ಮತ್ತು A3 ಆ ಮೂರು ಅಕ್ಯೂಸ್ ನಂಬರ್ 3 ಮೇಲೆ ದ ಪ್ರೆಸೆಂಟ್ ಪಿಟಿಷನರ್ ಅವರು ಪತ್ರವನ್ನು ತಯಾರಿ ಮಾಡಿಕೊಂಡು ರವರ ನಕಲಿ ಅಗ್ರಿಮೆಂಟ್ ನ ಮೇಲೆ ದಿನಾಂಕ 8/12/2018 ಲೀಗಲ್ ನೋಟಿಸ್ ನೀಡಿರುವಂತೆ ಪೋಸ್ಟಲ್ ರಸೀದಿ ಸ್ವೀಕೃತಿಯನ್ನು ಸೃಷ್ಟಿ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ದಟ್ ಈಸ್ ದ ಅಲಿಗೇಷನ್.
ಅದ್ ಏವನ್ರಿ ಅದು?
ಇವರು
ಸಾಕ್ಷಿದಾರರಂತೆ ಮತ್ತು ಆ ಮೂರೂರವರು ಪತ್ರವನ್ನು ತಯಾರು ಮಾಡಿಕೊಂಡು ರವರು ನಕಲಿ ಅಗ್ರಿಮೆಂಟ್ ನ ಮೇಲೆ
ದಿನಾಂಕ
6/12/2018 ಲೀಗಲ್ ನೋಟಿಸ್ ನೀಡಿರುವಂತೆ ಪೋಸ್ಟಲ್ ರಸೀದಿ ಸ್ವೀಕೃತಿಯನ್ನು ಸೃಷ್ಟಿ ಮಾಡಿರ್ತಾರೆ. ಅದು ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಅದು. KGF ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ OS ದಾಖಲೆ ಇತ್ಯರ್ಥವಾಗಿದೆ ಹೇಳಿ ದಾವೆಯನ್ನು ಹಿಂಪಡೆದಿರುತ್ತೆ. ಅವರು ದಸರ ಜಮೀನಿನ ಮಾಲೀಕರಾಗಲ್ಲಿ ಯಾವುದೇ ಮಾಹಿತಿಯನ್ನು ತಿಳಿಸಿದ್ರೆ ಜಮೀನಿನ ನಕಲಿ ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿಕೊಂಡಿದ್ದು ಅದೆಲ್ಲ A1 ಮೇಲೆನೆ ಇರೋದು. A3 ಏನಿದೆ ಸ್ಪೆಸಿಫಿಕ್ ಅಲಿಗೇಷನ್? ಆ ಒಂದು ಮತ್ತು ಅವರ ಸಹಿಗಳನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿ ಮೋಸ ಮಾಡಿರುತ್ತಾರೆ ಎಂದು ಮೇಲ್ಕಂಡ ಕಲಂಗಳ ಅನ್ವಯ 1, 2 ಮೇಲೆ ಮಾತ್ರ ಇದೆ. 3ನೇವ್ರ ಮೇಲೇನು? ಪತ್ರವನ್ನು ತಯಾರಿ ಮಾಡಿಕೊಂಡು ಅಷ್ಟೇ. ಓನ್ಲಿ ಡ್ರಾಫ್ಟೆಡ್ ಅಷ್ಟೇ ಅಲ್ವಾ?
ಅಷ್ಟೇ ಇರೋ ಸರ್.
ಆ ಮೂರೂರವರು ಪತ್ರವನ್ನು ತಯಾರಿ ಮಾಡಿಕೊಂಡು ರವರು ನಕಲಿ ಅಗ್ರಿಮೆಂಟ್ ನ ಮೇಲೆ ದಿನಾಂಕ 6/12/2018 ಲೀಗಲ್ ನೋಟಿಸ್ ನೀಡಿರುವಂತೆ ಪೋಸ್ಟಲ್ ರಸೀದಿಯನ್ನು ಸೃಷ್ಟಿ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಅಂದ್ರೆ ಯಾವ್ದೋ ಒಂದು ರಸೀಟ್ ಕ್ರಿಯೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಲೀಗಲ್ ನೋಟಿಸ್ ಕೊಟ್ಟಾಗೆ.
ಹೌದು,
ಅದು ಬಿಟ್ಟು ಬೇರೆ ಏನೇನಿಲ್ಲ. ತೋಳ್ ಅಷ್ಟೇ ಅಲ್ಲ ಮೇಡಮ್? ಯಾರು ಇವ್ರ? ಯಾವ್ದು ಇವ್ರೇನ್ ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ?
ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಈಸ್ ಯೂಸ್ಡ್
ಬೈ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಮೇಡಮ್.
ಆಯ್ತು ಮೇಡಮ್, ಯಾರದು? ಅದ್ರಲ್ಲಿ ಯಾರು ಆ ಸೂಟ್ ಅಲ್ಲಿ A1 and A2 ನಾ? A1 and A2 ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್. ಹಿ ಹ್ಯಾಸ್ ಡ್ರಾಫ್ಟೆಡ್. ಇವ್ರು ನಿಮ್ಮ ಪ್ರಕಾರನೇ ನೋಡಿ ಡ್ರಾಫ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ. ಆ ಮೂರೂರವರು ಪತ್ರವನ್ನು ತಯಾರು ಮಾಡಿಕೊಂಡು
ಅಲ್ಲ ಈವನ್
ದಾಖಲೆ ಸೂಟ್ ಹಾಕ್ದವ್ರು ಯಾರು ಅಲ್ಲಿ?
A1
ಹಾಕ್ದವ್ರು ಯಾರು? KGF ನ್ಯಾಯಾಲಯದಲ್ಲಿ
A1.
ಮತ್ತೆ A3 ಎಲ್ಲಿದೆ? A3 ನೋಡಿ ನಿಮ್ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇರೋದು ಕಲಂ ನಂಬರ್ 17 ಅಲ್ಲಿ. A3 ರವರು ಪತ್ರವನ್ನು ತಯಾರು ಮಾಡಿಕೊಂಡು ಅಷ್ಟೇ. ಆಮೇಲೆ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ರವರು ನಕಲಿ ಅಗ್ರಿಮೆಂಟ್ ನ ಮೇಲೆ ದಿನಾಂಕ 6/12/2018 ಲೀಗಲ್ ನೋಟಿಸ್ ನೀಡಿರುವಂತೆ ಪೋಸ್ಟಲ್ ರಸೀದಿ ಸ್ವೀಕೃತಿಯನ್ನು ಸೃಷ್ಟಿ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಅದು A1. ಎಕ್ಸೆಪ್ಟ್ ಸ್ಟೇಟಿಂಗ್ ದಟ್ A3 ಪ್ರಿಪೇರ್ಡ್ ದಿ ಡ್ರಾಫ್ಟ್ ಸೇಲ್ ಡೀಡ್, ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್. ಬೇರೆ ಏನೂ ಇಲ್ವಲ್ಲ? ಎಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲಿಗೇಷನ್ ಎಗನೆಸ್ಟ್ A1 and A2 ಓನ್ಲಿ.
ಇವನ್ PCR ಅಲ್ಲೂ ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ. ಅಕ್ಯೂಸ್ ನಂಬರ್ 3 ವಾಸ್ ಡ್ರಾಫ್ಟೆಡ್ ದ ಸೇಡ್ ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ಡೇಟೆಡ್ 11/9/2016.
ಅಷ್ಟೇ ಡ್ರಾಫ್ಟೆಡ್. ತೋಳಿ heard the petitioner counsel and also the counsel appearing for the state as well as respond number 2. The main contention of the counsel appearing for the petitioner before this court is that only charge sheet allegation in column number 17 against this petitioner who has been arraigned as accused number 3, that he drafted the sale agreement, and allegation against accused number 1 and 2 that the same is made use of by accused number 1 and 2, and hence the very initiation of criminal proceedings against an advocate is nothing but an abuse of process, and hence this court has to exercise the discretion to quash the proceedings. Per contra, the counsel appearing for the respondent number 1 and 2 state, and the complainant counsel would contend that there are number of cases against accused number 1, and also section 120 is invoked against all the accused. And when the criminal conspiracy is alleged in the charge sheet, and the counsel and the present petitioner who also indulged in creation of such document along with other accused, and hence
Matter for trial.
not a case for quashing of the proceedings. The counsel appearing for the state also would submit that there are allegations against this petitioner also, and not a case for quashing of the proceedings. Having heard the petitioner counsel and also the counsel appearing for the respondent, and also having read the column number 17 of the charge sheet, except allegation that he had drafted the sale agreement, nothing is alleged against this petitioner. And also even in the private complaint, allegation made against this petitioner is that he has drafted the sale agreement, and nothing whispered with regard to the criminal conspiracy is concerned. And criminal conspiracy is also proving of fact only by circumstantial evidence. And when there is no any such material available before the court against this petitioner, except drafting of sale agreement, question of facing criminal case by an advocate, that too he prepared the sale agreement, and no any substantial material that he had indulged in forging of document, and specific allegation made against accused number 2 and 3. And when such being the case, it is a clear case to invoke the discretion to quash the proceedings against this petitioner, and there is no any sufficient material against this petitioner except the allegation that he had drafted the sale agreement, and hence the proceedings initiated against this petitioner and arraigned him as accused number 3 is nothing but an abuse of process, and hence fit case to exercise the discretion to quash the proceedings against the petitioner, since there is no any sufficient material against him to face the criminal case. And hence I pass the following order. Petition is allowed and proceedings is quashed against the present petitioner.
Grateful.
Next.
Further argument 70, Prasanna Kumar P, PV Patil.
ಏನಾಯ್ತ್ರಿ ನಾ ಲಾಸ್ಟ್ ಟೈಮ್ ವೆರಿಫೈ ಮಾಡಿ ಹೇಳ್ತೀನಿ ಅಂದ್ರೆ
My lords, in as much as one charge sheet is filed, another one, my lords, there is the entire case hinges on CCTV footage. We have sent that CCTV footage for report in Kerala, and we are awaiting the response to that. Immediately on the receipt of it.
ಕೇರಳಕ್ಕೆ ಏನಕ್ಕೆ
ಅದು CCTV authentication ಮಾಡಕ್ಕೆ
genuineness ಗೆ
genuineness ಯಾಕಂದ್ರೆ ಅದನ್ನ ಬಿಟ್ರೆ
whether there is morphing or not ಅಂತ.
Yes, and he himself was there or no ಅಂತ ಅಲ್ಲಿ CCTV ನ ನಾವು hard drive ನ we had confiscated it from as an evidence from the office of one of the complainant. Now that has been sent, my lords, we are awaiting the report. It has been sent in the month of June, we are still awaiting. As soon as it comes, because that would be the only edifice there in ಅದರಲ್ಲಿ ಎರಡರಲ್ಲಿ. ಇನ್ನೊಂದು third one we are waiting on certain information based which again we'll file a charge sheet.
ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿರೋದು ನೀವು ಒಂದರಲ್ಲಿ ಮಾತ್ರ,
ಒಂದರಲ್ಲೇ ಮಾತ್ರ.
ಇನ್ನು ಎರಡರಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಇನ್ನೆರಡರಲ್ಲಿ ಅದೇ ಒಂದು CCTV ಬಂತಂದ್ರೆ ಇವೆರಡೂನು ಇವೆರಡನ್ನು ಕ್ಲೋಸ್ ಆಗ್, ಯಾಕಂದ್ರೆ
ವಾಟ್ ಹ್ಯಾಪಂಡ್ ಇನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್?
it is still pending, my lords. It's not being taken up.
This my lord may
Illi,
request
and
this
one more subtle thing, my lords, I want to state is that we had completed the arguments, my lords. At that juncture, we said that this charge sheet is being filed. So at that point in time, my lords, this honorable court was pleased to express that you may have to withdraw it and file it afresh. They filed an amendment saying
Amendment
that
ಮಾಡ್ಕೊಂಡ್ರಿ ಈಗ.
amendment ಮಾಡ್ಕೊಂಡ್ರು.
ಆಯ್ತು, amend ಆಯ್ತು.
ಇವಾಗ, my lords, we have nothing more to add because we had argued based upon the charge sheet itself. And in connection with the same, my lords, I am just filing a synopsis of all my arguments where I have verbatim reproduced from the annexures that I have given. So that would go to show, my lords, in all the three cases, we have now filed written arguments.
ಆಯ್ತು, ಹಾಗಾದ್ರೆ ಅವ್ರು ಹೇಳೋದು ಹೇಳಿ ನೀವು.
ಅಲ್ಲ, ಮತ್ತೆ ಮತ್ತೆ ಅದನ್ನೇ ರಿಪೀಟ್ ಮಾಡೋದ್ರೊಳಗೆ ಅರ್ಥ ಇಲ್ಲ ಅಂತ ನಾನು I'm just taking
ಆಯ್ತು.
this. And another one thing I have to say, my lords, is that
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಿರಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನ್ ಮೆಟೀರಿಯಲ್ ಇದೆ ಅವನ ಮೇಲೆ?
ಅದ್ರ ಮೇಲೆ
ಅದನ್ನ ಅವ್ರು ಲಾಸ್ಟ್ ಡೇಟ್ ದೇ ಅಪ್ರೈಸ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್.
ಅಲ್ಲ ಸರಿ, ಏನಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಪ್ಲೀಸ್.
ಈಗ ನೀವು ಚಾರ್ಜ್ ಶೀಟ್ ಇವನ್ ಮೇಲೆ ಹಾಕಿದಿರಿ,
CCTV
ಒಬ್ಬ ಅಕ್ಯೂಸ್ ಮೇಲೆ ಕ್ವಾಶ್ ಆಗಿದೆ,
ಒಬ್ಬ ಅಕ್ಯೂಸ್ ಮೇಲೆ ಕ್ವಾಶ್ ಆಗಿದ್ದನ್ನ
ಅದು ಈಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ.
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್
ಈಗ ಈ ಅಕ್ಯೂಸ್ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕುವಾಗ ವಾಟ್ ಆರ್ ದ ಮೆಟೀರಿಯಲ್ ಯು ಹ್ಯಾವ್ ಕಲೆಕ್ಟೆಡ್?
My lords, we have collected the statements of
any amount he collected?
My lords, there is 25 lakhs lying even now.
Lying ಸರಿ ರೀ, ಬಟ್ ಯಾರು ಕಲೆಕ್ಟ್ ಮಾಡಿರೋದು ಅದನ್ನ ಅಮೌಂಟ್?
ಅದನ್ನ ಅವರು one of the accused in accompaniment with the my person as against whom the quashment has happened.
ದುಡ್ಡು ಯಾರಿಗೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದಾರೆ?
ಅವರು ಪ್ರಿಲಿಮಿನರಿ ಇನ್ಕ್ವೈರಿಯಲ್ಲಿ ಬಂದು ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಗೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದ್ದಾರೆ, ಬ್ಯಾಗ್ ಅಲ್ಲಿ 25 ಲಕ್ಷ ಹಾಕಿ.
ಅವ್ರು ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡ್ಲಿ, ಅಮೌಂಟ್ ಯಾರ ಕಡೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಿದ ನಿಮ್ ಕಂಪ್ಲೇನೆಂಟ್. Amount of 25 lakhs was handed over to whom?
My lords, I will have to verify that, but one of the accused in this case only, my lords.
ಅದಕ್ಕೆ ನಾನು ಕೇಳ್ತಾ ಇರೋದು, ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನ್ ಅಲಿಗೇಷನ್ against him? What is the evidence against him during the course of investigation?
Against Ajay.
ಈಗ ಯಾರೋ
ಅಜಯ್ ಅನ್ನೋರು ಒಬ್ಬರೇ ಬಂದಿದ್ದಾರೆ.
ಅಜಯ್ ಅನ್ನೋರು ಬಂದಿದ್ದಾರೆ, ಅವನ ಮೇಲೆ ಏನಿದೆ ಅದು ನೀವು ಹೇಳ್ಬೇಕಲ್ಲ. ಅದನ್ನ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ಬೇಕಾದ್ರೆ you have found some material against him. What are those materials?
I'll mark out the pages in the charge sheet and
may I take 5 minutes, my lord? The allegation which your lordship questioned, who received the money? The allegation is insofar as accused number 1 is concerned. It is not the petitioner. Insofar as that
material, charge sheet material ಏನಿದೆ
I
ಅಂತ
will
ನಾನು
take
ಕೇಳ್ತಾ
5 minutes.
ಇದ್ದೀನಿ.
I'll appraise this honorable court as to what is the money.
ಕೊಡಿ ಮಾಡಿ. ಇದು ಫಸ್ಟ್ ಕ್ರೈಮಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಹೇಳಿ.
5918 please.
5918 ಅಲ್ಲಿ
Please.
ನೋಟ್ಸ್ ಇರ್ಬೇಕು. ಈಗ ಫ್ರೆಶ್ ಆಗಿ ಏನೋ ಹೇಳ್ತಾರಂತವ್ರು ಹೇಳಿ. 5198
5918
ಇದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
ಇದರಲ್ಲೇ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
ಆಗಿರೋದು
ಆಗಿರೋದು
24. ನಿಮ್ ಪ್ರಕಾರ ಏನು ಇಲ್ಲ ಅಂತನಾ?
Please, certain points.
ಇವನ್ ಮೇಲೆ ಮೆಟೀರಿಯಲ್ ಏನ್ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕುವಾಗ? ವಾಟ್ ದೇ ಆರ್ ರಿಲೈಯಿಂಗ್ ಅಪಾನ್?
Please, my lord.
ಹಾ.
Firstly, all the statements which they rely upon in the charge sheet which they have filed dates back to 2020 and 2021. There is no additional statement beyond August 2021 which the prosecution relies upon in the entire charge sheet. Now, your lordship's order.
You are not answering to my question.
Please, my lord.
In the charge sheet, what they are relying upon to proceed against you? That is the crux of the issue.
Statements
ಅದನ್ನ ಹೇಳ್ಬಿಡಿ, ನೀವು ಸ್ಟೇಟ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಬಿಟ್ಬಿಡಿ.
ಇಬ್ರು ವಿಟ್ನೆಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್, ಒಂದು alleged CCTV footage.
ಇಬ್ರದ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂತಂದ್ರೆ ಯಾರ್ಯಾರ್ದು?
CW2 and CW3.
ಈಗ ರಿಲೈ ಮಾಡ್ತಾ ಇರೋದವರು
ಈ ಕೇಸಲ್ಲಿ
ಚಾರ್ಜ್ ಶೀಟಿಗೆ,
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಈ ಕೇಸಲ್ಲಿ CW2 and CW3
ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್.
ಚಾರ್ಜ್ ಶೀಟ್ ಮಾಡಿ.
ಆಮೇಲೆ ಇನ್ನೊಂದೇನು?
ಇನ್ನೊಂದು that is
CCTV.
Please.
CCTV ಫುಟೇಜ್. CCTV ಫುಟೇಜ್ ಅಲ್ಲಿ ಇದ್ರಲ್ಲಿ ನಿಮಗೆ ರಿಪೋರ್ಟ್ ಬಂದಿದೆಯೇನ್ರಿ? ನಿಮಗೆ ಇದ್ರಲ್ಲಿ ಬಂದಿದೆಯಾ FSL ರಿಪೋರ್ಟ್?
ಇದರಲ್ಲಿ
CCTV ಇದು
ಚಾರ್ಜ್ ಶೀಟ್ is filed.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ, ರಿಪೋರ್ಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಈಗ ಹೇಳಿರೋರು ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ನಮಗೆ ಕಳಿಸಿದೀವಿ ಕೇರಳಕ್ಕೆ, ಇನ್ನೂ ಬಂದಿಲ್ಲ ರಿಪೋರ್ಟ್ ಅಂತಂದ್ರು. ಇದ್ರಲ್ಲಿ ಬಂದಿದೆಯಾ CCTVದು? ಏನ್ CCTV ನಲ್ಲಿ ಏನಿದೆ?
CCTV one of the witness goes to the bank, withdraws money.
Goes to the bank.
Bank and withdraws money.
Witness goes to the bank.
One of the witness goes to the bank.
ಈ ಅಕ್ಯೂಸ್ಡ್ ಏನಾರು ತಗೊಳ್ಳೋದು ಆ ತರದ್ ಏನಾರು
ಆ
ಇದೆಯಾ?
ತರದ್ ಏನೂ ಇಲ್ಲ. ಯಾವ ಆರೋಪಿನೂ ತಗೊಳ್ಳೋದು ಏನೂ ಇಲ್ಲ.
ಇಲ್ಲ.
ಅವ್ರು
ಎಲ್ಲೂ ಇಲ್ಲ.
ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ, ಯಾರು ವಿಡ್ರಾ ಮಾಡ್ಕೋತಾರ ಅವ್ರು ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡ್ತಾರೆ, ನನಗೆ ಇವ್ರು ಕೊಟ್ಟು ಕಳ್ಸಿದ್ರು, ಇವ್ರು ಇಲ್ಲಿ ನಿಂತಿದ್ರು, ನನಗೆ ಹೋಗಿ ದುಡ್ಡು ತಗೊಂಬಾ ಅಂತ ಹೇಳಿದ್ರು ಅಂತ.
ಏನಂತ?
ಇವ್ರು ಇಲ್ಲಿವರೆಗೆ ಬಂದ್ರು,
ಹಾ.
ಇಲ್ಲಿಂದ ಬಂದು ನನಗೆ ದುಡ್ಡು ತಗೊಂಬಾ ಅಂತ ಬ್ಯಾಂಕಿಗೆ ಕಳ್ಸಿದ್ರು, ನಾನು ಇಳಿದು ಹೋಗಿ ಅಲ್ಲಿಂದ ಬ್ಯಾಂಕ್ ತಗೊಂಡ್ ಬಂದು ಕೊಟ್ಟೆ ಅವರಿಗೆ.
ತಗೊಂಡ್ ಬಂದ್ ಇವನಿಗೆ ಕೊಟ್ಟೆ
ಹಾ.
ದುಡ್ಡು ಅಂತ.
ಹಾ.
ಯಾರಿಗ್ ಕೊಟ್ಟೆ ಅಂತ ಹೇಳಿ?
ಇವ್ರು ಅಜಯನವರಿಗೆ.
ಇವ್ರಿಗೆ ಕೊಟ್ಟೆ ಅಂತ
ಹಾ.
ಹೇಳ್ತಾನ?
Yes.
ಯಾರದ್ ಹೇಳಿರೋದು?
ಅವ್ರ ವಿಟ್ನೆಸ್.
CCTV report shows that the witness went to the bank.
He withdrew the money and came and gave it back to him. It has to be read in conjecture that he has given a statement that he withdrew the money and gave it back.
ಮನಿ ಎಷ್ಟು ಕೊಟ್ಟೆ ಅಂತ ಹೇಳ್ತಾನೆ ಇವನಿಗೆ?
Lord said
ಎಷ್ಟು?
ಅದು ಡಿಫರೆಂಟ್ ಅಮೌಂಟ್ಸ್ ಇದೆ ಅದರಲ್ಲಿ, ಬೇರೆ ಬೇರೆ ಇದರಲ್ಲಿ.
ಈ ಕೇಸಲ್ಲಿ ಎಷ್ಟು ಅಂತ ಇವನಿಗೆ ಗೊತ್ತಿಲ್ವಾ?
I'll have to individually check, my lords. Individually ನಾವು ಚಾರ್ಜ್ ಶೀಟ್ ಅನ್ನ ಕ್ಲಿಯರ್ ಆಗಿ ನೋಡಿಲ್ಲ. What we were on supposition, my lords, is that
2.5 ಲಕ್ಷ.
2.5 ಲಕ್ಷನಾ? 2.5 ಲಕ್ಷ. ಹಾ.
We are only on the preliminary ground that in 482 jurisdiction cannot be exercised here in the face of this evidence itself. Only
ಅಂದ್ರೆ
uncalled.
he handed over the money to particularly to this accused ಅಂತ.
Please.
By drawing the money from the bank.
Please.
ಆ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಡ್ರಾ ಮಾಡಿರೋದಕ್ಕೂ ದಾಖಲೆ ಕಲೆಕ್ಟ್ ಮಾಡಿದಿರಾ ನೀವು?
ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಗಳಿವೆ.
ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಂದ್ರೆ ವಿಡ್ರಾ ಮಾಡಿದ್ಕೆ ಅವ್ರು ಎಷ್ಟು ಅವ್ರು ವಿಟ್ನೆಸ್? ಈ ವಿಟ್ನೆಸ್ ಹೋಗಿ ಬ್ಯಾಂಕಿಗೆ ಹೋಗಿ ಡ್ರಾ ಮಾಡ್ದ ಅಂತ ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್ ಹೇಳಿದಾನ?
ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್.
ಅವ್ರು ಎಷ್ಟನೇ ವಿಟ್ನೆಸ್? CW 14. But the fact that he withdrew the money on that day is also collected the material.
Please.
And also recorded the statement of CW 14.
Please. This has to go into trial is my respectful submission.
I take your lordships to those statements.
ಹೇಳ್ರಿ ನೀವೇನು?
Firstly, my lord, all the statements dates back to 2020 and 2021. Your lordship's order in para 42
statements
dates back to 2020 and before August 2021.
2021. ಆಯ್ತು.
Your lordship's order dated 8 September 2021 at paragraph 42 reads as keeping in view these provisions, this court has to look into the material available on record and proceeds to.
That is with regard to the consideration of case of A1.
Please, my lord.
A1. ಹೌದಾ?
As of that stage.
Not in respect of A2. In that petition, materials are not considered. ಹೌದಾ?
As of that day, investigation was under progress.
ಅವತ್ತಿನ ದಿವಸ ಅವ್ರು A2 ಬಗ್ಗೆ ಇವನ್ ಎಷ್ಟನೇ ಅವ್ನು A2 ನಾ? A2 ಬಗ್ಗೆ ನಾವೇನ್ ಡಿಸ್ಕಸ್ ಮಾಡಿರಲ್ಲ ಅದರಲ್ಲಿ.
Material available on record, investigation was going on. So the entire case papers were produced before this.
ಈಗ now charge sheet is filed.
Please.
Now you defend the charge sheet material. It is not a case for trial ಅಂತ ನಿಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕು ನೀವು ಹೇಳಿ.
Now there are two witnesses, my lord, CW 2 and 3, who they rely upon. Now these two witnesses have been examined as witness number 1 and 7 in the departmental inquiry. In the departmental inquiry, they've been examined. And only after examination of these two witnesses, the petitioner herein has been exonerated from the departmental inquiry.
Exonerate ಮಾಡಿದಾರಾ?
He has been exonerated. Now document, one of the contention that is taken by the respondents is that this is an independent investigation. But your lordship's order says this is nothing but a second FIR, therefore this cannot stand. Now may I request your lordships to kindly have a look at volume number 2 of the charge sheet which they have filed.
Volume number 2. ಹೇಳಿ ಪೇಜ್ ಏನು ಹೇಳಿ?
Volume number 2, document number 66, page number 242 to 303.
242 to 303.
242 to 303.
Page.
Page.
ಏನದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್?
That is document number 66 is the seizure and all the documents which have been obtained in crime number 63/2020.
ಇದು 63 ಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದ ಅಥವಾ ಕ್ರೈಮ್ ಬೇರೆನಾ?
ಇದು ACB crime, ಅದು ಕಾಟನ್ಪೇಟೆ ಪೊಲೀಸ್.
ಅದಾಯ್ತ್ರಿ. 5918 ಇದೆಯಲ್ಲ,
ಇದು ACB, not ಕಾಟನ್ಪೇಟೆ. This is ಲೋಕಾಯುಕ್ತ crime.
ಇದು ಲೋಕಾಯುಕ್ತ ಕೇಸ್.
ಲೋಕಾಯುಕ್ತ
ಹಾ
case.
ಆಯ್ತು. ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ಡಾಕ್ಯುಮೆಂಟ್ ಅದು.
Document 66 pertains to the state case.
ಸ್ಟೇಟ್ ಕೇಸ್ ಬಿಟ್ಬಿಡಿ ಈ ಕೇಸ್ ಇಂದ ಕೇಳಿ.
ಅಲ್ಲ ಈ ಕೇಸ್ ಅಲ್ಲಿ their entire seizure whatever they say
ಹಾ.
that CCTV footage ಇದೆ ಈ ತರ ಹೋಗಿ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ ಬಂದಿದ್ದಾರೆ. All these documents pertain to a seizure that is effected in crime 63 by the state police.
ಸ್ಟೇಟ್ ಕೇಸ್
By
ಅಲ್ಲಿ.
the state police.
Now they are relying upon the state case measure.
Please.
ಹೌದಾ?
State gate measure, state gate seizure, all these things have been
ಹಾ.
done in the state case.
ಆಯ್ತು.
That is document number 66, pages from 242 to 303, which indicates that your lordship's observation that this is a second FIR on the very same facts would hold water, and which runs contrary to their submission that this is an independent matter. We are doing independent investigation. That is one. Then document number 63, the lordship will find on page 224. Now, the entire contention of the respondents here is that the petitioner and other accused persons, the petitioner, in order to help one of the accused in crime number 164 of 2020 of Banaswadi police, made a demand for illegal gratification. Now, this document number 63, which runs from page 224 to 238, the petitioner here is not a witness. He is not the investigating officer, nor is he part of any raiding party. So their entire allegation that I was handling this matter, therefore I made a demand for illegal gratification in order to leave that person, would be without any basis.
Not a part of investigation.
I was not part of the investigating team, nor a witness, nor the IO. Therefore, question of me trying to influence or drop an accused in that case would not arise. Now, in addition to that, the statement which the other side relies upon is statement of CW18.
CW14 bank manager.
ಅಲ್ಲ ಅದೇ sir. Both have to be read together.
ಆಮೇಲೆ 2 ಲಕ್ಷ ಬ್ಯಾಂಕಿಗೆ ಹೋಗಿ ತಗೊಂಡ್ ಬಂದು
ಅವರು CW18 ಅವರು.
ಅವ್ನು CW18.
CW18.
ಹಾ ಅದಕ್ಕೇನ್ ಹೇಳ್ತೀರಾ ನೀವು?
ಅವರು may I request this court to kindly have a
He
look.
gave the money to particularly to this accused ಅಂತ ಹೇಳ್ತಾನಲ್ಲ ಅವನು.
CW14.
By drawing the money from the bank.
Please.
But now material corresponds with the evidence statement of bank manager.
Please.
And also the statement of CW18.
Please.
That he gave the money to you. What is your answer?
Now this, my lords, your lordship may have to go through the statement of CW14, which is at page 105. Now this CW14 is a bank manager who states at 105.
105.
CW14 is a bank manager who states at paragraph number 2 that some person came, he gave a check, and I've given the money to this person, and in order to verify, I have taken signature of this person on the check, on the back side of the check.
Backside
of the check.
But check ಯಾರಿಗೆ ಸೇರಿದ್ದದು?
Check belongs to, check is not belonging to any person. It is not that witness.
But check ಅಲ್ಲಿ ನಿಮ್ಮೊಂದು ಸಿಗ್ನೇಚರ್ ಇದೆ.
ಅವ್ರು ಯಾರು ವಿಡ್ರಾ ಮಾಡಕ್ ಹೋಗ್ತಾರೆ, ನೀನ್
ಅವನ ಸಿಗ್ನೇಚರ್
ನೀನ್ ಅಕೌಂಟ್ ಹೋಲ್ಡರ್ ಆಗಿದ್ದರಿಂದ ನಿನ್ನ ಸೈನ್ ತಗೊಂಡಿದೀನಿ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. Now this is the statement of CW14. Now that checks have been produced at page number 280 onwards. In none of these checks, there is any signature of the said witness form.
Accused ಇಲ್ಲ.
ಅಲ್ಲ ಅಕ್ಯೂಸ್ಡ್ ಅಲ್ವೇ ಅಲ್ಲ.
Petitioner ಇಲ್ಲ ಅಂತ.
Petitioner ಅಲ್ಲ. ಅವ್ರು ಯಾರು ಹೇಳ್ತಾರೆ ನಾನು ಹೋಗಿ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡು ಬಂದೆ, ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್ ಹೇಳ್ತಾರೆ ಯಾರು ವಿಡ್ರಾ ಮಾಡಕ್ ಬಂದಿದ್ರು ಅವ್ರು ಸಹಿ ಪಡೆದಿದ್ದೀನಿ ಹಿಂದೆಗಡೆ ಅಂತ. ಇದು ಯಾವುದೇ ಚೆಕ್ ಅಲ್ಲೂ ಯಾರ್ದು ಸಹಿ ಇಲ್ಲ ಹಿಂದೆಗಡೆ.
ಅಂದ್ರೆ ಈ CW18 ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ.
CW18 ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ.
ಇಲ್ಲ. ಅದನ್ನ ಯಾವಾಗ ನೋಡ್ಬೇಕು ಅದನ್ನ ಸಿಗ್ನೇಚರ್ ಒಂದು ಹೌದಾ ಅಲ್ವಾ ಅನ್ನೋದನ್ನ?
No, I understand. But I'm saying their only addition is this.
Okay.
Now that is apparent.
Sorry.
Now even these checks, these seizure of checks, which your lordship will find from page number 2.
Check ಯಾರಿಗೆ ಸೇರಿದ್ದದು?
Check belongs to CW2 and one of the two witnesses, CW2 and 3.
2 and 3 ನಲ್ಲಿ.
2 and 3, one of them. Now this.
Their case is that they sent the check through CW18 to make the payment in favor of your petitioner. and he withdrew the amount and handed over the same to your petitioner anta our case.
Their
CW2 ದು.
case is CW2 and 3 are involved in some other crime of Banaswadi police.
Crime ಆಯ್ತ್ರಿ, but ಇವ್ರಿಗೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕುವಾಗ
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ
their
ಅಂದ್ರೆ
statement that
no.
I gave the check to so and so person, that is CW18.
They do not state that. Their case is that, but the witnesses CW2 and 3 statement in the charge sheet also does not state that. In the departmental inquiry also, those two witnesses do not state that. The bank manager also does not state that. She says somebody came, I took their signature, gave them money. Now their
But
case
check
is,
belongs to whom?
check belongs to CW
2 na 3 na?
2. CW Shaji Thomas, CW
You said 5 minutes anta ಅದಕ್ಕೆ.
CW2.
You said 5 minutes ಅಂದ್ರೆ.
I'm done.
One case
Last
alla
two
ಇನ್ನು 5
submissions.
minutes.
Last two submissions. Belongs to CW2. CW2 does not state that. He is not told that in the departmental inquiry. Now this check does not bear signature of CW18, and even these checks which they have placed on record forms part of document number 66, which again goes back to crime number 63 of Cottonpete police, which is in consonance with your lordship's observation that it is a second FIR on the very same facts.
Well, how can we deny in the departmental inquiry that check was not given by him?
That, my lord, I have placed
once the amount was withdrawn from him,
I have placed
his account.
I have placed.
Have you challenged that exoneration order?
No.
No, my lords, that.
But here is a case of.
ಅದು ಲೋಕಾಯುಕ್ತ ಅವ್ರು ಬರಂಗಿಲ್ಲ, ಅವ್ರು ಇಂಟರ್ನಲ್ಲಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಇಟ್ ಇಸ್ ನಾಟ್
in the state.
ಸ್ಟೇಟ್ ಅಲ್ಲಿ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ನಮ್ ಲೋಕಾಯುಕ್ತ ಅಲ್ಲ ಅದು.
Departmental inquiry in the state.
Inquiry by the state within their own department. Not ಲೋಕಾಯುಕ್ತ. ಲೋಕಾಯುಕ್ತದ ಇದ್ರೆ we would have looked into it.
Next.
Now this statements of these witnesses I have also produced along with my application for amendment, which your lordship will find on page number 52 onwards.
Andre statement before the departmental inquiry na?
Inquiry.
Whether that can be looked into in a 482 petition?
My lords, one of the ground is that exoneration and departmental inquiry would also entitle me to the benefit of.
That is your ground.
That is one of the ground. Now that is if the material placed before departmental inquiry is different as that of the material placed by the police in the charge sheet, then that would not entitle me for the said benefit. But in this case, the same witnesses have been examined. Therefore, I urge this ground. Now that your lordship will find at page 52 of my amendment application and page 84 of my amendment.
The same grounds. Charge sheet ಹಾಕಿದ್ಮೇಲೆ ಹಾಕಿರೋ amendment.
ಅಷ್ಟೇ.
Amendment ಆದ್ಮೇಲೆ grounds. Amended petition ಹಾಕಿದಿರಿ.
Amended petition.
ಆಯ್ತು, next case.
This, my lord, is the first case.
But now that in our written arguments as regards a connected case, we have put a tabular column and said what are the evidences that is relied in departmental inquiry and what we are relying on criminal and how different they are.
That is you have filed.
In argument on tabular column ಮಾಡಿ ಹಾಕಿ ಮೂರಲ್ಲಿನೂ ಹಾಕ್ಬಿಡಿ.
ಹಾಕಿದಿರಾ?
ಹಾಕಿ ಯಾವ್ದು CCTV ಇದೆ, ಯಾವ್ದ್ರಲ್ಲಿ ಇಲ್ಲ, ಇದರಲ್ಲಿ ಏನ್ ಎಕ್ಸ್ಟ್ರಾ ಎವಿಡೆನ್ಸ್ ನಾವು ಲೀಡ್ ಮಾಡ್ತಾ ಇದ್ದೇವೆ ಅಂತ.
ನೆಕ್ಸ್ಟ್ ಕೇಸ್ ಹೇಳಿ ಅವ್ರು ನೋಡೋಣ.
Please.
6117.
6117 belongs to state police.
ಸ್ಟೇಟ್ ಯಾರ್ರಿ ನೀವಾ ಅಂತ ಹೇಳ್ತೀರಾ ನೀವು ಅದರಲ್ಲಿ?
Please, my lord.
ಹೇಳಿ. 6117.
Charge sheet has not been filed.
Not yet filed charge sheet.
Charge sheet is not filed and case as against accused number 1 has been quashed in criminal petition 2389/2020.
But now what are the materials against you?
No, my lord, there is no additional material. The same in this case, there is no statement or any other document that is placed. Insofar as the material available, the same witnesses have been examined.
What is the accusation against you in this case?
In this case, my lord, your lordship will find at page number 18 of the appeal. That is a FIR. It says, I along with accused number 1 and accused number 3 made a demand for illegal gratification. Now there is no seizure, there is no recovery, there is no document or statement to indicate there was any demand or acceptance from my end in respect of any illegal gratification in this case. In this case, there has been no seizure, there is no statement of witnesses, nothing, my lords. To indicate
Statement of witnesses ilva?
Statement of witnesses as against me, there is nothing.
Illa.
None against any. The only allegation was pertaining to accused number 1, and that is proceedings have been terminated insofar as accused number 1 is concerned. That is the second petition, my lord. Third petition.
Next, 6127. ಏನ್ ಮೇಡಮ್ ನಿಮ್ದೇನಿದೆ ಮೇಡಮ್ ಇದರಲ್ಲಿ? ಒಂದೇ ನಿಮಿಷ ಅವ್ರು ಹೇಳ್ಬಿಡ್ಲಿ. ಸ್ಟೇಟ್ ಆಯ್ತು. why you have not filed the charge sheet till date? It was the incident of 2020. ಲೋಕಾಯುಕ್ತ ಸಪರೇಟ್. ನಿಮ್ ಸ್ಟೇಟ್ನವ್ರು ಏನ್ ಮಾಡಿದ್ರಿ? It appears you are in hand in glove with the accused. ಯಾಕೆಂದ್ರೆ ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಎನ್ಕ್ವೈರಿ ನಲ್ಲಿ ಎಲ್ಲ exonerated. And also you have not investigated the matter for a period of 5 years. Incident was in the year 2020. Hoda? COVID period. Why you have not collected the material from last 5 years? No stay, nothing. 5 ವರ್ಷದ ಮೇಲೆ ಏನ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ತೀರಿ ನೀವು? ಈ ನಮ್ಮ 482 ಪಿಟಿಷನ್ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಸ್ಟೇ ಆಗ್ಬಿಟ್ರೆ ಅವು ಸತ್ತಂಗೆ ಅದು. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸ್ಟೇ ಆದ್ರೆ ಆ ಕೇಸ್ ಸತ್ತಂಗೆ. ಡಿಸ್ಪೋಸಲ್ ಆಗೋದು 7-8 ವರ್ಷ. ಆಮೇಲೆ ಏನು ಐಒ ಕಲೆಕ್ಟ್ ಮಾಡ್ತಾನೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ನಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ನ? ಅದೇ ಆಗ್ತಿರತ್ತಾನ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ. ಎಲ್ಲಾ ಕೇಸು ಅಷ್ಟೇ. ಸತ್ತವನು ಹೋದ, ಬದುಕಿದ್ದವನು ಇಲ್ಲಿ ಉಂಡಾಡಿಕೊಂಡಂಗಿದ್ದ, ಎಲ್ಲ ಅಷ್ಟೇ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಅಷ್ಟೇ. ಅವ್ನು ಐವೋ ಏನ್ ಮಾಡ್ತಾನ್ರಿ ಇನ್ನ ಮುಂದೆ? ನೀವು ಸ್ಟೇ ಇಲ್ದವ್ರೇನೆ ನೀವು ಮಾಡಲ್ಲ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ನ. ಏನ್ ವೆರಿಫೈ ಮಾಡೋದು ಮೇಡಮ್? ಹೌ ದಿ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇಸ್ ಫಂಕ್ಷನಿಂಗ್ ಅಂತ. ಅಂಡ್ ಆಲ್ಸೋ ಹೌ ದಿ ಕೋರ್ಟ್ಸ್ ಆರ್ ಫಂಕ್ಷನಿಂಗ್ ಅಂತ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ಸ್ ಅಲ್ಲ ಸ್ಟೇ. ಈ ಕೇಸ್ಗಳು 482 ಡಿಸ್ಪೋಸಲ್ ಆಗೋದು ಸಾವಿರಾರು ಇದಾವೆ, ಸ್ಟೇ ಆದವು. 7-8 ವರ್ಷ ಆದ್ಮೇಲೆ ಡಿಸ್ಪೋಸ್ ಆಗ್ತವೆ. ಆವಾಗ ಅಯ್ಯೋ ಏನ್ ಮಾಡ್ತಾನೆ? ವಾಟ್ ಮೆಟೀರಿಯಲ್ he can collect in the case? What will be impact on the society? Accused oriented justice, not victim oriented justice. Why you have not done the investigation from last 5 years? No stay. ಈ ಕೇಸಲ್ಲಿ ನಾವು ಸ್ಟೇ ಕೊಟ್ಟಿದ್ವಿ ಇಲ್ಲಲ್ಲ? ಮತ್ತೆ what you are doing? ಇಲ್ಲ ಕೇಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಕ್ವಾಶ್ ಮಾಡಾಕ್ಬಿಡೋದು ಅಷ್ಟೇ. ಏನಿಲ್ಲ, ಏನ್ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡಿ? You are not ready to investigate the matter and collect the material. ಈ ಕಂಪ್ಲೇನೆಂಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬಿಟ್ರೆ ಇನ್ನೇನು ಬೇರೆ ಇಲ್ವಾ ಇದರಲ್ಲಿ? ಚಾರ್ಜ್ ಶೀಟ್ ನಾಟ್ yet filed, madam. What material you have collected after the registration of the case?
Both the state FIRs, my lord. The allegation is insofar as accused number 1 is concerned. The allegation says demand was made by accused number 1, money was also received by accused number 1. That is the allegation. But as my learned senior friend pointed out, 25 ಲಕ್ಷ ತಗೊಂಡೋಗಿ DCP ಮುಂದೆ ಬ್ಯಾಗ್ ಅಲ್ಲಿ ಕೊಡ್ತಾರೆ ಅಂತೆಲ್ಲ, ಅದು ಎಲ್ಲೂನು A2 ಆಗ್ಲಿ A3 ಆಗ್ಲಿ ಅವ್ರ ಮೇಲೆ ಯಾವುದೇ ಅಲಿಗೇಷನ್ ಇಲ್ಲ.
ಆದ್ರೆ ಇವತ್ತಿನವರೆಗಿನೂ 25 ಲಕ್ಷ ಕ್ಯಾಶ್ ಇದೆ.
ಅಲ್ಲ
ಕ್ಯಾಶ್ ಇರೋದು
ಇದೆ ರೀ. ಬಟ್ who paid that amount?
ಅದ ಡಿಸಿಪ್ಲಿನ್ ಅದು ಪ್ರಿಲಿಮಿನರಿ ಎನ್ಕ್ವೈರಿ ಕಂಡಕ್ಟ್ ಮಾಡಿದಾಗ ನಮ್ಮ DCP ಅವರು, ಸ್ಟೇಟ್ ಪೊಲೀಸ್ ಅವರು ಆ ಪ್ರಿಲಿಮಿನರಿ ಇನ್ಕ್ವೈರಿ ಇಲ್ಲ ಪ್ಯಾರಾಗ್ರಾಫ್ ಎಲ್ಲ ಅವರೇ ಹೇಳ್ತಾರೆ ನಾವು ತಗೊಂಡಿದ್ದೇವೆ ನಾವು ತಂದು ನಿಮಗೆ ಕೊಡ್ತಾ ಇದ್ದೇವೆ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರೇ.
ಯಾರು ಹೇಳೋದು?
ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಪ್ರಿಲಿಮಿನರಿ ಇನ್ಕ್ವೈರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ.
ನೀವು ಸೆಲ್ಫ್ ಇನ್ಕ್ರಿಮಿನೇಷನ್ ರಿಲೈ ಮಾಡಬಹುದಾ?
ಅಲ್ಲ ಸೆಲ್ಫ್ ಇನ್ಕ್ರಿಮಿನೇಷನ್
ದಿ ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ ಹೌದಾ?
It's a preliminary inquiry, my lord.
It's not police report.
It is.
Then what value can be attached to that report?
Maybe there is no evidentiary value, my lords. Agreeable, but from out of thin air, 25 lakhs cannot come, my lords. And they give the bag and they candidly say we have received it in connection with this. Paragraph will not ಮಾಡಿದ್ದಾರೆ.
No, my lord, even as per their case, my friend is saying that accused number 1 tan ಕೊಟ್ರು ಅಂತ, but we have received ಅಂತ ಇದ್ದಾರೆ. There is no allegation against A2 and 3. It is against A1.
ಈ ಕೇಸ್ ಅಲ್ಲಿ ಏನು ಅದನ್ನ ಹೇಳಿ.
ಎಲ್ಲೂ ಇಲ್ಲ. A2 and 3 ಮೇಲೆ there is no recovery, there is no demand.
ನೀವು ಹೇಳ್ತಾ ಇರೋದು ಈಗ ಅಲ್ಲ
ಯಾಕಂದ್ರೆ ಅದನ್ನ ನಾನು
ಮಾಡಬೇಡಿ ಎಲ್ಲಾನು
ಮಿಕ್ಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ನಾನು
ಈ ಕೇಸ್ ಅಲ್ಲಿ ಏನು 6117 ಅಲ್ಲಿ
6
ಅದರಲ್ಲಿ ನಾವಿಲ್ಲ, ಬಟ್ ಆ ಪ್ರಿಲಿಮಿನರಿ ಇನ್ಕ್ವೈರಿ ಆಗಿದ್ದು ಅದರಲ್ಲಿ.
ದಟ್ ಇಸ್ ದಿ ಬೇಸಿಸ್.
ದಟ್ ಇಸ್ ದ ಬೇಸ್. ಯಾಕಂದ್ರೆ ಫಸ್ಟ್ ಆದ್ಮೇಲೆ ಒಬ್ರು jurisdictional DCP ಅಂಡರ್ ದ ಕಮಿಷನರ್
ಪೇಪರ್ಸ್ ಏನು ನೋಡಿಲ್ವಾ? Charge sheet ಆಯ್ತು ಮೇಡಮ್. What are the material to proceed against him? ಕ್ರಿಮಿನಲ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಸುಮ್ಮನೆ ಏನೋ ಒಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಮೇಲೆ ಕ್ರಿಮಿನಲ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. There must be some material to proceed against him. ಯಾರ ಅದರ್ ಅಕ್ಯೂಸ್ಡ್ ಹೇಳ್ದ ಅಂತೇಳಿ ಅವ್ನು ಕರ್ಕೊಂಡ್ಬಂದು ಇಲ್ಲಿ ಫಿಕ್ಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. There must be some material. ಕೋ ಅಕ್ಯೂಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮೇಲೆ ತಗೊಂಡ್ ಬಂದು ನಿಲ್ಸಕ್ಕಾಗಲ್ಲ. What are the materials? Otherwise it is a humiliation to an accused. Without any material, why he should face the trial in the absence of material? ನಿಮ್ಮ ಹತ್ರ ಏನು ಇಲ್ವಲ್ಲ ಮೇಡಮ್? ಹೋಗ್ಲಿ, ಏನ್ ಮಾಡಿದ್ರಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಫ್ರಮ್ ಲಾಸ್ಟ್ 5 years? ನಥಿಂಗ್. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಹೇಳ್ರಿ. ನೆಕ್ಸ್ಟ್ ಕೇಸ್ ನೀವು ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡು ಹೇಳ್ತೀರಾ ಮೆಟೀರಿಯಲ್? ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಬೇರೆ ನೆಕ್ಸ್ಟ್ ಕೇಸ್ 6127.
The third matter is whatever is collected in this case is what has been relied upon by the Lokayukta in the first matter.
ಇದು ಲೋಕಾಯುಕ್ತ ಕೇಸ್, ಸ್ಟೇಟ್ ಕೇಸ್.
State case, where whatever is collected in this case, only that has been relied upon by the Lokayukta. Their charge sheet basis comes out of this case.
ಅಂದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಯಾವ್ದು?
ಅದು ಯಾವ್ದು ಸೀಜರ್ ವಿಚ್ ಐ ಪಾಯಿಂಟೆಡ್ ಔಟ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್. ಸೀಜರ್ ಆಗಿದೆ, ಚೆಕ್ ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ, ಸಿಸಿಟಿವಿ ಸೀಸ್ ಮಾಡಿದ್ದಾರೆ,
ಚೆಕ್ ಸೀಸ್ ಆಗಿದೆ ಅಂತ.
ಅದೆಲ್ಲ ಈ ಕೇಸ್ ಅಲ್ಲಿ ಆಗಿದೆ.
ಅದನ್ನು ಇದನ್ನು ಸೇಮಾ?
ಸೇಮ್
ಅಂದ್ರೆ ಸಿಮಿಲರ್. 5198 ಏನಿದೆಯೋ ಅದೇನಾ?
The same seizure has been document has been placed in 5918. That is the reason your lordships have framed an opinion that it is nothing but a second FIR. The same statements of witnesses, same seizures, same documents. So serial number 1 and serial number 3.
ಆಯ್ತು, 2 ಆಯ್ತು. ಈಗ 6222 ನಲ್ಲಿ
22, my lords. This is same as that of serial number 2.
serial number 2 ಇದು ಸ್ಟೇಟಾ?
ಇಲ್ಲಿ ಇದು ಲೋಕಾಯುಕ್ತ ಅವರದು.
ಲೋಕಾಯುಕ್ತ.
This is the second FIR for serial number 2. Now in this
serial number 2 ಅಂತಂದ್ರೆ ಈಗ 6117 ಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ.
ಹೌದು, 6117 ಗೆ ಸಂಬಂಧಪಟ್ಟ. ಇದರಲ್ಲಿ I'll request your lordship to just take one document, that is a statement of objections filed by the respondent Lokayukta. Page number 67. 67 onwards. 67. This entire statement, they have placed statement of 2 witnesses on record. This entire statement does not make any allegation as against me. It only makes allegation as against accused number 1. That is the statement that runs from page number 67 to 69.
Not against A2 anta.
Not against A2.
Only against A1.
Only against A1. Then, my lord, the next statement. Your lordship will find at page 75 and 76. relevant portion at 76 para 2. May I just read out 2 lines? The only allegation ಅಲ್ಲ, ನನ್ನ ಹೆಸರು ಬರೋದು ಒಂದೇ ಕಡೆ. May I just read? ಅಲ್ಲಿ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಆದ ಅಜಯ್ ಮತ್ತು ನಿರಂಜನ್ ಕುಮಾರ್ ಅವರನ್ನು ಭೇಟಿಯಾದೆನು. ಸದರಿ ಪೊಲೀಸ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ಗಳು ನನಗೆ ITC ಸಿಗರೇಟ್ ಲಾಕ್ಡೌನ್ ಅವಧಿಯಲ್ಲೂ ಹೇಗೆ ದೊರೆಯುತ್ತಿದೆ ಎಂದು ಪ್ರಶ್ನಿಸಿದರು. ಅದಕ್ಕೆ ಲಾಕ್ಡೌನ್ ಇರುವುದರಿಂದ ನಾನು ಮನೆಯಲ್ಲಿದ್ದು ಈ ಬಗ್ಗೆ ನನಗೆ ಏನು ತಿಳಿದಿಲ್ಲ ಅಂತ ತಿಳಿಸಿದೆ. ಅದಕ್ಕೆ ಅವರು ಹೇಳಿಕೆ ನೀಡುವಂತೆ ತಿಳಿಸಿದ್ದು, ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಬಂದ ಪೊಲೀಸ್ ಕಾನ್ಸ್ಟೇಬಲ್ ಅವರೇ ನನ್ನ ಹೇಳಿಕೆಯನ್ನು ಕಂಪ್ಯೂಟರ್ನಲ್ಲಿ ಟೈಪ್ ಮಾಡಿದರು. I've inquired him. There is a statement which is recorded in accordance with law. These are the only 2 witnesses who speak in that case, and that too, none of these witnesses attribute any overt act against me or even remote allegations of demand of bribe. Only allegation is insofar as accused number 1 is concerned, not as against me. This, my lord, is the 4th petition. Now the last petition, that is pertains to crime number 23 of Lokayukta.
ಸ್ಟೇಟ್ ಎರಡೇ ಇರೋದಾ?
ಸ್ಟೇಟ್ ಎರಡೇ.
ಲೋಕಾಯುಕ್ತದ 3.
ಲೋಕಾಯುಕ್ತವ್ರದ್ದು 3 ಇದೆ. Insofar as this is concerned, your lordship's order in respect of accused number 1 would clearly read that this FIR has been registered only because this court had granted stay on the other FIRs. Just as a retaliatory measure to ensure that the petitioner and other accused persons are troubled, they have registered this FIR. That your lordship will find at para number 48.
ಇದ್ರಲ್ಲಿ ಏನು ಅಕ್ಯೂಸೇಷನ್ ಏನು?
ಇದರಲ್ಲಿ ಆಕ್ಚುಲಿ ಫಸ್ಟ್ FIR ಸ್ಟೇಟ್ ಪೊಲೀಸ್ ರಿಜಿಸ್ಟರ್ ಆಗುತ್ತೆ. ಆ ನಂತರ ACB ಅವರು ಸೇಮ್ FIR ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾರೆ. ಸೆಕೆಂಡ್ FIR ಸ್ಟೇಟ್ ಅವ್ರದ್ದು ರಿಜಿಸ್ಟರ್ ಆಗುತ್ತೆ. ಸೆಕೆಂಡ್ FIR ಸೇಮ್ ACB ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾರೆ. Your lordships would come to an opinion that it is nothing but a second FIR which is impermissible.
State case only extortion.
State case is extortion. Lokayukta case is in respect of illegal gratification. Now on 2 observations, the Lokayukta case is quashed, telling firstly second FIR which is impermissible under law, and 2, there is no demand or acceptance from either of the parties, therefore it would not stand. Now when all these matters have been stayed by this honorable court, just to ensure that the accused persons are again troubled, they register this fresh FIR which is a 5th petition. The date of registration of FIR is subsequent to the order of stay granted by this honorable court. That too after lapse of several months on the very same allegation. There is no fresh allegation. And there is a finding from this honorable court telling that it is nothing but in order to attack these persons this has been done. Now that observation has not been diluted or set aside.
That's all. Third. ನೀವೇನಾದ್ರು ಬೇರೆ ಹೇಳ್ತೀರಾ? ಓನ್ಲಿ ಸಿನಾಪ್ಸಿಸ್ ಸರ್.
ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದೀನಿ. I would only say, my lords, these are not retaliatory. They were for distinct separate offenses in all 4 of them. And my lords, there is an extortion case as against a public servant. Would that constitute extortion or a bribe under section 7 is a closely read issue. So there somewhere around, my lords, the facts would be intertwined is my respectful submission. And most important all, my lords, when my lords were pleased to entertain the quashment of accused number 1, all these material was not placed at before this honorable court is my respectful submission. My lords were ill-equipped to answer, and my lords were rather swayed on different considerations in terms of saying that there is interdepartmental rivalry which is leading to all of this. But whereas the underlying facts were, my lords, that there was explicit demand. There is a preliminary inquiry where the demand was clearly made out, money was seized, there are CCTV footages, not to mention various statements of not only the complainant but other people as well.
ಈಗ CCTV ಫುಟೇಜ್ ಅಲ್ಲಿ ಕೊಡ್ತಾ ಇರೋದು ದುಡ್ಡು ತಗೊಳ್ತಾ ಇರೋದು ಏನಾರು ಇದೆಯಾ?
ಇಲ್ಲ.
ಅವ್ರು ಬಂದಿರೋದಿದೆ, ಅವ್ರು ಬಂದಿರೋದು ಟೈಮಿಗೆ ಕೋರಿಲೇಟ್ ಆಗುತ್ತೆ. Now, my lords, the latest position of law after Neeraj Datta, it says that even in terms of circumstantial evidence, if we can prove demand and acceptance, the presumption of section 20 will kick in. Now, my respectful submission is, in the
But what
CC
is the prima facie material to proceed against them in a criminal case?
My lords, one is the seizure, two is the statements of the complainants.
Seizure?
Seizure of the cash
Hmm.
and statement of the complainants.
Hmm.
Sorry to
And,
interrupt.
and
my lord.
contextually,
Sorry, ಹೇಳಿ, ತಡೀರಿ.
Allah, contextually, if these are seen, my lords, it is COVID time. At that point in time, sale of cigarette was, sale per se was totally barred because of the lockdown as such. So all of this has to be seen in context is my respectful submission.
Told. Heard the petitioner's counsel in all the matters, and also the counsel appearing for the Lokayukta special PP, and counsel for the state seeks, ಎಷ್ಟು ಸಬೇಕು madam? Next week, seeks time and list this matter on next week, madam,
Matter is
26th.
before the trial court on 24th for framing of charge. May I request?
Charge frame ಆದ್ರೆ ಏನಾಗುತ್ತೆ? If it is quashed, everything will goes.
This time.
If it is not quashed, you have to face the trial. That's all. List this matter on 26th. ಅವ್ರನ್ನ ಕೇಳ್ದಲೆ ನಾನು ಆಟೋ ಬರೆಯಕ್ಕಾಗಲ್ಲ.
One submission, my lord, which my learned friend said, that the case rests on seizure and statements of witnesses. That seizure is also not from my end. That statements of witnesses also do not say I made any demand or I accepted any money. Both are against accused number one, not against me. Nor do they say I received it or I asked it to give to somebody, nothing against me.
But what about in first case?
In the first case also, my lord, they do
First case also
none
ಕೂಡ
of the,
ಅವನು
none of the
CW18, CW14 ಅಮೌಂಟ್ ನ ಬ್ಯಾಂಕ್ ಇಂದ ಡ್ರಾ ಮಾಡಿ ತಗೊಂಡೋಗಿ ತಗೊಂಡೋಗಿ ನಿಮ್ ಕೈಗೆ ಕೊಟ್ಟೆ ಅಂತ
ಅದ್ ಏನ್
ಹೇಳ್ತಾನಲ್ಲ ಅದು.
ಹೇಳ್ತಾರೆ? CW14 ಹೇಳ್ತಾರೆ, ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಯಾರೋ ಬಂದ್ರು ವಿಡ್ರಾ ಮಾಡಿದ್ರು. CW14 bank manager says
ಹೌದು.
somebody came withdrew money. CW18 says
Somebody ಅಲ್ಲ, he took the signature of the person
that
who
is
withdrew the
allegedly
money.
CW18. Now CW18 signature is not found. Two, CW18 does not say I took check from the witness, withdrew and gave it to accused.
That is matter of trial. ಈಗೆಲ್ಲ ನೋಡಕ್ಕಾಗಲ್ಲ ಅದನ್ನ
It does not
482
say.
ನಲ್ಲಿ.
That is my, that's the matter of trial is my submission.
ಅದರಲ್ಲಿ ಟ್ರಯಲ್
ಇವೆಲ್ಲ ನೀವು
ನೋಡೋಣ.
only
ಬೇರೆದ್ರಲ್ಲಿ ಏನಿದೆ ನೋಡೋಣ.
My lords, uncontroverted complaint averments if they do not make an offense as against him. Here is where specifically a statement ಇವ್ರು ಬಂದು ನನಗೆ ಕೇಳಿದ್ದಾರೆ ದುಡ್ಡು ಅಂತ.
Even otherwise, my lord, that becomes a second FIR, which is impermissible.
My lords, that's a written synopsis may be taken on.
ತಗೊಂಡಲ್ಲ. ಏನಾಯ್ತು ಮೇಡಮ್, ಏನ್ ಹೇಳಿದೆ ಮೇಡಮ್?
At the land council appearing for the petitioner in all the matters and also the council who appeared for Lokayukta.
Lokayukta, special PP, and also filed synopsis.
Please.
In all the cases.
All the cases.
In all the three cases.
All the
three cases. And counsel appearing for the state additional SPP seeks time. List this matter on 26/11.
Obliged, deeply.
List one. Pastoral matter, serial number 7.
ಯಾವ್ದೋ ಒಂದು ಕಾಂಪ್ರಮೈಸ್ ಅಂದ್ರಲ್ರಿ ಏನ ಫಸ್ಟ್ ಬಿಗಿನಿಂಗ್ ಅಲ್ಲಿ.
Serial number 12.
ಈಗ ಎಷ್ಟನೇ ಕರೆದ್ರಿ?
7, sir.
7. ಹಾ ಹೇಳಿ ಏನು?
List one, serial number 7.
Recall application filed by the appellant, my lordship.
ಹಾ ಏನಾಯ್ತು ಕಾಸ್ಟ್?
ಕೇಳಿದೆ 5,000 may be imposed, my lordship.
ಅದು ಆಯ್ತು, ಬೆಳಗ್ಗೆಲ್ಲ ಆಯ್ತು.
ಒಂದು ಡಿಫಾಲ್ಟ್ ಆಗಿರೋದು.
25,000 ಅಂತ ಕೇಳಿದ್ರಿ.
Myself has to pay.
ಆಯ್ತು, ದಟ್ಸ್ ಆಲ್. ಅಷ್ಟೇನಾ? ಬೆಳಿಗ್ಗೆ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದೀನಿ ಸಿಮಿಲರ್ ತಗೊಳ್ಳಿ. Order on A number 1 of 25 for recalling the order dated 13/12/10/25 and while dismissing the appeal, this court taken note of the several opportunities given to the appellant counsel to address the argument, and in spite of several opportunity did not utilize the said opportunity and now filed the application for recalling. Concurrent finding ಇದನ್ನು
Yes, my lordship. Or else ನಾಳೆ ಅಥವಾ ನಾಡಿದ್ದು ಹಾಕೊಳ್ಳಿ. ನಾನು senior ನ present.
concurrent finding on
Definitely, my lordship.
and the earlier this court taken note of at the time of dismissal that it is a concurrent finding, and when this court expressed that going to recall the order subject to the cost of rupees 25,000 and counsel took time to verify and make submission, and now makes the submission that cost of rupees 5,000 may be imposed, and having taken note of the proceedings which has been taken place before this court on several dates and in spite of opportunity is not utilized, recalled on cost of rupees 25,000 and the same is payable within 2 weeks from today. If cost is paid, list this matter on 8/12 If no cost is paid, the earlier order subsists.
No, my lordship. Appellant or poor
ನಿಮ್ಮದ್ ಮಾತ್ರ ಅಲ್ಲ ಮೇಡಮ್, ಇನ್ನೊಂದ್ ಕೇಸಲ್ಲೂ ಅದೇ ಮಾಡಿದೀನಿ, 25,000 ಹಾಕಿದೀನಿ ಕೊಡಿ. ನಿಮ್ದು ಆರ್ಡರ್ ನೋಡಿ, ನಾನು ಒನ್ ಟೈಮ್ 2ನೇ ಸರಿ 3ನೇ ಸರಿ ಯಾವಾಗ್ಲೂ ಡಿಸ್ಮಿಸ್ ಮಾಡೋದಿಲ್ಲ. ಮಾಡ್ಬೇಕಾದ್ರೆ ರೀಸನ್ಸ್ ಕೊಟ್ಟು ಮಾಡಿದೀನಿ, ಡೀಟೇಲ್ಡ್ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದೀನಿ, ಹಿಂದಿನ ಪ್ರೀವಿಯಸ್ ಅಕೇಶನ್ 2-3 ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ, ಆದ್ರೂ ನೀವು ಬಂದಿಲ್ಲ, ಡಿಸ್ಮಿಸ್ ಮಾಡಿದೀನಿ. ಡೀಟೇಲ್ಡ್ ಆರ್ಡರ್ ಇದೆ, ಮಾಡಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಹಳೆ ಆರ್ಡರ್ ಉಳಿಯುತ್ತೆ ಅಷ್ಟೇ. ನೆಕ್ಸ್ಟ್ 12 ಮೇಡಮ್.
12 ವೆಂಕಟಾಚಲಪತಿ ಎಸ್ಕೆ ಮಂಜುಳಾ ಎ.
ಇದೇನಾ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಅಂದ್ರಲ್ಲ, ಇದಾ ಕೊಡಿ. ಏನದು? ಓನರ್ PI granted confirmed.
ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ಸ್
ನಾ
ಅದ್ರಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಸದರ್ನ್ ಸೈಡ್ 5 ಅಡಿ ಅವ್ರದ್ದಿದೆ ಅಂತ ಇಟ್ ಹಸ್ ಬಿನ್ ಕನ್ಫರ್ಮ್ಡ್ ಅಂಡ್ ಡಿಕ್ಲೇರ್ಡ್ ದಿ ಇಂಜಂಕ್ಷನ್ ಹಸ್ ಬಿನ್.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಏನೀಗ?
ಸೆಟಲ್ಮೆಂಟ್ ಏನಪ್ಪಾ ಅಂತಂದ್ರೆ 5 ಅಡಿ ಜಾಗ ಅವ್ರದೇನೆ, ಯಾರ್ದು ಡಿಫೆಂಡೆಂಟ್ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇರೋದೇ ಜಾಗನೇ. 2 ಅಡಿ ಮಾತ್ರ ಅವ್ರು ಏನು ಫರ್ದರ್ ಏನಾದ್ರು ಬಿಟ್ಟು ಏನಾದ್ರು ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡ್ಕೋಬೇಕು ಅಂತಂದ್ರೆ 2 ಅಡಿ ಸೆಟ್ ಬ್ಯಾಕ್ ಬಿಟ್ಟು ಕಟ್ಕೋಬೇಕು, ಡೆವಲಪ್ ಮಾಡ್ಕೋಬೇಕು.
ಏನೋ ಇಲ್ಲಿದೆ, plaintiff has already removed the spouts kept towards the southern side of his house.
Please.
Same has been kept as per his convenience towards northern side of the property, and he has no objection to enjoy the property of defendant abutting to the property of the respondent. ಏನ್ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದ್ರೇನ್ರಿ ಏನಂತ? ಕಾಂಪ್ರಮೈಸ್ ಏನಂತ ಹೇಳಿದ್ರಿ ಹೇಳಿ, ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಲಿ. ಯಾರು ಕನ್ಸೆಂಟ್ ಕೊಡ್ತಾ ಇರೋದಾರು, ಯಾರ ಪರವಾಗಿ ಡಿಗ್ರಿ ಇರೋದು?
ಇವ್ರ ಪರವಾಗಿ.
ಯಜಮಾನ್ರೆ ಏನ್ ರಾಜಿ ಏನ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ?
ನಾವು ಅದೇ ಈ ಕಡೆಗೆ ಅವ್ರ ಸೈಟ್ ಇತ್ತು ಸರ್, ಈ ಕಡೆ ಪಕ್ಕಕ್ಕೆ ಈ ಕಡೆ ನಮ್ಮ ಸೈಟ್ ಇತ್ತು, ನಾವು ಈ ಕಡೆ ಮನೆ ಕಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀವಿ, ಆ ಕಡೆ ಸೈಟ್ ಐತಿ, ಅದಕ್ಕೆ ನಾವು ರೋಡ್ ಇಕ್ಕಿದ್ವಿ, ತಿರ್ಗಾ ಅದು ಕಿತ್ಕೊಂಡು ಈ ಕಡೆ ಸೈಡ್ಗೆ ನಾವು ನೀರ್ ಬಿಡಾಕ್ ಮಾಡ್ಕೊಂಡಿದ್ವಿ.
ನಿಮ್ ಪರವಾಗಿ
ನಮ್ ಲಾಯರ್
ಗೊತ್ತಾಯ್ತು, ನಿಮ್ ಪರವಾಗಿ ಕೇಸ್ ಇತ್ಯರ್ಥ ಆಗಿತ್ತಲ್ಲ?
ಆಯ್ತು, ಆಗಿತ್ತು ಸರ್.
ಆಗಿತ್ತು. ಈಗ ನೀವು 5 ಅಡಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಏನಾದ್ರು ಬಿಟ್ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ಅದೇ ಒಪ್ಪ ನಾವೆಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದ್ಬಿಟ್ಟಿದ್ದೀವಿ.
ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದ್ರಿ, ಏನ್ ಬಿಟ್ಕೊಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ ಕೇಳಿದ್ರು.
ಬಿಟ್ಕೊಡ್ತಾ ಇದ್ವಿ.
ಎಷ್ಟು ಬಿಟ್ಕೊಡ್ತಾ ಇದ್ದೀರಿ?
ಅದೇ ಅವ್ರಿಗೆ ಅವ್ರ ಸೈಟಿನ ಕಡೆಗೇನೆ ನಾನು ಕಡಿಮೆಲ್ಲ
ನೋಡ್ರಿ, ಅವ್ರಿಗೆ ಇವ್ರಿಗೆ ಅಂತಾರ ಅವರು.
ಇಲ್ಲ ಇಲ್ಲ ಸರ್, ಅವ್ರಿಗೆ ಗೊತ್ತಿದೆ. ಅಲ್ಲ ಈಗ unless parties understood the compromise. ಹೇಳಿ ಗೊತ್ತಿದೆ.
ನೀವು ಹೇಳಿದಿರಿ, ನೀವು ಹೇಳಿ
ಗೊತ್ತಾಗಕ್ಕೆ ಆಗ್ತಾ ಇಲ್ಲ ಪಾಪ.
5 ಅಡಿ ಬಿಟ್ಕೊಡ್ತಾ ಇದ್ವಿ.
ನೋಡ್ರಿ, plaintiff admitted there is no 5 feet space towards the southern side of his property and the appellant plaintiff is in possession and ಇದು plaintiff's ಇದು
appeal defendants.
ಮತ್ತೆ ಇಲ್ಲ ಹಂಗಂತ ಬರೀತೀರಿ, appellant plaintiff ಅಂತ ಇಲ್ಲಿ ಡಾಟ್ ಹಾಕ್ತೀರಿ.
ಐ ಆಮ್ ಸಾರಿ, defendants.
ಮತ್ತೆ ಹಿಂಗೆಲ್ಲ ಬರೆದ್ರೆ ಹೆಂಗ್ರಿ ಕಾಂಪ್ರಮೈಸ್ ಅಲ್ಲಿ?
Oversight.
Appellant plaintiff is in possession and enjoyment of the property abutting to the property of the respondent plaintiff ಅಂತ ಬರೀತೀರಿ.
Respondent plaintiff.
ಮತ್ತೆ ಇಲ್ಲಿ appellant plaintiff ಅಂತ ಮೇಲೆ ಬರ್ತಿದ್ದೀರಿ.
ಕರೆಕ್ಷನ್.
ಆಮೇಲೆ ಇಲ್ಲೇ ಬರೀತೀರಿ, appellant defendant has admitted has no objection to allow the respondent to use the southern side property. ಮತ್ತೆ ಇಲ್ಲಿ appellant plaintiff ಅಂತ ಬರೀತೀರಲ್ರಿ, ಫಾರ್ ಕ್ಲೀನಿಂಗ್ ಆಫ್ ವಾಲ್. ಇಲ್ಲ ಸರಿಯಾಗಿಲ್ಲ, ಇದು ಕರೆಕ್ಷನ್ ಮಾಡಿ ಫಸ್ಟ್. ತೊಗೊಳ್ಳಿ, ಒಂದ್ ಕಡೆ ಅಲ್ಲ ಎಲ್ಲಾ ಕಡೆ ಹಂಗೆ ಮಾಡಿದಿರಿ. appellant plaintiff ಕೂರ್ಸಿ ಅವ್ರಿಗೆಲ್ಲಾರು ಒಂದ್ ಕಡೆ. ಪಾಸ್ ಓವರ್ 22 Venkatesh Somareddy
22
partly allowed half share in item number 7, partly allowed 1/3 1 to 4 6 and 8 and 4 9 share. ಹೇಳ್ರಿ. ನಾಳೆಗೆ ಅಂತ ಇಲ್ಲ, ಈಗ ಮಾಡ್ತೀರಾ? ಬೆಳಗಿನ ಸರಿ ಪಾಸ್ ಓವರ್ ಮಾಡಿದೀವಿ, ಈಗ ಒಂದ್ ಸರಿ ಪಾಸ್ ಓವರ್.
ಸೀನಿಯರ್ ಇನ್ನೊಂದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ ಸರ್.
ಮತ್ತೆ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ಹೌ ಮೆನಿ ಟೈಮ್ಸ್ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಅರ್ಜೆಂಟ್ ದಿ ಮ್ಯಾಟರ್? ತೊಗೊಳ್ಳಿ. Appellant counsel sought pass over in the early morning and even at 3:50 also seeks for pass over and hence an urgent on cost of rupees 5,000. List this matter on 8/12. 8/12 ನಾವೆಲ್ಲ ಕೊಡ್ತಾ ಇರೋದು 5/12 ಮೇಡಮ್. 5/12
ರೆಡಿ ಮಿನಿಟ್ಸ್ ಪ್ಲೀಸ್.
ರೆಡಿ ಅಲ್ಲೇ ಇರಲಿ. ಅವತ್ತು ಬಂದು ಕಾಸ್ಟ್ ಇಸ್ ಪೇಯಬಲ್ ಇನ್ ದ ರಿಜಿಸ್ಟ್ರಿ ವಿತ್ ಇನ್ 1 week.
23,
Next.
Pallav R. P.N. Manmohan.
Plaintiff's appeal,
Hmm.
recurrent judgment and decrease.
Suit for injunction.
Suit for permanent and mandatory injunction.
Hmm.
Initially, the suit was filed for permanent injunction.
Hmm.
Later, my lord, the prayer, an additional relief was sought because
An additional relief ಏನು
mandatory injunction directing the defendant to hand over possession because it was stated in the plaint by way of amendment that during the pendency of the suit, the plaintiff was dispossessed of the property by the defendant.
Dispossessed whole extent or portion?
Whole
extent.
The disputed property is a basketball court, my lord. This
Club.
lies.
Club.
Plaintiff is club, my lord, recreational club. Defendant is Mysore University. But the disputed property lies, my lord, in between Oval Grounds and Cosmopolitan Club, a basketball ground. But the case of the plaintiff was that the property of the club, as well as this disputed properties, that is 3,510 square meters of land, that is where a basketball court is constructed, was given by the then Diwan of Mysore in the year 1895, and they are in continuous possession of the property, suitable property, and that Mysore University was interfering with the possession of the club, and therefore the suit was filed. Before that, my lord, what happened was,
Your Lordship, small submission, Your Lordship. Your Lordship, I received the copies today. If Your Lordship permit me.
ಇವತ್ತು ಕಾಪೀಸ್ ಕೊಟ್ರಾ?
ಅದು KVS ಅಲ್ಲಿ 90 days lapse ಆಗಿತ್ತು, ಹಾಗಾಗಿ ನಮ್ಗೆ ಅವಾಗ ನಾವು ಫೈಲಿಂಗ್
90 days lapse ಅಲ್ರಿ?
Your Lordship.
ನಿಮ್ ಕೇವೆಟ್ ಪೀರಿಯಡ್ lapse ಆಗ್ಬಿಟ್ಟಿದೆ.
No, KVT was tagged with the petition before.
ತೊಂದ್ರೆ ಇಲ್ಲ, ಕಾಪಿ ಕೊಟ್ಟಿದ್ರು.
ಟ್ಯಾಗ್ ಆಗಿದೆ, ಬಟ್ ನಿಮ್ ಪೀರಿಯಡ್ ಇದಾಗಿತ್ತು. ಆಯ್ತು ತೊಗೊಳ್ಳಿ. Counsel for the respondent submits that copy of the appeal memo is received today and seeks time and hence list this matter on 5/12.
25, Sachin B.S.
Payment of rent, ಏನಾಯ್ತ್ರಿ?
ಡೆಪಾಸಿಟ್ ಇದೆ ಅಂತ ಹೇಳಿ ಹೇಳ್ತಾರೆ. ಡೆಪಾಸಿಟ್ ಇದೆ ಅಂತ ಹೇಳಿ ಹೇಳ್ತಾರೆ. ಲಾಸ್ಟ್ ಡೆಪಾಸಿಟ್ ಐ ಥಿಂಕ್ ಇನ್ 22 ಮಾಡಿರು ಅಲ್ಲಿ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಡ್ರಾಫ್ಟಿನ
ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರೆ ಅವಾಗ?
ಅಲ್ಲ, ಡ್ರಾಫ್ಟಿನ ಜಿರಾಕ್ಸ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ರಿಸಿಟ್ ಆರ್ಡರ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಒಳ್ಳೆ ಇತ್ತು.
ಅಲ್ಲ ಆಯ್ತು, ಈಗ ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಆದ್ಮೇಲೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರ?
ಅಲ್ಲ, 22 2022 ಡೆಪಾಸಿಟ್.
ನಿಮ್ ಸೂಟ್ ಯಾವಾಗ ಆಗಿರೋದು?
ಸೂಟ್ ಅಲ್ಲ, ಈ ಅಪೀಲ್ ವಾಸ್ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಇನ್ 24.
ಯಾವ ಅಪೀಲ್ ರೀ
ಇದು? ಕೆಳಗಿನ ಕೋರ್ಟ್ನ ಅಪೀಲ್.
ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. ಈಗ ಡೆಪಾಸಿಟ್ ಎಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ?
ಕೆಳಗೆ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಮೇ ಬಿ ಅಟ್ ದ ಡೈರೆಕ್ಷನ್ ಆಫ್ ದಿ ಫಸ್ಟ್ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್. ಅದಕ್ಕೆ ಯಾವ ವರ್ಷದಲ್ಲಿ ಅಪೀಲ್? ಯಾವ
22 ಅಪೀಲ್ ಇಸ್
ಯಾವ ವರ್ಷದ್ದು?
ಅಪೀಲ್ ಇಸ್ ಇನ್ ದ ಇಯರ್ 2020 ಮಲ.
ಆಯ್ತು,
2023.
6 months ಟೈಮ್ ಕೊಟ್ರೆ ಎಷ್ಟು ಬಾಡಿಗೆ ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡ್ತೀರಿ ನೀವು?
ನಮ್ಗೆ ಏನಿಲ್ಲ, ತಾವು ಮಾಡಿದವಳು ನಮಗೆ
ಇಲ್ಲಿ ಬರ್ಲಿಲ್ಲ ಅವರು.
ವಿ ಆರ್ ನಾಟ್ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಇನ್ ದಿ ರೆಂಟ್.
ಯು ವಾಂಟ್ ಪೊಸೆಷನ್ ಅಷ್ಟೇ.
Because all the other tenants have vacated. Only this person is, you want to demolish it and.
Demolition and construction. ಇವರು ಸಚಿನ್ BS ಮತ್ತೊಂದ್ಸರಿ ಪಾಸ್ ಓವರ್ ಮಾಡಿ ನೋಡ್. ನಾ
32
ಸುಧೀಂದ್ರ ಎಸ್.
ನಾಗೇಶ್ ಎಸ್.
Tomorrow, my lord, senior is.
ಎಲ್ಲ ಡೇಟ್ ಗಿವನ್ ಮ್ಯಾಟರ್ಸ್ ರೀ. ನಾನೇನಿಲ್ಲ, ಇನ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದೀನಿ. 5,000 ಕಾಸ್ಟ್ ಹಾಕ್ತೀನಿ, ಕೊಡ್ತೀನಿ ಡೇಟ್ ಅಷ್ಟೇ.
Tomorrow.
Third, appellant counsel seeks time and counsel for the respondent is absent and hence list this matter on 5/12 adjourned on cost of rupees 5,000 payable at registry and same is payable within 1 week from today. ಯಾಕೆಂದ್ರೆ 2 ವಾರ ಕೊಟ್ರೆ ಕಟ್ಟೋದೇ ಇಲ್ಲ. 1 week ಅಲ್ಲಿ ಕಟ್ಟಿ ಮುಂದಿನ ಸರಿ 2 ವಾರ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿರ್ತಾರಲ್ಲ, ಅವತ್ತು ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
ಪಾಸ್ ಓವರ್.
ನೋ ಪಾಸ್ ಓವರ್ ಕೌನ್ಸಿಲ್. ನೆಕ್ಸ್ಟ್
34, ರೇವಣ್ಣ ಬಳ್ಳಾರಿ.
ರೇವಣ್ಣ ಬಳ್ಳಾರಿ.
Suit for partition and possession. Respondent number 1, my father.
Partition suit was dismissed. Partition suit was dismissed. Same is confirmed.
1/4 share ನಮಗೆ ಬರ್ಬೇಕು ಮೇಲೆ. ಅವರಲ್ಲಿ
1/4 ಬರ್ಬೇಕಿತ್ತು, ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ ಅದನ್ನ ಹೇಳಿ. ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ ಅದನ್ನ ಹೇಳಿ. ಯಾಕೆ ಕೊಡಲಿಲ್ಲ? 1/4 ಬರ್ಬೇಕಿತ್ತು, ಅದನ್ನ ಯಾಕೆ ಕೊಡ್ಲಿಲ್ಲ ಅನ್ನೋದು ರೀಸನ್ ಹೇಳಿ ಹಿಂದೆ.
Madam, ನಮ್
Divided
ತಾಯಿನ
and some of the properties purchased by this father and registered sale deed. Properties are already divided as per exhibit D13. On perusal of exhibit D13, Panchayat Parikat was effected between the sons and daughters of Nanjappa, who is the father of defendant number 1. The properties were already divided and allotted to their shares. Under this document, there is no reference about the plaintiff and his mother and Kath were also mutated in their names and they have acted upon partition deed.
ಚೀಟಿಂಗ್ ಮಾಡಿ ಮದ್ವೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಚೀಟಿಂಗ್ ಮಾಡಿ ನಮ್ ತಂದೆ ಮದುವೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಮತ್ತೆ ಫಸ್ಟ್ ವೈಫ್ ಇದ್ದಾಗ ಅವ್ನಿಗೆ ಹೇಳೇ ಇಲ್ಲ ಮೇಲೆ ಅದಕ್ಕೆ 1/4 ಶೇರ್ ನಮಗೆ ಬೇಕು.
ಆಲ್ರೆಡಿ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ ಅಂತಲ್ಲ ಮೇಡಮ್.
ಫಸ್ಟ್ ವೈಫ್ ಚಿಲ್ಡ್ರನ್ಸಿಗೆ ಪಾರ್ಟಿಷನ್ ಮಾಡಿದಾರೆ ಮೇಲೆ ನಮಗೆ ಕೊಟ್ಟಿಲ್ಲ.
ನೀವ್ ಯಾರು ಸೆಕೆಂಡ್ ವೈಫ್ ಮಕ್ಕಳ?
ಸೆಕೆಂಡ್ ವೈಫ್.
The plaintiff being illegitimate child is not entitled for share in the ancestral properties of defendant number 1, but he is entitled for a share in the separate property of defendant number 1. But the plaintiff has not produced any document to show that out of the suit schedule properties, any one of the property is the self-acquired property of defendant number 1. Defendant number 1 ಇನ್ನು ಇದಾರಾ?
Yes, ಮೇಲೆ. ಇದಾರೆ ಮೇಲೆ.
But even ancestral property ನಲ್ಲೂ ಅಪ್ಪನ ಶೇರ್ ಅಲ್ಲಿ ಬರ್ಲೇಬೇಕಲ್ಲ ಮಕ್ಕಳು. ಎರಡನೇ ಹೆಂಡತಿ ಮಕ್ಕಳು
ಹೇಳಿದಾರೆ ಮೇಲೆ ಎವಿಡೆನ್ಸ್ ಕ್ರಾಸ್ ಅಲ್ಲೆಲ್ಲ ಆ ತರಾನೇ ಹೇಳಿದಾರೆ. ಅವರು ಮತ್ತೆ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ ಮೇಲೆ. ಅವ್ರ ಹೈಸ್ಕೂಲ್ ಹೆಡ್ ಮಾಸ್ಟರ್ ಇದಾರೆ ಮೇಲೆ. ನಮಗೆ 1/4 ಶೇರ್.
D1 ಇದಾರಾ?
ಇದಾರೆ ಮೇಲೆ.
Still. Recent judgment of Supreme Court ತಗೊಳ್ಳಿ ರೇವಣ್ ಸಿದ್ದಯ್ಯ ಕೇಸು. What Supreme Court says when the issue was referred to the larger bench.
ಚೀಟಿಂಗ್ ಮಾಡಿ ಮದುವೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಮುಂದಿನ ಸರಿ ನೋಡ್ಕೊಂಡು ಓದ್ಕೊಂಡು ಬಂದು ಹೇಳಿ. ಆಯ್ತು. Appellant counsel seeks time list this matter on
25th
5/12.
25th ಆಗಿದೆ.
ಏನ್ ಮೇಡಮ್?
25th.
25th. ಯಾಕೆ 5/12 ನೀವು ಇರಲ್ವಾ? ಇರಲ್ಲ ಮೇಡಮ್? 25th ನಾವೆಲ್ಲ ಜಾಸ್ತಿ ಪೋಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ವಿ, ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ 5/12 ಬನ್ನಿ ಅವತ್ತು. ಇಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿ, ಏನಾದ್ರು ಡಿಫಿಕಲ್ಟಿ ಇದ್ರೆ ಹೇಳಿ. ಇಲ್ಲಲ್ಲ ಮಾತಾಡ್ರಿ.
25th ಗೆ ಬೇಕಿತ್ತು ಮೇಲೆ.
ಯಾಕೆ ಏನಾವತ್ತೇನು ಒಳ್ಳೆ ದಿವಸನಾ? 25th ಒಳ್ಳೆ ದಿವಸ ಏನ್ರಿ ಅದು? 25th ಮಂಗಳವಾರ. ಮಂಗಳವಾರ ಹೆಣ್ಮಕ್ಳಿಗೆ ಒಳ್ಳೆ ದಿನ ಅಂತ ಅದಕ್ಕ ಮೇಡಮ್?
ದೇವಿ ವಾರ.
5ನೇ ತಾರೀಕು ಇರಲ್ವಾ ನೀವು? ಇರ್ತಿರಲ್ವಾ? ಜಾಸ್ತಿ ದಿವಸ 3/11 ಇಲ್ಲ 3/12 ಅಷ್ಟೇ. 3/12 ನಾನು ಸಿಟ್ಟಿಂಗ್ ಮಾಡಲ್ಲ. ಏನೋ ಅಡ್ವೊಕೇಟ್ಸ್ ಡೇ ಅವತ್ತೇನೋ ಕರೆದವ್ರೆಲ್ಲ ಒಂದ್ ಕಡೆ. 5/12 ಆಗಲ್ವಾ? ಯಾಕೇನು? ಯಾಕೆಂದ್ರೆ ಒಳ್ಳೆ ದಿವಸ ಅಲ್ವೇನ್ರಿ 5/12? ಶುಕ್ರವಾರ ಒಳ್ಳೆ ದಿನ, ಮಂಗಳವಾರಕ್ಕಿಂತ ಒಳ್ಳೆ ದಿನ. ಆಯ್ತು 5/12. 35 Ravikumar BR.
Case Sanjay Kumar.
Appearing for appellant in this case, your lordship. When the NOC in the last date itself, your lordship. I've given the NOC in the last date itself. It is reflecting in my name only.
Where is the acknowledgement, madam? For having given NOC, where is the acknowledgement?
I have not filed in this, your lordship. I have not filed in this. I have given the NOC.
You have to file NOC acknowledgement, madam.
Sure, I'll file your lordship. I have intimated
last time ಏನಾಗಿದೆ ನೋಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ.
also.
Last time.
ಅಷ್ಟೇ ಇದೆ ತಗೊಳ್ಳಿ. Appellant counsel submits that NOC was given and counsel for the appellant is directed to produce the acknowledgement for handing over the papers to the appellant in the next date of hearing. ಯಾವತ್ತು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀರಿ?
Immediate, your lordship.
Immediate. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ ಮೇಡಮ್.
26/11.
26/11.
Grateful, your lordship.
36.
ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್?
ಈಗ ಇಲ್ಲ, your
ಮತ್ತೆ ತರ್ಸ್ಕೊಂಡು ಕೊಡ್ತೀರಾ?
Yes.
ಆಯ್ತು.
Great.
36 ವೈಕೆನ್ ಶರ್ಮಾ. Good for partition dismissed.
Dismissed.
ಹೇಳಿ.
And the appellate court is concurrent finding law. The original propositors was Chikkalinge Gowda. He has succeeded property and he had 2 wives, my lord. First wife is Siddhamma and second wife is Boramma.
ಜೊತೆಲ್ಲ ಎಡೆ ಬರ್ತಾವಲ್ಲ. ಆಯ್ತು ಹೇಳಿ, ಹೆಸರೇನು? ಚಿಕ್ಕ
ಸಿದ್ದಮ್ಮ
ಅಲ್ಲ, ಅವನ ಹೆಸರೇನು ಪ್ರಪೋಸಿಟರ್?
ಚಿಕ್ಕಲಿಂಗೇಗೌಡ.
ಚಿಕ್ಕಲಿಂಗೇಗೌಡ.
He had two wives. One is Siddhamma
ಸಿದ್ದಮ್ಮ
and second wife is Boramma.
ಬೋರಮ್ಮ. ಸಿದ್ದಮ್ಮನಿಗೆ ಎಷ್ಟು ಮಕ್ಳು?
ಸಿದ್ದಮ್ಮನೆ ಮೂರು ಮಕ್ಕಳು. ಚಿಕ್ಕ ರಾಚೇಗೌಡ,
ಹಾ.
ಸಿದ್ದೇ two children.
ಸೆಕೆಂಡ್ ವೈಫಿಗೆ ಎಷ್ಟು?
ಸೆಕೆಂಡ್ ವೈಫಿಗೆ six children.
ಆರು.
ಅವರೊಳಗಡೆ ಇರುವ ಪಾರ್ಟಿಷನ್ ಸೂಟ್ ಇದು. This is a suit between those 6 children.
ಆಯ್ತ್ರಿ, ಅವ್ರಿಗೆ 6 ಜನ ಮಕ್ಳ?
ಹೌದೌದು, 6 ಮಂದಿ ಮಕ್ಕಳು.
ಇವ್ರಿಗೆ 3, ಅವ್ರಿಗೆ 6.
ಹೌದು. There was a partition between the first wife and second wife.
Already partition ಆಗಿತ್ತು. ಆಯ್ತು.
And in respect of that, the property is allotted to the share of second wife. For that,
now interest
between them.
Between the second wife
and children.
Second wife ಇದಾರಾ?
ಇದ್ದಾರೆ. ಅಲ್ಲ, ಈಗ ತೀರೋಗಿದ್ದಾರೆ. After filing the suit, she is the defendant number 1.
ಆಯ್ತು.
She was the defendant number 1, Milord.
ಆಯ್ತು. D1 ಅಂತ ಅವ್ರನ್ನ ಮದರ್ನ D1 ಮಾಡಿದ್ರು. ಸೂಟ್ ಹಾಕ್ತವ್ರು ಯಾರು?
ಸೂಟ್ ಹಾಕಿದ್ದು some of the sons. Except one son.
Except one son.
He is second defendant. And remaining
ತಾಯಿ ಮತ್ತೆ D2 ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ.
ಹೌದು.
ಈ 5 ಜನ ಮಕ್ಕಳು ಒಟ್ಟಿಗೆ ಪ್ಲೇಂಟಿಫ್ಸ್.
4 ಮಂದಿ. ಒಬ್ರು ಇನ್ನೊಬ್ರನ್ನು ಥರ್ಡ್ ಡಿಫೆಂಡ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ, ಡಾಟರ್ ಅನ್ನು ಗೌರಮ್ಮ.
D2 D3 ಇದ್ದಾರೆ.
ಇದ್ದಾರೆ ಗೌರಮ್ಮ. She is D3.
ಅಲ್ಲಿ 4 ಜನ ಪ್ಲೇಂಟಿಫ್ಸ್.
ಹೌದು.
ಸೆಕೆಂಡ್ ವೈಫ್ ಮಕ್ಕಳು.
ಹೌದು.
ಯಾಕೆ ಸೂಟ್ ಆಗಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದು?
Suit dismissed. The trial court said that is the whatever property succeeded by the mother, because Kata has been made in her name. Whatever property succeeded by her, that becomes her absolute property under section 14.
But she succeeded the property of her husband. Chikkalingegodan property nadu.
ಹೌದು. ಚಿಕ್ಕಲಿಂಗೇಗೌಡ purchased item number 1 under registered sale deed dated 9/4/1964. Then
ಏನಾರು ವಿಲ್ ಇದೆಯಾ ಸೆಕೆಂಡ್ ವೈಫ್ ಗೆ?
ಇಲ್ಲ.
ಟೆಸ್ಟಮೆಂಟರಿ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆಯಾ ಅಥವಾ?
ಇಲ್ಲ. He died intestate. After that, the first wife and her children have executed a release deed. All of them have succeeded the property. Then they have executed a release deed in favor of defendant number 1.
First wife and children have executed a release deed in favor of the
defendant number 1.
Defendant number 1 mother. She is the second wife of the Chikkalingegoda.
That's why the learned judge said that it is an absolute property of her.
ರಿಲೀಸ್ ಡೀಡ್ ಏನು ಹಾಕಿದೀರಾ ನೀವು?
ಹಾಕಿದೀವಿ.
ಕೋರ್ಟ್ ಮುಂದೆ
ಹಾಕಿದೀವಿ.
ಯಾವ್ದು ಡಾಕ್ಯುಮೆಂಟ್?
That is, there is no dispute regarding that. Even defendant also said
relinquishment deed dated 30/10/2006. ಏನೋ ಒಂದು ಗಿಫ್ಟ್ ಡೀಡ್ ಇದೆಯಲ್ಲ, ಅದೇನೋ?
ಇಲ್ಲ, ಅದರ ನಂತರ that defendant number 1 has gifted that property to defendant number 2.
Only in favor of one of the son.
Yes.
And that means your contention is that she was not having any absolute right to give the property in favor of so and so. First appellate court
it's a joint family property ಅಂತ ಹೇಳಿಬಿಟ್ಟು there was no proper pleading ಅಂತ ಹೇಳಿಬಿಟ್ಟು dismiss ಮಾಡಿದ್ರು first appellate court. It's a joint family property and defendant number 2 has taken a contention that some of the properties have been sold. And he has not been allotted any share.
Issue notice and call for records.
And intimate he shall not sell the property, my lord. Defendant number 2 shall not sell the property. Intimate ಅಷ್ಟೇ ಕೇಳ್ತಾರೆ.
ಗಿಫ್ಟ್ ಇರೋದ್ರಿಂದ.
Not
A number 1/25 wherein prayer is sought not to alienate the property against the defendant number 2, that based on the gift deed exhibit D2 nado exhibit D2 not to sell the property further. And having taken note of the grounds which have been urged in the second appeal and also the contention that making an attempt to sell the property, defendant number 2 is restrained from alienating the property till the next date of hearing. Issue notice and call for records. List this matter on 17/12.
37 Ramesh Kya.
Applied in this matter. Now the suit for partition, there is a delay of 2 days in filing this appeal. But one of these joint family property is not included and telkondo suit has been dismissed.
Not ನೀವು ಸೇರಿಸಬೇಕಲ್ಲ, you cannot seek for partial partition.
We will file necessary application.
ಹೋಗ್ಲಿ, ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಎಲ್ಲಾರು ಹಾಕಿದ್ರಾ?
ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ ಸರ್. ಈಗ now we are
ಅಲ್ಲೂ ಹಾಕ್ಲಿಲ್ಲ. ಈಗ ಇಲ್ಲ ಹಾಕಿದೀರಾ?
ಹಾಕ್ಬೇಕು ಸರ್.
ಇಲ್ಲೂ ಹಾಕಿಲ್ಲ.
ಇಂಟಿಮೇಟ್ ಅದನ್ನ ಅದ್ರ ಡೀಟೇಲ್ಸ್ ಕೊಡಕ್ ಹೇಳಿದೆ
ಮತ್ತೇನ್ರಿ ಇದು?
ಅದನ್ನ ಇನ್ಕ್ಲೂಡ್ ಮಾಡ್ತೀವಿ ಸರ್. Your Lordship may kindly peruse. ಇದರಲ್ಲಿ ಪೇಜ್ 52 my lord, the trial court ಅಲ್ಲಿ para 25 my lord, page 58 of the trial court order.
Para 24, 25 ಅದೇ observation.
I'll
You
include-
cannot seek for partial partition.
I'll include that also, the details.
Appellant counsel seeks time. This matter on 8/12, 5/12. ಅಷ್ಟ್ರೊಳಗೆ ಅದೇನಾದ್ರು ಸಾಕೋಂಗಿದ್ರೆ
Please.
ಇನ್ನೊಂದು ರೌಂಡ್ ಲಿಟಿಗೇಷನ್ ಬೇಡ ಅಂತ
Please.
ರಿಮೈಂಡ್ ಮಾಡೋಣ at the cost of you because you have not produced the documents.
38 PX with Virupaksaya.
Dismiss, reversed.
Defendant.
Call for records, issue notice. List this matter on 17/12. 39.
Lord, in this matter, I appear for the respondent. I seek for a short adjournment my lord, by
By
2 days.
counsel half share ಅವ್ರು ಹೇಳ್ಬೇಕು. ಹಾಫ್ ಶೇರ್ ಗ್ರಾಂಟ್ ಆಗಿದೆ, ಕನ್ಫರ್ಮ್ ಆಗಿದೆ. ನೀವ್ ಹೇಳಿ, ನಿಮ್ಗೆ ಏನಾದ್ರು ಅವಶ್ಯಕತೆ ಇದ್ರೆ ಕೊಡ್ತೀನಿ ಟೈಮ್.
Defendant's appeal.
ಹಾ.
My lord, the appellant's husband by name C.N. Anjana Reddy has expired in the year 1997. My lord, 1997.
Appellant husband.
Anjana Reddy. My lord, he was working in the health department. He was died in an accident. Appellant has got the money from the accident claims tribunal and also the death benefit of Anjana Reddy. She has purchased the property in her name along with the name of the respondent, plaintiff, for the reason that the respondent was living with the plaintiff. ಇದು ಎರಡೇ living relationship.
ಓ, ಇನ್ನೊಬ್ರು
Appellant has a husband by name Anjana Reddy. She had a son through first wife. First husband. First husband. ಅದನ್ನ ಅಭ್ಯಾಸ. First husband. She got a death benefits and also the compensation from the claims tribunal. Thereafter, she was living with the plaintiff.
Plaintiff ಯಾರು ಬೇರೆಯವ್ರು ಹಾಗಾರೆ?
ಅವ್ರಿಗೆ ಒಂದು ಮಗು ಇದೆ, ಹೆಣ್ಣು ಮಗು ಇದೆ. ಎರಡು ಮಕ್ಕಳು ಪ್ಲೇಂಟಿಫ್ ಜೊತೆಗೆ ಇದ್ದಾರೆ. ಡಿಫೆಂಡೆಂಟ್ ಜೊತೆಗೆ ಇದ್ದಾರೆ, ಅಪಲೆಂಟ್ ಜೊತೆಗೆ.
ಅಂದ್ರೆ ಈಕೆಗೆ ಫಸ್ಟ್ ಹಸ್ಬೆಂಡ್ ಮಗು ಮತ್ತೆ ಈ
ಲಿವಿಂಗ್ ಟುಗೆದರ್ ಅಲ್ಲಿ ಇದ್ದಂತ ಹೆಣ್ಣು ಮಗು
ಒಂದು ಆಯ್ತು.
ಎರಡು ಕೂಡ ದೇ ಆರ್ ವಿತ್ ದಿ ಡಿಫೆಂಡೆಂಟ್.
ಆಯ್ತು.
Since they are living in living relationship, to maintain the harmonious relationship, a property was purchased in the joint name of plaintiff and defendant.
ಓ, ಇಬ್ರಸ್ರಲ್ಲೂ.
My contention is there is no contribution from the plaintiff. So we have produced the agreement, my lord, exhibit P2, P1, wherein we have produced even the plaintiff himself.
Now ಈಗ ಲಿವಿಂಗ್ ರಿಲೇಶನ್ಶಿಪ್ is not in good terms.
Now it may not be in good terms, otherwise this suit might have been not filed. My lord, exhibit P9 may kindly peruse for this reason. Consideration amount is rupees 7,50,000. 7,50,000. 1 lakh amount was paid by cash. There is a dispute with respect to cash. Defendant claims that she paid the cash. Plaintiff claims that he paid the cash. But as far as the other considerations, remaining amount of 600 odd amount is concerned, 3,44,093 has been transferred directly by the defendant to the vendor. Since vendor has raised a loan in one of the cooperative society, this amount has been directly transferred by the defendant. On 21/12/2005, the remaining 3 lakh amount has been transferred by the defendant to the vendor. So
ಅದು ಹೇಗೆ?
By account transfer.
ಅದು through account ಏನಾ?
Account. Through check dated.
According to you, the total almost
3,44,093 has been directly transferred.
Plus.
3 plus 3, 6,44,093. So there is no contribution. Even my lord says that this defendant has raised a loan. Even today, she is paying the loan installment. The plaintiff is not paying any loan installment. There is no contribution. It is not a joint family property. Only to maintain the relationship with the plaintiff, this property was purchased in the joint name. So documents needs to be called, my lord, document needs to be examined. Only contention raised by reasons assigned by the courts below is, my lord. They are living together, hence they have purchased the property jointly. So under these circumstances, my lord, this document exhibit P9 marked by the plaintiff and also the exhibit P1, the sale deed, needs to be reconsidered and reappreciated. Even I have produced the exhibit D8.
ವೆಂಡರ್ ನ ಕರೆದು ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ರ?
ಇಲ್ಲ,
1 ಲಕ್ಷ ಅಮೌಂಟ್ ಇತ್ತಲ್ಲ?
ಇಲ್ಲ, ಅದು ಮಾಡಿಲ್ಲ.
Who paid that amount ಅಂತ?
ಇಲ್ಲ, ಅದನ್ನ ಮಾಡಿಲ್ಲ.
ಅದ್ ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ?
Even plaintiff has also not made. Even
ನೀವು ಮಾಡ್ಲಿಲ್ಲ, ಅವರು ಮಾಡ್ಲಿಲ್ಲ.
Page number 50.
Call for records. 6 ಲಕ್ಷ ಚಿಲ್ಲರೆ ಅವ್ರ ಕಡೆಯಿಂದಲ್ಲ ಡೈರೆಕ್ಟ್ ಹೋಗಿದ್ಯಾ?
ಇಲ್ಲ, ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್ ಕ್ಯಾಶ್ ಅಲ್ಲೂ ಇವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ 3 ಲಕ್ಷ. ಅಪಾರ್ಟ್ ಫ್ರಮ್ ದಟ್
ಹೇಳ್ತಾರ ಪ್ರಕಾರ 3,44,000 ಡೈರೆಕ್ಟ್ಲಿ ಪೇಡ್ ಟು ದಿ ಅಕೌಂಟ್ ಆಫ್ ದಿ ಲೋನ್ ಆಫ್ ದಿ ವೆಂಡರ್. And another 3 lakhs was paid by way of the bank transaction. Total 6,44,000 was paid by him. Now only dispute is only with regard to the 1 lakh is concerned. That who has paid that amount ಅಂತ ನೋಡ್ಬೇಕು. Records ಬರ್ಲಿ. Call for records. ಇನ್ಯಾರು ಇಲ್ಲಲ್ಲ, ಒಬ್ರೇ ಅಲ್ಲ? List this matter on 8/12. ಅಲ್ಲ 17/12. Records ತುಮಕೂರಿಂದ ಬರ್ಬೇಕಾ? ಆ ಮಧ್ಯದಲ್ಲಿ ಹಾಕೋದಾರ ಹಾಕಿ. 8/12.
40. Srinivas DS.
Sale deed null and void, confirmed. Permanent injunction granted, reversed.
Reversed, my lord. Appeal, concurrent filing in regard to cancellation and declaration, my lord. Reversed in favor of injunction.
Only permanent injunction is concerned. Only permanent injunction is concerned.
Yes, my lord.
Sale deed null and void is.
My lord, the only ground which the trial court comes to the conclusion that I have not produced, my lord, I am defendant number 4. I'm in an appeal, my lord, I am the subsequent purchaser. Kindly see parat 13, my lord, where the trial court comes to the conclusion that exhibit D24, certified copy of the sale deed, executed in favor of one Mada, is not been produced, my lord. My lord, EC, my lord, is being produced before the trial court. I request to produce these documents, my lord. EC is being produced. ECP 5025, my lord, is the encumbrance certificate which reflects the sale deeds, my lord. The trial court comes to the conclusion that the sale deeds are not being produced.
Sale is not in?
Sale deeds are not being, plaintiffs, defendant sale deeds are not being produced. That is one 1916 sale deed and a 1925 sale deed, my lord. Subsequently, 1950 plaintiffs have got a sale deed executed, my lord, for the same property.
You have purchased the property in which
in
year?
2010, I purchased, my vendors have purchased in the year 2016 and 25, my lord. 2 different sale deeds. PODs have been done. My lord, now the trial court does not consider the POD which have been done.
Issue notice and call for records.
Much of it, my lord. May I request for a stay, my lord? They are trying to alienate the property, my lord.
Yen stay?
Stay for not to.
Then INA involved?
Lord, IA ಇದೆ.
IA ಇದೆಯಾ? ತೋರ್ಸೇ ಇಲ್ಲ?
Sorry, then I'm not filing.
ಇದೆಯಾ ಮೇಡಮ್? ಇಲ್ಲ.
IA ಇಲ್ಲ ಸರ್.
This matter on 17/12 record ಬರ್ಲಿ. 41.
41.
Limitation rejected on the ground of delay.
Delay, my lord.
Delay of
342 days, my lord. There was delay, my lord, in filing the appeal before the London First Appellate Court, my lord. Suit, my lord, was filed by the plaintiffs, my lord, seeking the relief of declaration and possession, my lord, in respect of the suit scheduled property. My lord, the plaintiffs appellants, my lord, contended that the suit scheduled property, my lord.
Why there was a delay?
My lord, since there were several, my lord, in the affidavit, my lord, I have only narrated, my lord, stating that since there were several appellants, my lord, all the appellants could not come together and give instructions to the council, my lord, to file the appeal.
Is it a ground?
And my lords, few of the appellants, my lord, who are aged over and above 50 years, my lord.
Suit also dismissed. Suit also dismissed on that.
Suit, please, my lord. Suit, my lords, seeking the relief of declaration and possession, my lord, in respect of the suit scheduled property was dismissed, my lord. My lord, the suit scheduled property, my lord, was the property, my lord, owned by the father of the plaintiffs, my lord. After the death of the father, my lord, the khata came to be entered in the mother's name.
ನಿಮ್ admission ನೋಡ್ರಿ evidence ಅಲ್ಲಿ. When you have been examined before the appellate court
Please.
as PW1, ನನ್ನ ಮೊಬೈಲ್ ಅಂಗಡಿ ಈ ನ್ಯಾಯಾಲಯದ ಎದುರುಗಡೆ ಇದೆ ಎಂದರೆ
Lord,
ಸರಿ.
the sixth appellant, my lord, is my lord.
ಕೋರ್ಟ್ ಮುಂದ್ಗಡೆಲ್ಲ ಇದೆ ನಿಮ್ ಮೊಬೈಲ್
My
ಅಂಗಡಿ.
lord, he has a shop, my
ಈ
lord.
ಪ್ರಕರಣಕ್ಕೆ ಮಾಹಿತಿಯನ್ನು ಎಲ್ಲ ಅಪೀಲದಾರರು ಸೇರಿ ಕೊಟ್ಟಿದ್ದೇವೆ.
ಹೌದು.
ಅಪೀಲ್ ನಲ್ಲಿ ತಿಳಿಸಿರುವ ವಯಸ್ಸು ವಿಳಾಸ ಎಲ್ಲವೂ ಸರಿಯಾಗಿದೆ. ಪೆರ್ಮೇನಹಳ್ಳಿಯಲ್ಲಿ ವ್ಯಾಪ್ತಿ 1 ಕಿಲೋಮೀಟರ್ ಇರಬಹುದು. ಅಪೀಲುದಾರರ ಎಲ್ಲರ ವಯಸ್ಸು 50ರ ಒಳಗೆ ಇದೆ. ನಮ್ಮ ಎಲ್ಲರ ಆರೋಗ್ಯ ಸ್ಥಿತಿ ಚೆನ್ನಾಗಿದೆ ಎಂದರೆ ಸರಿ. ಮತ್ತೆ ಕೋರ್ಟ್ ಎದುರುಗಡೆ ಇದೀರಿ ನೀವು.
It is admitted, my lord, he is running a mobile shop, my lord, just in front of the court premises. My lord, the only reason, my lord, for the delay.
All of them hale and healthy.
There was delay, my lord, of 342 days.
ಏನಕ್ಕೆ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಿ ಅದಕ್ಕೆ.
My lord, in the affidavit, it was only narrated, my lords, that all of them could not, my lords, come together, my lord, and give instructions to the council, my lord, to file the appeal.
ಬಟ್ ಎಲ್ಲರೂ ಸೇರಿ ಕೊಟ್ಟಿದ್ದೀವಿ ಒಟ್ಟಿಗೆ ಅಂತ ನಿಮ್ಮ ಅಡ್ಮಿಷನ್
ಅಲ್ಲ ಅದು ಅದಕ್ಕೋಸ್ಕರನೇ
ದಟ್ ಈಸ್ ಅಗೇನ್ಸ್ಟ್ ಯುವರ್ ಓನ್ ಗವರ್ನಮೆಂಟ್ಸ್.
ಇಲ್ಲ ಅದಕ್ಕೋಸ್ಕರನೇ ಜೊತೆಗೆ ಬಂದು ಬೇಗ ಬರ್ಲಿಕ್ಕೆ ಆಗಲಿಲ್ಲ ಅಂತ ನನಗೆ ಡಿಲೇ ಆಗಿತ್ತು ಅಂತ. ದಟ್ ವಾಸ್ ದಿ ರೀಸನ್, my lord. The suit is for the relief of declaration.
ಏನಕ್ಕೆ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು? ರೀಸನ್ ಏನು?
My lord, I had failed to prove, my lord, the relationship. My lord, page 41, my lord. Page 17, my lords, of the London trial court judgment.
Trial court alla.
Please. Para 23, my lord.
Even ignoring the said documents, what is pertinent to note is that plaintiffs have not produced a single document like voter ID card, birth certificate or any other documents to substantiate the name of the father of the Gauri Bai and Ganga Bai is Manya Naika. It is pertinent to note that in the entire proceedings, the plaintiffs have contended that husband of Gujra is Manya Naika, whereas in the cross-examination DW1 for the first time, the plaintiff counsel suggests that Girija Gujrabai married Manya Naika, and after the death of Manya Naika, she married Bhima Naika. In such circumstances, though it is well at principle of that no evidence can be go beyond the pleadings, the burden is on the plaintiff to prove that the plaintiffs 1 and 2 were born to Manya Naika. To prove the same, plaintiffs have produced exhibit P3, which reflects that Gujrai Bai is the wife of Bhima Naika. ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿರೋದೆಲ್ಲ ನಿಮ್ ಎಗನೆಸ್ಟ್ ಇದೆಯಲ್ರಿ?
My lord, in fact, my lord, the defendant, my lord, in the written statement, had not denied, my lord, the relationship. My lord, however, the trial court holds, my lord, that the weakness of the defendant, my lord, cannot come to the aid of the plaintiff, my lord. Only on the ground, my lord, that few documents, my lord, such as voter ID card and also birth certificate are not produced, my lord.
ಬಟ್ ಏನು ಕೊಟ್ಟೆ ಇಲ್ವಾ? ನೀವೇನ್ ಕೊಟ್ಟಿದ್ದೀರಿ?
My lord, in fact, the relationship itself.
ಚಿಲ್ಡ್ರನ್ ಆಫ್ ಮಾನ್ಯ ನಾಯಕ ಅಂತ ತೋರ್ಸಕ್ಕೆ
ಅಲ್ಲ, my lord,
ಏನ್ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ? ಅದ್ರ ಬದಲು ನಿಮ್ ತಂದೆ ಹೆಸರು ಬೇರೆ ಕಡೆ ಬೇರೆ ಭೀಮಾ ನಾಯಕ ಇದೆಯಲ್ಲ?
My lord, it was an admitted fact, my lord. In fact, defendant also did not dispute the relationship. Whether, my lords, the suture property, my lord, whether the plaintiffs, my lord, are entitled, my lords, for the relief of declaration.
Notice soberly ನೋಡೋಣ. Only 342 days delay. The issue notice against the respondent and call for records. List this matter on 17/12.
42 case Harish.
Suit for partly decreed.
Permit me to appear for
ಹೇಳಿ.
appellate. Convenient compilation ಮಾಡಿ suit for specific purpose.
ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಇದು
ಎರಡು agreement miscellaneous. My lord permits.
Counsel for the appellant submits that he had applied for the certified copy and the trial court rejected the application for filing of return statement. And then seeks time. ಹೇಳ್ರಿ.
Last time my lord said directed. We produced the certified copy of the order sheet. 3 sheets ಅದು blank ಇತ್ತು. Lord said how can you produce this ಅಂತ ಹೇಳಿ ಮತ್ತೆ ಮಾರನೇ ದಿನ ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದಾರೆ. ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ಆದ ನಂತರ ಹಾಕಿದ್ದಾರೆ. ಅದು ಇವತ್ತರೆಗೂ ಸಿಕ್ಕಿಲ್ಲ. ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ ಬೆಳಗ್ಗೆ ತಂದು ಕೊಡ್ತೀನಿ ಅಂತ ಮಾಡಿದೆ. ನೌ ಐ ಆಮ್ ಪ್ರಿಪೇರ್ಡ್, ಐ ವಿಲ್ ಸಬ್ಮಿಟ್.
ಈಗ ಬಂದಿದೆಯಾ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ?
ಅದು ಸಿಕ್ಲಿಲ್ಲ.
ಅದು ಬೇಕಲ್ಲ. ಅದೇ ರೀಸನ್ಗೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಐ ವಾಸ್ ನಾಟ್ ಕನ್ವಿನ್ಸ್ಡ್ ವಿತ್ ಹಿಸ್ ಆರ್ಗ್ಯುಮೆಂಟ್.
ಅದಕ್ಕೆ ಕೇಳಿದೆ ಬೆಳಗ್ಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೀವಿ, ನಮ್ಗೆ ಇನ್ನೂ ಕೊಟ್ಟಿಲ್ಲ ಕೋರ್ಟ್ನವರು.
ನೋಡಿ, appellant counsel seeks time, another 2 weeks time to produce the certified copy and hence list this matter on 5/12.
43 came Somashekara.
For the appellant.
Decreed, permanent injunction granted, confirmed.
Plaintiff has filed a suit for declaration
Hmm.
based on this LD dated 1952, purchased by his father and another one Hanmante Gowda. But as on the date of filing the suit, my lord, there was no records stands in the name of his father or his ancestor. There are revenue records produced by the defendants, my lord, since from 1968. Stand in the name of defendant's mother after defendants were partitioned between their family 2003 registered partition deed. The revenue records stand in the name of defendant and his brothers and a sister. Lord, only without
Go to paragraph number 19.
First appellate court, my lord.
Trial court. Your admission.
As a last sentence, my lord, that is 50 guntegan and ಯಾವುದು ತಕರಾರು ಇಲ್ಲ ಅಂತ. But regarding possession, my lord, there was no discussions regarding
Exhibit D1 is the certified copy of the sale deed dated 26/11/1954, wherein Sidlingayya and his minor son Siddappa have jointly executed
24
surrender number 46/2 measuring 2 acres 20 kuntas in favor of Mallamma, and thereby surrender number 42 has conveyed to 2 acres 20 kuntas. Exhibit D2 is the certified copy of the sale deed dated 10/12/1956. In support of claim of defendant, he filed affidavit in lieu of his chief examination. Got examined DW1 and got marked document exhibit D1 and thereby closed his side of evidence. The cross examination of DW1 dated 16/8/21, paragraph so and so, relevant and same as extracted below. ನಾನು ಎಷ್ಟು ವಿಸ್ತೀರ್ಣದ ಖರಾಬು ಆಸ್ತಿಯನ್ನು ಹೊಂದಿದ್ದೇನೆ ಎನ್ನುವ ಪ್ರಶ್ನೆಗೆ ಸಾಕ್ಷಿಯು ಚೆಕ್ಕು ಬಂದಿಯ ಆಸ್ತಿ ಇರುವ ಜಾಗದಲ್ಲಿ ಇದ್ದೇನೆ ಎಂದು ಉತ್ತರಿಸುತ್ತಾರೆ. ನನ್ನ ತಾಯಿಯು 2 ಕ್ರಯ ಪತ್ರಗಳ ಪ್ರಕಾರ ಒಟ್ಟು 4 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನನ್ನು ಖರೀದಿಸುತ್ತಾರೆ. ಸಾಕ್ಷಿ ಮುಂದುವರಿದು ಖರಾಬು ನಮೂದಾಗಿಲ್ಲ ಎಂದು ಉತ್ತರಿಸುತ್ತಾರೆ. ಸಾಕ್ಷಿ ಮುಂದುವರಿದು ಖರಾಬು ಇಷ್ಟು ಎಂದು ಲೆಕ್ಕ ಇಲ್ಲ ಎಂದು ಉತ್ತರಿಸುತ್ತಾರೆ. ನಾನು ಹಾಜರುಪಡಿಸಿದ ನಿಶಾನೆ ಡಿ 6ರಿಂದ 32ರವರೆಗಿನ ದಾಖಲೆಗಳಲ್ಲಿ ಖರಾಬು 3 ಗುಂಟೆ ಎಂದು ನಮೂದಿದೆ. ಸರ್ವೆ ನಂಬರ್ 3 ಜಮೀನಲ್ಲಿ ಹೊರತುಪಡಿಸಿ ಬೇರೆ ಯಾವುದೋ ಖರಾಬು ಜಮೀನು ಇಲ್ಲ. ವಾದಿಯರು ಕ್ರಯಕ್ಕೆ ಕೊಂಡಂತ 15 ಗುಂಟೆ ಜಮೀನಿಗೆ ಅವರ ಪರವಾಗಿ ಡಿಕ್ರಿ ಆದರೆ ನನ್ನದು ಯಾವುದೇ ತಕರಾರು ಇಲ್ಲ.
That is a stray admission so far as my lord.
Stray admission.
My lord, regarding possession, my lord, he is in written statement as well as in the evidence also the plaintiff put a suggestion. We are in possession of property. That was denied, my lord, para that 24 your lordship kindly see regarding possession trial court.
ನಿಮ್ಮ ಎಕ್ಸ್ಟೆಂಟ್ ಎಷ್ಟು ನೀವು ಪರ್ಚೇಸ್ ಮಾಡಿರೋದು?
That 2 acres 20 guntas and
D1 and D2 ಪ್ರಕಾರ.
Yes, my lord. D1 my lord
4 ಎಕರೆ 20 ಗುಂಟೆ.
2 acres 20 guntas.
ಒಟ್ಟಿಗೆ 4 ಎಕರೆ 20 ಗುಂಟೆ.
4 ಎಕರೆ 20
ಎರಡು ಸೇಲ್ ಡೀಡ್ ಇದೆ D1 and D2.
D1 and D2.
How can you claim more than that?
Lord, revenue records
that you are interfering with possession.
Lord, revenue records does not stand in the name of plaintiff. He sought for declaration without seeking consequential relief.
Sale deed ಇದೆಯೇನ್ರಿ? Exhibit P2
sale deed ಇದೆ.
ಆಮೇಲೆ
RTC like
RTC exhibit P4.
Lord, P5
RTC exhibit P5 to 7.
all stand in the name of my mother name and different name. He is not
but ಮಾರಾಟ ಮಾಡಿದವರು ಯಾರು ಪ್ರಾಪರ್ಟಿ?
Lord,
ಪ್ರಾಪರ್ಟಿ ಮಾರಾಟ ಮಾಡಿದವರು ಯಾರು ಡಿಫೆಂಡೆಂಟ್ ಗೆ?
ಪ್ರಾಪರ್ಟಿ ಮಾರಾಟ ಮಾಡಿದವರು ಸಿದ್ದಲಿಂಗಯ್ಯ ಅಂತ. Not by this we are also purchased from the ಸಿದ್ದಲಿಂಗಯ್ಯ.
ಹೌದು. Maybe the revenue entries are continued in the
since
name
from
of the
1960
original vendor.
Not with the original vendor. 68 in the D6 in the D14, no, my mother name ಅಲ್ಲಿ ಇದೆ. 16 in the 2002.
MR exhibit P8
ನಮ್ಮ ಹೆಸರಲ್ಲಿ ಇದೆ.
MR ನಿಮ್ಗೆ ಹೆಂಗ್ ಬಂತು? ನೀವೇನ್
ವರ್ಚ್ ಆಫ್
ನೀವೇನ್ ಕೊಂಡ್ಕೊಂಡಿದ್ದೀರಾ ಅಷ್ಟಕ್ಕೆ ಮಾತ್ರ ಇದೆ.
ಇಲ್ಲ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ಮಾಡ್ಕೊಂಡ್ರಿ ನಾವು ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ.
ಯಾರು?
ನಮ್ಮ ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್ ಡಿಪೆಂಡೆಂಟ್ ಅಂಡ್
ಎಷ್ಟಕ್ಕೆ ಮಾಡ್ಕೊಂಡ್ರಿ?
ಎಂಟೈರ್ ಎಕ್ಸ್ಟೆಂಟ್ RTC ತೋರ್ಸ ಪಾಸ್ ಆನ್ ದಿಸ್ ಆಲ್ ರೆಕಾರ್ಡ್ಸ್
ಕೊಂಡ್ಕೊಂಡಿರೋದೇ 4 ಎಕರೆ 20 ಗುಂಟೆ.
ಲಾರ್ಡ್ ಖರಾಬ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಖರಾಬ್ ಆಲ್ಸೋ.
ಖರಾಬ್ ಹೆಂಗ್ರಿ ಬರ್ತದ ಅದರಲ್ಲಿ? ಖರಾಬ್ ಅಂತ ಇದೆಯಾ ಪಾಣಿಂದ ನೀವು ಕೊಂಡ್ಕೊಳ್ಳುವಾಗ?
ಲಾರ್ಡ್ ಒನ್ಲಿ ಕ್ವೆಶ್ಚನ್ ಮೈ ಲಾರ್ಡ್, ಇಟ್ ಕ್ಯಾನ್ ಹಿ ಸೀಕ್ ಫಾರ್ ಪೊಸೆಷನ್.
You cannot claim more than that.
He seek for possession, my lord, only declaratory relief is sought.
ಯಾರ್ possession ಯಾರ್ ಕೇಳಿರೋದು?
Is not sought possession.
Possession ಯಾಕೆ ಕೇಳಬೇಕು? Property is in his possession ಇದ್ದಾಗ.
My lord, he is not produced any single document to show that he is in possession of property, my lord. Except exhibit P2, the sale deed. He stand in name of his grandfather. He purchased a property 1952 nalli. So far as possession concerned,
nimdu sale deed exhibit D1 and D2 only to the extent of 4 acres 20 kuntas.
Yes, my lord, as you were
original partition deed ಪ್ರಕಾರ ಎಷ್ಟು partition ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ?
We are partition, my lord, total 3 acres 37 guntas and 3 guntas Karab. And 1 acre stand in the name of some Jailakshmi.
Jailakshmi yaru?
Jailakshmi, there is no explanation from plaintiff. Plaintiff only claiming that, my lord, 46(2), originally 46(p). 46(2), none sharing bandirodu 2 acres 37 guntas olge, he claiming the property under 15 guntas. Nan partition deed al bandirodu 2 acres 27 guntas. Our property nalli he is claiming that declared that I am the owner of the property. That is the boundary.
Plaintiff claim ಮಾಡ್ತಿರೋದು ಏನ್ರಿ?
15 guntas.
Based on the document of
exhibit P2, my lord.
Sale deed.
Sale deed.
Sale deed executed by the very vendor of your client also.
Not my lord. Is executed by one Siddhalingaya, son of Siddhaya.
ನಿಮ್ಮ vendor ಯಾರು?
ನಮ್ಮ vendor Siddhalingayane.
ಮತ್ತೆ ಈಗ ಹೇಳಿದ್ರಲ್ರಿ ಮತ್ತೆ ಈಗ ಬೇರೆ ಬೇರೆ ಅಂತೀರಿ?
Siddhalingayane. Siddhalinga originally, my lord, Hanumantachari is a owner entire extent. Survey number 46. Subsequently ported and podi was also done. He is not in possession. I will pass on judgment your lordship on without seeking a further relief. Revenue documents exhibit D3 in the 35 documents stand in the name of
mere entry in your name. Your ನಿಮ್ಮ ಇರೋದನ್ನು ಹೇಳಿ ಇವೆಲ್ಲ ಗೊತ್ತಿರೋದು settled law.
Without seeking further relief, my lord, possession. If he could have sought for possession,
title follows the possession in case of sale ಇದ್ದಾಗ. You are also claiming the same from your vendor. Vendor is one and the same.
Lord, is not examined. Not examined.
Not examined.
Lord, my point is, my lord, as per partition deed,
you cannot claim the more than the property what you have purchased.
Lord, as per partition exhibit D3.
ಹೌದ್ರಿ ನಿಮ್ಮ ಅಡ್ಮಿಷನ್ ನೋಡಿದ್ರಾ?
ಅಲ್ಲ ನೋಡಿದೆ.
ಅವ್ರು ಎಷ್ಟು ಕೊಂಡ್ಕೊಂಡಿದ್ದಾರೆ ಹೇಳಿ?
ನನ್ನ ಪ್ರಾಪರ್ಟಿ ನನಗೆ ಬಂದಿರೋ ಶೇರ್ ಕ್ಲೈಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅದರ ನಮ್ಮ ಬ್ರದರ್ಸ್ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
ನಿಮ್ಮ ಮನೆದ್ರ ಹಂಗೆ ನಿಮ್ದಂಗೆ ಕೇಳ್ತಾರೆ.
ಅಲ್ಲ ಅದರ್ ಬ್ರದರ್ ಮೈ ಬ್ರದರ್ ಶೇರ್ ಹೋಗಿದೆ.
15 ಗುಂಟೆ ಜಮೀನಿಗೆ ಅವರ ಪರವಾಗಿ ಡಿಕ್ರಿ ಆದ್ರೆ ನನ್ನದು ತಕರಾರು ಯಾವುದೇ ಇಲ್ಲ ಅಂತ ನೀವೇ ಹೇಳಿದ್ರಿ.
ಅದರ್ ಪೋರ್ಷನ್ ಆಫ್ examination, cross examination, my lord, shows that, my lord, he is denied the possession. Return statement of specific contention ತಗೊಂಡಿದ್ದಾರೆ. ಪಾರ್ಟ್ ಆಫ್ ಮೈ ಶೇರ್ ಅಲ್ಲಿ
ಅವ್ರ ಕ್ಲೈಮ್ ಇರೋದೇ 15 ಗುಂಟೆ. ನಿಮ್ಮ 15 ಗುಂಟೆನಲ್ಲಿ
lord till 1954 ಇಂದ ನಾವು ಪೊಸಿಷನ್
ನಾವು ported as 46(2), totally measuring 3 acres including Karab 3
guntas. ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಶೇರ್ ಬಂದಿರೋದು ಕೇಳ್ತಾ ಇದೆ.
situated.
That is the share. That is the contention of the defendant. ನನಗೆ ಶೇರ್ ಬಂದಿರಬೇಕು. ಸ್ಪೆಸಿಫಿಕ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲೂ ಅದೇ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿದ್ದೀರಿ.
ಏನಂತ?
ನನಗೆ ಬಂದಿರೋ ಶೇರ್ ಅಲ್ಲಿ ಈಸ್ ಪಾರ್ಟ್ ಆಫ್ ಮೈ ಶೇರ್ ಓನ್ಲಿ he is claiming property ಅಂತ.
ನಿಮ್ಮ ಶೇರ್ ಹೆಂಗ ಗೊತ್ತು?
Para 7A, my lord, we have specifically pleaded that, my lord, and also at no point of time the plaintiff was in possession enjoyment of suitable property. Part of non sharing bandira property nalli he is claiming my brother is not made party. Entire extent to 5 acres irodu. Out of his my share what the revenue records stand in my name, he is claiming out of it 15 gunta.
ನಿಮ್ದಿರೋದು ನಿಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಮಾತ್ರ ರೀ. ವಾಟ್ ಎವರ್ ದಿ ಪ್ರಾಪರ್ಟಿ ಯು ಹ್ಯಾವ್ ಪರ್ಚೇಸ್ ದಟ್ ಈಸ್ ಟು ದಿ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ 4 acres 20 guntas. They are not claiming any right in respect of your property is concerned.
Lord, 46/2 is given. Earlier, my lord, only 46. After 40 is given 46/2.
ಯಾರಕ್ಕೆ? ನಿಮ್ದಕ್ಕ ಅವ್ರದಕ್ಕ?
ನಮ್ದಕ್ಕೆ. ಅವ್ರದ್ದು ಇದೆ 46 ಅಷ್ಟೇ. ಪೈಕಿ ಅಂತ.
ಆಯ್ತು, ನಿಮ್ದೇನಿದೆ ಕೋಡ್ ಆಗಿದೆ, ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಐಡೆಂಟಿಫೈ ಆಗಿದೆ ಯಾವ್ದು ಅಂತ.
ಹೌದು, ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಅದನ್ನ ಬೌಂಡ್ರಿ ಸೇರ್ಸ್ ಕೊಡ್ತಾ ಇದಾರೆ ಅಂತ. ದಟ್ ಇಸ್ ಮೈ ಕಂಟೆನ್ಷನ್.
ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಏನಿದೆ ಅದನ್ನ ಮಾತ್ರ ಅವ್ರು ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಲಾರ್ಡ್, ಮೈ ಸಬ್ಮಿಷನ್ ಮೈ ಲಾರ್ಡ್,
ಬೌಂಡ್ರೀಸ್ ಯಾಕೆ ತೋರಿಸಿದಾರೆ ನೋಡ್ರಿ.
ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಫೈಂಡಿಂಗ್ಸ್ ನೋಡಿ. ಪೊಸಿಷನ್
ಬೌಂಡ್ರೀಸ್ ಕೂಡ ಇದೆ ನೋಡ್ರಿ ಅದರಲ್ಲಿ.
ಪ್ಯಾರಾ 24 ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್
ಕಂಟೆಂಟ್ ಆಫ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇನ್ ನಟ್ಸೆಲ್.
ಪ್ಯಾರಾ 24 ಆಫ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ರಿಗಾರ್ಡಿಂಗ್ ಪೊಸಿಷನ್ ಕನ್ಸರ್ನ್.
ಏನ್ ಹೇಳಿದಾರೆ ಹೇಳಿ.
Moreover, on perusal of exhibit P2, it is more evident that for valuable consideration, even on the day of execution of sale deed, possession
handed over in favor of the plaintiff.
Ade exhibit P3 genealogical tree. Our father indanu
legal heirs anta.
Ade legal heirs anta.
They are the legal heirs anta.
Last paragraph 26 regarding my possession revenue records na admit madstare. The ratio is applicable to in the present case, though the advocate for defendant vehemently submitted that in his disclosure that as per exhibit P5 to P10, the name of defendant reflected as that owner and in possession of the suit scheduled property. Moreover, as per 136 of the Karnataka Land Revenue Act, though they do carry presumptive value, however, they are not the title documents which are confirmed title to the person. Moreover, the exhibit P14 at page 6, it is clear that evident that exhibit P8 and P9 have been rejected in the AC court And as such, it reflects that survey number 46 name of Hanumante Gowda and Melappa son of Kumbaya jointly appears to the extent of 15 gunta. The owner virtue of exhibit P2 name of the defendant to an extent of 2 acres 17 guntas has been entered into, and remaining 5 guntas stands in the name of original Katedar. Thereby remaining total extent of 46 is 2 acres 37 guntas. Moreover, exhibit P15 it clearly reflects that survey number 46 the name of Mela and Kumbaya in respect of person who is in possession enjoyment. 46 alin they are claiming 46 bar 2. That there is no evidence regarding 46 ಗೆ ಕೋಡೆ ಆಗಿರೋದು ಇದ್ರ ಬಗ್ಗೆ ಆಗಿರೋದು ಏನು ಇದು ಮಾಡಿಲ್ಲ. So therefore he is not in possession of the property. The consequential relief has not been sought for seeking for possession.
ನಿಮ್ಮ ಹತ್ರ ಈ ಕೋಡಿ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆಯಾ?
Not about
46/2. What is the total extent of Podi? Now you are claiming that that is coded as 46/2 that belongs to you.
Yes, madam.
Podi document ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ನೀವು ಏನಾರು ಹಾಕಿದ್ದೀರಾ? ನೀವು ಹಾಕಿಲ್ಲ.
ಇಲ್ಲ ನಾವು ಹಾಕಿಲ್ಲ. Since from 1968 ಅಲ್ಲೇ ಆಗಿದೆ. 68 16 exhibit.
What is the total extent?
D6 ಇಂದ D6 ವರೆಗೂ my mother ಹೆಸರಲ್ಲಿ
ಯಾವಾಗ 1954
54 68 ಇಂದ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ ಸರ್.
ನಿಮ್ ಸೇಲ್ ಡೀಡ್ ಯಾವ ವರ್ಷದ್ದು?
54.
ನಿಮ್ದು?
ನಮ್ದು 54 ಅಲ್ಲಿ 26
ನೀವು 56
ಅಲ್ಲ 54 ಒಂದು 56
ನಿಮ್ಗಿಂತ ಮುಂಚೆ ಅವ್ರು ಕೊಂಡ್ಕೊಂಡಿದ್ದಾರೆ.
54 ಒಂದು 56 ಒಂದು.
ಹೌದು, ಅವ್ರ ಸೇಲ್ ಡೀಡ್ ಇನ್ನು ಮುಂಚೆ ಅಲ್ವಾ?
ಅವ್ರ ಸೇಲ್ ಡೀಡ್ 52. Exhibit D6 ಇಂದ my mother name is appears to till 2002 5 acres. Revenue records ಅಲ್ಲಿ D6 D7 D8
5 acres ಹೆಂಗ್ರಿ ಬರುತ್ತೆ? ನೀವು ಕೊಂಡ್ಕೊಂಡ್ರದೆ 420 ಅದ್ರ ಬೇಸಿಸ್ ಮೇಲೆ ನೀವು ಇಂಟರ್ಫಿಯರ್ ಮಾಡ್ತಾ ಇರೋದು ಅವ್ರ ಪೊಸಿಷನ್ ಗೆ. That's the reason.
As on the date of filing suit my lord there is no document to show that they are in possession.
Title ಇರೋದೇ 420. That's all.
ಅಲ್ಲ they are not in possession of property.
That's all your argument.
My submission without seeking possession my lord all
why they have to seek the possession? Possession was given in the year 1952 itself when the property was sold.
No revenue records stand in the name of my lord plaintiff.
Mere wrong entry in the revenue records will not confer any title in favor of you. Third, heard the appellant counsel and this matter is listed for admission. This appeal is filed against the concurrent finding. The factual matters of case of plaintiff before the trial court that while seeking the relief of declaration and permanent injunction that Suchalu property is in peaceful possession and enjoyment of the plaintiffs, and also sought for the relief of declaration claiming that originally sued property belongs to one Hanumanta Chari, son of Bhimanna, resident of Narasapura village, who inter alia conveyed the Suchal property in favor of Siddhalingayya, son of Siddhayya, who in turn alienated the same in favor of Hanumante Gowda and Melappa, son of Kumbaya, under the registered sale deed dated 4/9/1952. The said Melappa is none other than the father of the plaintiff, and he was in physical possession and enjoyment of the social property during his lifetime. Pursuant to his demise, plaintiff is in continuous physical possession and enjoyment of the social property as a successor. The said Melappa was being an illiterate person, though he obtained the J slip from sub-registrar office. However, Kata Pani was not mutated in the name of in favor of the plaintiff. The defendant have no manner of right over the social property, causing obstruction, and made an attempt to cut and remove the standing trees which are existence in the social property. The act of the defendant was reported to the police, and police advised them to approach the court, and hence they filed the suit for the relief of declaration and injunction. The defendant appeared and filed written statement contending that land bearing survey number 46/2 totally measuring 4 acres 34 guntas, out of which 2 acres 20 guntas was purchased by the mother of the present defendant, namely Srimati Mallamma, under a registered sale deed dated 26/11/1954 for valuable consideration. from lawful vendors, that is Sidlingaya, and his minor son Siddappa. The boundary is also mentioned. Subsequently, the mother of the defendant, namely Srimati Mallamma, also purchased another bit of land in same survey number 46/2, measuring 2 acres from one Guddaya under the registered sale deed dated 10/12/1956. Since then, Mallamma not only become an absolute owner to an extent of 4 acres 20 kuntas, including Karab in total measuring 5 acres of land in survey number 46/2. The social property is part and parcel of this land to an extent of 5 acres. The Mallamma was in possession and enjoyment of the land till her death. Pursuant to her demise, the defendant and his brothers succeeded to this land, bearing survey number 46/2, totally measuring 5 acres, and were in joint possession and enjoyment of the same. That the defendant and his brothers partitioned that joint family properties, including this land, 46/2, on 26/8/2003, and in the said division 46/2, measuring 3 acres 37 kuntas of land, including Karab, has fallen to the share of the defendant. The remaining portion has fallen to the share of his brother. Since the date of partition, this defendant and his brother have been in possession and enjoyment of their respective share in the social property 46/2, which is inclusive of the suit schedule property. That never the plaintiff was in peaceful possession and enjoyment of the suit schedule property towards the northern side of the suit property, which has fallen to the share of defendant. There is a land belonging to one Chikka Thopaya. However, in reality, number between the land of Chikka Thopaya and the present defendant, there exists 15 guntas of land. And appeal was filed before the Assistant Commissioner in RRT number 99 of 2010-11, and the same was in the name of the present defendant, and prayed the court to dismiss the suit. The trial court, having considered both oral and documentary evidence, particularly extracted the evidence of the PW1 in paragraph number 15, and so also taken note of the admission on the part of DW1 in his cross-examination, since he relies upon document exhibit D1 and D2 to the extent that he had purchased the property to the extent of 4 acres 20 kuntas, and also categorically admits in the cross-examination that property was purchased only to the extent of 4 acres 20 kuntas. However, he claims that there is a Karab land, but he admits that Karab is not mentioned in the document. And also he categorically admits that Karab land are to the extent also not mentioned. And only in exhibit D6 to 37 mentioned the extent of 3 kuntas of Karab land. And also he admits that except 3 kuntas of Karab, no other Karab land is available. And also he categorically admits that he has no any objection to granting the relief in favor of the plaintiff to the extent of 15 kuntas. Having considered this admission on the part of DW1, comes to the conclusion that property was purchased by the defendant only to the extent of 4 acres 20 kuntas. And also the written statement claim was also taken note of. And merely because the RTC stands to the extent of 5 acres of land in the name of defendant cannot be considered as the owner to the extent of 5 acres. And the same is also taken note of, particularly taking note of admission on the part of DW1. And only he claims more 3 kuntas of Karab land. And the same is also not reflected in any of the documents except the admission on the part of DW1 in exhibit 6 to 37, and the same is also mentioned only to the extent of 3 guntas. And hence he cannot claim the ownership to the extent of 5 acres, taking the advantage of revenue entries, and the same is taken note of by the trial court, and trial court rightly granted the relief of declaration and permanent injunction in favor of the plaintiff. The first appellate court also reassessed the material available on record and having considered the material on record and also the grounds which have been urged in the appeal, formulated the point whether the trial court committed an error in granting the relief and committed an error justified in granting the relief. And appellate court also on reappreciation, considering the material level on record, particularly the document of exhibit P2, sale deed of 4/9/1952, and the same was also purchased even prior to the defendant, and defendant purchased the property in the year 54 and 56, which are subsequent to the sale deed of father of the plaintiff. And these factors were also taken note of by the appellate court, and appellate court also confirmed the same. Now the present second appeal is filed before this court, and counsel would vehemently contend that both the courts committed an error in granting the relief and contend that both the courts were not justified, that suit for declaration simpliciter was not maintainable in view of section 34 of the specific relief act. And also counsel would vehemently contend that both the courts are not justified in ignoring exhibit P 5 to 8 and exhibit D 6 to 14, 15 to 37, 38 to 42, and 43 to 46 and 47 to 50, showing the defendant is in possession and enjoyment of the property since 1968-69 and hence committed an error. Having taken note of the said contention in the present appeal, and also particularly taking note of the admission on the part of DW1 before the trial court, wherein categorically admitted that he has no any objection to grant the relief in favor of the plaintiff, who claims the declaration and injunction in respect of 15 guntas of land. And apart from that, he categorically admits that in terms of the two sale deeds of exhibit D1 and D2, the property was purchased to the extent of 4 acres 20 guntas, but he claims the extent of 5 acres by taking the advantage of entry found in the revenue records. And the very specific pleading of the plaintiff before the trial court that the plaintiff father was an illiterate and he did not make the entries, and when there is a sale deed in favor of the plaintiff, that too a sale deed from the same vendor of the defendant, and also the document is very clear to the extent of 4 acres 20 guntas, but on the guise of the Kharab land, the defendant makes an attempt to claim that he is in possession to the extent of entire land, and the same is taken note of by the trial court and appellate court, and hence I do not find any ground to admit and frame substantive question of law, and the very contention of the appellant that they are in possession of the property more than the property what they have purchased cannot be accepted. The very admission takes away the case of the appellant and hence not a case to invoke section 100 of CPC. In view of the discussions made up, I pass the following order. Second appeal is dismissed. 44.
Pramod R.
For the appellant, my lord, the defendant's appeal, the relationship is that, my lord, the plaintiff is the son of the second defendant, my lord. The second defendant is the son of the first defendant. It is through the first wife, my lord, she has died. Defendant 3 to 5 are the sons of the first event through the second wife, Boramma, my lord. Here, the defendant 2 son has filed the suit for partition, my lord, contending that it is an ancestral and joint family property, my lord. The trial court, we have taken the contention before the trial court that item number 1 to 3 are the properties as the ancestral property acquired by the defendant number 1 by the partition between their brothers, my lord. And the remaining property is the acquired by this defendant number 1 out of his own income, my lord. That was the contention was taken place. In the meantime, my lord, the defendant number 1 has executed the will in favor of the defendant number 3 to 6, my lord, and 6A with respect to the properties, my lord. The trial court has decreed the suit of the plaintiff with respect to all the properties, joint and ancestral properties, my lord. And the first appellate court confirmed the same, my lord. My humble submission is that, my lord, both the courts have come to the conclusion that defendant number 1 has executed the will in favor of the defendant number 3 to 6, my lord. And it is not disputed by the defendant number 1 because he has filed the return statement accepting the same, my lord. Even the first appellate court says that the section 68 is fulfilled by the defendant with regard to the will, my lord, and there is a suspicious circumstances and near relatives has been excluded, my lord. On that ground, it is disbelieved, my lord. In this case, my lord, the daughters are also the parties to the suit, my lord. They have not disputed that particular thing. My humble submission is that, my lord, when the will has been proved.
What is the reason for disinheriting the other family members by the defendant number 1 while executing the will?
There is no reason as such as been stated. It is self-acquired property, my lord, that as I am executing the same, my lord.
Maybe a self-acquired property.
That is,
but they are the children.
Yes, my lord. Even they
What
are
is the
parties
reason?
to the
What is the
proceedings, my lord.
reason?
And they are the parties to the
What is the
proceedings.
reason?
The
Counsel?
reason is that, my lord, this is the property is acquired by me, my lord. That's why I am
Maybe acquired by you. Why you have given the property in favor of particularly the person?
The defendant number 3 to 6, my lord.
Including the other children.
That is not be stated, my lord. What is the reason? That is not. But he says that it is self-acquired property, my lord. The question is that, my lord, only the plaintiff says that it has not been executed. Even the defendant accepts that. Even the daughters are the parties to the proceedings, my lord. They have not disputed that particular will, my lord. They have accepted it. The court goes to, says that it is suspicious circumstances, my lord. Even
that is also one of the suspicious circumstances.
That is, the will has been proved, and the person who has executed the testator has accepted the will. Daughters have been accepted, who are excluded, my lord. The question arises, my lord, the will which has been executed, even though it is not binds on the plaintiff, my lord, to the extent of share of the defendant to number 1 is valid. That part of the thing has not been considered by the both the courts, my lord. And another aspect is, my lord, the plaintiff says in the pleading, my lord, the ancestral properties are item number 1 to 3, my lord, and the remaining properties are acquired in the name of the defendant number 1. He has to say in this pleading, my lord, that there is a nucleus out of the ancestral property item number 1 to 3. There is no material with regard to those.
In conduct ella bardavaru nodi para number 46 ಅಲ್ಲಿ. It is true that in exhibit D18 it is stated that first defendant has given the family properties 2-3 times to the second defendant and he has sold them. But it is not the case of the defendant number 1 and 3 to 6 that the first defendant has given such family properties to the second defendant. He has sold the properties which are acquired by him under the gift deed executed by Narsegoda. It is undisputed fact that before execution of exhibit D18 by the first defendant, the second defendant has already filed the suit for partition and separate possession of his share in the very same suit share properties, which was later dismissed by filing the memo stating that matter is settled out of court on 25/11/1997. The second defendant has claimed in the said suit that the properties purchased by the first defendant also joint family properties in which he has half share. After dismissal of the said suit, exhibit D18 was executed by the first defendant only in respect of the suit schedule item number 4 to 7 and 9. ನೀವೇ ಹಿಂದೆ ಸೂಟ್ ಹಾಕಿದಿರಿ.
ಅಲ್ಲ ನಾವಲ್ಲ ಹಾಕಿದ್ದು. This was the suit filed by the father of the plaintiff.
ಅದೇ second defendant.
The second defendant, father of the plaintiff, has filed a suit that was dismissed as settled out of the court, my lord.
All these factors were taken note of with regard to the very execution of document.
It is not the
all
defendants who have filed
surrounding circumstances appearing in exhibit P18, excluding the second defendant, revealed that the mind of the testator was not free.
That is, my lord, that is the suit which was filed by the plaintiff's father, my lord. Therefore, defendant.
Detailed reasoning is given with regard to the suspicious circumstances of exhibit D18.
D18, my lord, it is the property, my lord. Even though it is assumed that it is joint and ancestral property, the extent of the share of the defendant one has to be binding, my lord. The records is necessary for with regard to the deposition and other things, my lord. Call for records, my lord, and I will. Because, my lord, OS 68 has been filed. Defendant number 2, who is the father of the plaintiff, and he has withdrawn the suit, stating that it is settled out of the court, and he has not appeared before the court itself, and also says that with regard to the will, my lord, only the suspicious circumstances when he has alleged by the plaintiff says that it is under the circumstances it has been executed. The person who has executed a will says that it is my self-acquired property. I have bequeathed the property in favor of defendant 3 to 6, my lord, and also that, my lord, when they have to establish.
Scope is very limited in second appeal. Second appeal alli except perversity, the court cannot reappreciate the same.
And that is the, my lord, with regard to the finding which was given exhibit D18, the will, my lord, it is not the case of the plaintiff. It is a circumstances under which it has been made out, my lord. It is the case, my lord, who are the.
Only perversity in the finding of both the.
That's why, my lord, section 68 has been fulfilled. It is accepted by the appellate court, my lord. The attesting witness is examined and everything has been
Mere
done, my lord.
examination is not enough, counsel, for proving.
That's correct, my lord. My humble submission with regard to those aspects, my lord. The will has been proved to the against the defendant number one and all the daughters. The daughters are not disputed with regard to the exclusion of them from giving the property in the will, my lord. My humble submission is that, my lord, when the will has been proved at the absence of the defendant number one and the other daughters, my lord, and they have not claimed any right over that particular document, even they have not taken any contention with regard to those things. The property which has been bequeathed to the extent of the share of the testator to be gone to the defendant number 3 to 6, my lord, that cannot be equally partitioned. That is my humble, that is the substantial question of law I am submitting, my lord. And suspicious circumstances, my lord, before going to that, whether it is self-acquired property or not, my lord, the plaintiff has filed a suit, my lord, wherein he has to state it in the pleading that the joint family having the nucleus of item number 1 to 3 having the nucleus, and by that he has purchased the property. There is no pleading in that regard, my lord. The court has taken that particular thing, it is not necessary. And the person who comes to the court has to establish the nucleus, then he has to say that it is the property under that particular thing. These are the income that has been derived, my lord. Only that first appellate court that in the RTC there is a areca trees are there. Therefore, there is a sufficient income. There is no evidence with regard to those things, my lord. And the nucleus has to be proved by the plaintiff. That was not considered. And it is a burden put on the defendant that you have to say.
That's all. Third. Matter is listed for admission. I heard the counsel appearing for the appellant. This second appeal is filed against the concurrent finding. The factual matrix of case of plaintiff before the trial court while seeking the relief of partition and separate possession.
One more submission, my lord.
Specifically pleaded that really
having notice of this particular will, my lord, in the TP Act, my lord, having notice, it is a registered document, my lord. And the suit is very much bought by
registered
time.
Document to execution, yella sari. But when the will is shrouded with suspicious circumstances, the same cannot be accepted. And both the courts also taken note of the said fact into consideration.
Those aspects, what has been considered by the first appellate court, neither in the oral evidence nor in the pleading, my lord.
Right.
The court takes, my lord.
That the plaintiff along with defendants 1 to 6 constituted the joint family and scheduled properties are ancestral properties. And defendant number 1, 3 to 6 took the contention that defendant number 1 separated from the joint family. And also considering the written statement filed by defendant number 5, additional issue also framed that Srimati Gauramma had executed, whether the fifth defendant proved that Gauramma had executed the registered will dated 21/7/1992 jointly in favor of Narsai Gowda and the fifth defendant in respect of some of the properties as contended in the written statement. And also whether the fifth defendant proves that the sale proceeds of the crops grown in the properties fallen to him under the will dated 21/7/1992 and his own earnings he has purchased the suit schedule item number 11 of the property and whether it is a self-acquired property. And also considering the defense of the defendant number 1, 3 to 6, it is contended that first defendant has sold the suit schedule item number 2 property in favor of subject defendant for family necessity. And whether defendant number 1 to 3, 1, 3 to 6 proves that suit schedule item number 4 to 7, 9 and 10 properties are the self-acquired properties of the first defendant. And suit schedule item number 8 is the Sridhana property of Gauramma. Whether defendant number 1, 3 to 6 prove that the second defendant is living separately by enjoying the properties acquired under registered gift deed dated 12/12/1963. And whether defendant number 1, 3 to 6 prove that the second defendant has sold the suit schedule item number 8 to 10 properties and the lands bearing survey number 41/3A, 41/2 and 75/2 are awarded in the written statement. And also whether the defendant number 1, 3 to 6 prove that the first defendant has executed the registered will dated 29/8/1988 as contained in the written statement. The trial court allowed the parties to lead evidence and having considered the evidence available on record, answered the issue number 1 and 2 as affirmative in coming to the conclusion that they constitute the joint family and properties are the ancestral properties, and also answered the other issues as negative, that is issue number 3, 4. However, answered the issue number 5 as affirmative that there is a cause of action, and additional issues also issue number 1, 2, 3, 4, 5 framed on different dates were also answered as negative. Only answered the additional issue number 4 dated 12/1/2018 in the affirmative in coming to the conclusion that property was already sold. That is second defendant in respect of item number 8 to 10. And answered other additional issue number 5 and 6 as negative, and comes to the conclusion that will which was propounded is surrounded with suspicious circumstances, and even though the document is registered and examined the witness, attesting witness, but the document clearly discloses that came into existence in a suspicious circumstances that has been discussed in paragraph number 43, 44, 45, 46, and 47 and 48. While answering issue number 6 dated 12/1/2018, and also taken note of admittedly the properties sold by the second defendant are acquired by him under a registered gift deed dated 12/12/1963 executed by Narsi Gowda, who is the brother of the first defendant. Exhibit P17 and P27 are the certified copies of the said gift deed, and also admitted fact that the said properties gifted by Narsi Gowda in favor of the second defendant are acquired by him under the registered partition deed dated 3/1/1957. A DW1 also admitted in his cross-examination that at the time of execution of the said gift deed, the second defendant was a minor, aged about 10 years, and the first defendant has represented as natural guardian of the minor of second defendant. Such being the facts and circumstances of the properties gifted by Narsai Gowda in favor of the second defendant will become his self-acquired properties, and the plaintiff has no right to claim any share in it under Section 6 of Hindu Succession Act. The plaintiff has neither challenged the said sale transaction nor any right to do so, as the same are not devolved to the plaintiff, and hence the purchasers of the properties from second defendant are not just and necessary parties to this suit, since the very issue was very ground was taken, and hence definite conclusion was given by the trial court in granting the relief in favor of the plaintiff, partly declaring the suit entitled for partition and separate possession of his 1/3 share and the share of the deceased second defendant in the suit schedule properties by meets and bounds. Since the sale of the suit schedule item number 2 property in favor of the seventh defendant is not the family necessity and benefit of the family, and transaction is not binding on the share of the plaintiff in respect of the suit property, and hence granted the relief in favor of the plaintiff. Being agreed by the same, a second appeal is filed. First appeal is filed before the appellate court, and appellate court also having reassessed the both oral and documentary evidence in view of the objections, in view of the grounds which have been urged in the first appeal, formulated the point whether the trial court committed an error in granting the relief in favor of the plaintiff in not accepting the will as propounded by the defendant, and on evaluation of both oral and documentary evidence, the first appellate court also comes to the conclusion that trial court has not committed any error in coming to the conclusion in answering issue number 1 and 2 and other issues as negative, and so also in respect of the sale of the property by defendant number 2 also accepted the reasoning of the trial court and confirmed the judgment of the appellate court. Being agreed by the said judgment and decree, second appeal is filed before this court. The main contention of the counsel appearing to the appellant that in respect of The father of the plaintiff, public respondent number 1, had filed the suit in OS number 62 of 93 against the appellant and other respondents. Also with respect to item number 1 to 10, properties are got dismissed as settled out of court. In the above said circumstances, the suit is not maintainable. And also the counsel would vehemently contend that in the absence of pleading of proof by the plaintiff with regard to the joint family having nucleus to purchase the property in the name of defendant number 1, the trial court and first appellate court not right in decreeing the suit. And also counsel would vehemently contend that when the registered will dated 24/2017 was executed and the same is proved in terms of section 68, ought not to have granted the relief in respect of the said properties, and both the courts have committed an error, and hence this court has to admit and frame substantive question of law. Having heard the appellant counsel and also considering the material available on record, particularly the pleadings of the plaintiff as well as the defendants, and also the additional issues which have been framed, and the same has been considered by the trial court, and trial court comes to the conclusion that they constitute the joint family and properties are an ancestral properties. And also with regard to the contention of the defendant number 1, 3 to 6, that already defendant number 1 separated from the joint family was not accepted, and also the contention of the defendant that there was a registered will dated 21/7/1992, and in terms of the said will, he was having his own earnings and he has purchased the social property was also turned down by the trial court, since the very will which was marked as exhibit P18 comes to the conclusion that disinheriting of the property of the very legal heirs of the executant of the will is suspicious circumstances, and also taken note of the circumstances under which the document came into existence in paragraph number 40. 43, 46, 44, 45, 46 in detail taken note of the exhibit D18, and also taken note of that 6th defendant is unmarried daughter of the first defendant and the 3rd defendant is vagabond, and DW1 has admitted in its cross examination that defendants number 3 and 6 are handicapped. DW2 has also deposed that 3rd defendant is also a handicapped person, and considering the material available on record, trial court comes to the conclusion that excluding the 2nd defendant revealed that the mind of the testator was not free while executing the document of exhibit D18, and also taken note of the first defendant has given the family properties 2 to 3 times to the 2nd defendant and he has sold the same, but it is not the case of the defendants 1, 3 and to 6 that the first defendant has given such family properties to the 2nd defendant, and having taken note of all the material on record, rightly comes to the conclusion that will has not been proved as propounded by the defendant number 5, and so also with regard to the self-acquisition based on the said will away properties, and also considering the material on record, rightly comes to the conclusion that will is surrounded with the suspicious circumstances, and first appellate court also in detail considered the material available on record, and on reappreciation also comes to the conclusion that whether the said will is in a suspicious circumstances, and also taken note of the natural heirs have been disinherited, and also no such reason is assigned for disinheriting the other natural heirs, and hence confirm the same. And when such finding is given by the trial court as well as the appellate court, and this court can only in the case of perversity is found in appreciation of evidence of both oral and documentary evidence can only admit the second appeal, and the same is not found in the reasoning of the trial court as well as the first appellate court, and when such being the case, I do not find any ground to admit and frame substantive question of law by invoking section 100 of CPC. In view of the discussions, madam, I pass the following order. Next 45. Hirematad Mahesh Ayyar Rudraya.
Kindly have it on Friday, will
Hmm?
kindly have it on Friday, will
ಏನು?
Friday.
ಕೋರ್ಟಲ್ಲಿ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದವ್ರು ಯಾರು ಮೇಡಮ್? ಕೋರ್ಟಲ್ ಮೆಮೋ ಮೂವ್ ಮಾಡಿರೋದು ಯಾರು?
ನಾನೇ ಮೂವ್ ಮಾಡಿದ್ ಮೇಡಮ್.
ಹಾ?
It moved by me only. I'm not feeling well, madam.
Why you are seeking time?
Since I'm not feeling well.
Not feeling well because of 5 o'clock.
No, I'm feeling cold and fever, madam.
Cold and fever. Appellant counsel seeks time to discuss this matter on 5/12. ಏನಾಯ್ತ್ರಿ ಉದಯ ಪ್ರಕಾಶ್ ರವಿಶಂಕರ್ ಶಾಸ್ತ್ರಿ?
46.
ಹಾ?
My lord.
ಆಗ್ಲಿಲ್ವಾ ಸೆಟ್ಲ್?
ಇಲ್ಲ ಆಗಿಲ್ಲ.
ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಅಂತ ಬರ್ದಿ
ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ.
ಹೇಳ್ಬಿಡಿ ನೋಡೋಣ ಏನ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದ್ರೆ ಕೇಳೋಣ.
ಶಾರ್ಟ್
ರಿಸರ್ವ್ ಮಾಡ್ಕೊಂಡು ಬರಿತೀನಿ.
ಹೌದು.
ಶಾರ್ಟಾ?
ಶಾರ್ಟ್.
ಹೇಳಿ. ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲೂ ಇಟ್ ಶುಡ್ ಬಿ
ಹೌದು, ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸೋಲ್ಡ್ ಅಂತ
ಪಾರ್ಟಿಷನ್ ಆಕ್ಟ್
ಬಿಕಾಸ್ ಆಫ್ ದಿ
ಅಲ್ಲ, ಇನಿಷಿಯಲಿ ಏನಾಯ್ತು, ಸೋಲ್ಡ್ ಅಂತ ಆಯ್ತು. ಅದು ಆಮೇಲೆ ಕಮಿಷನ್ ರಿಪೋರ್ಟ್ ಫ್ರೆಶ್ ಕಾಲ್ ಫಾರ್ ಮಾಡಿದ್ರು.
ಆಯ್ತು.
ಅದಾದ್ಮೇಲೆ ಅದನ್ನ ಪುನಃ ಪಾರ್ಟಿಷನ್ ಆಗ್ಬೇಕು ಅಂತ ಮಾಡಿದ್ರು. ಅದು ಸೆಟ್ ಅಸೈಡ್ ಆಯ್ತು. ಫಸ್ಟ್ ಅಪರೇಟ್
ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸೆಟ್ ಅಸೈಡ್
ಆಗಿ ಪುನಃ ಕಳಿಸಿದ್ರು. ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಸೋಲ್ಡ್ ಇಂಟರ್ನಲ್ ವಿತ್ ಇನ್ ಪಾರ್ಟೀಸ್ ಇನ್ ಫೇವರ್.
ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅದನ್ನೇ ಹೇಳ್ತಾರೆ.
ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಸೇಸ್ ಇಟ್ ಶುಡ್ ಬಿ ಸೋಲ್ಡ್ ಇನ್ ಅಕಾರ್ಡೆನ್ಸ್ ವಿತ್ ದ ಪಾರ್ಟಿಷನ್ ಆಕ್ಟ್ ಅಂತ ಹೇಳ್ತಾರೆ. I don't have any other except to say that whether compulsion is possible or not, ಅಷ್ಟೇ ಇದ್ದಿತ್ತು ನನ್ನ argument. That is all.
Only ground.
Only ground.
Cannot compel you to sell the property.
Sell my share ಅಂತೇಳಿ ಅಷ್ಟೇ ಇದ್ದಿದ್ದು, ಬೇರೆ. ಅದರಲ್ಲಿ ಈಗ ಇರುವಂತದ್ದು I am told only 2.6 cents is there. I think it is better. It won't be useful for my client also is what I also feel. But anyway, that was only the legal question.
ನಿಮ್ಮಿಬ್ಬರಲ್ಲಿ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಪ್ರೈಸ್ ಫಿಕ್ಸ್ ಆಗ್ಲಿಲ್ಲ.
ಇಲ್ಲ.
ಅದರಿಂದ ಅಲ್ಲೇ ಹೋಗಿ
ಅದೇ ಮಾಡ್ಬೇಕು.
ನೋಡ್ಕೊಳ್ಳಿ. FDP ನಲ್ಲಿ.
ಹೌದು.
FDP ನ ಇದಾ?
FDP ಅಲ್ಲಿ. My lord, here my lord, on 23/11/2018, my lord, my client has made an application under section 2 and 3 of the Partition Act, my lord, requesting the court to, my lord, permit me to buy the share of the 1/6 share of the appellant, my lord. That was allowed by the FDP court. That order has become a finality, my lord. It was not challenged by filing an appeal by the contesting appellant, my lord. Then, my lord, after their
FDP attained finality.
Yes, my lord. 23/11/2018 order has attained finality under section 3 of the Act, Partition Act, my lord. Then, my lord, after lapse of nearly 7 years, my lord, present appellant requests the court that, my lord, he don't want to sell his share, and therefore, my lord, commissioner was again appointed on suo motu, my lord. The second commissioner, my lord, files a report, my lord, before the court on 2/3/2020, my lord. Lord, on the next day, my lord, it was posted for objection by the parties, my lord. On 3/3/2020, my lord, we files objection, my lord, before the FDP court for the second commissioner report.
Second commissioner report for partition.
Yes, my lord. Second commissioner files a report, my lord, stating that some portion could be allotted to his share. My lord, our grievance before the first appellate court was that, my lord, on the same day of filing objection, my lord, the FDP was allowed, my lord, and he was ordered to be, my lord, allotted with the share. There was no consideration of our objection, my lord, to the second commissioner report. That is the first grievance. Then second grievance was that, my lord, since there was an already order dated 23/11/2018, my lord, permitting us to buy his share, which has reached finality. My lord, now the court cannot, my lord, allot a separate share to him, my lord, unless, my lord, he would have challenged the order dated 23/11/18, which has reached finality. That observing that, my lord, the first appellate court now holds
reverse the same
and holds that, my lord, the filing a second commissioner report, my lord, without there being a set aside in the first commissioner report, which has reached finality, is erroneous. And the first appellate court also holds that, my lord, the party shall be having the liberty to, my lord, participate in the proceedings of auction, my lord, and thus, my lord, reverses the order and, my lord, remits the matter by holding that, my lord, proceedings shall be taken in strictly in accordance with section 3 of the Act, my lord. Therefore, my lord, I may respectfully submit, since the order dated 23/11/18 was not, my lord, challenged by the party, my lord, the finding of the first appellate court is just and proper, my lord.
Order reserved.
Please.
ಇನ್ನೊಂದು ಯಾವ್ದೋ ಪಾಠ ಆಡಿದೆ. ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ ಪಾಠಾಡು?
ಹೌದು ಸರ್.
ಹ್ಮ್
20 minutes ಅಷ್ಟೇ.
ನಿಮಗೆ 20 minutes. ನಿಮ್ಗೆ?
No, I had heard on that day, after completion of his hearing, I will conclude it.
ನಿಮ್ದು ಆಲ್ರೆಡಿ ಆಗಿದೆಯಾ?
ಆಗಿದೆ ಸರ್. I will conclude it.
ಯಾವಾಗ?
ನೆಕ್ಸ್ಟ್ 26, 27.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎಲ್ಲ ಕೊಡಿ ಮೇಡಮ್.
26, 11.
26/3.
11.
Want of time. Sorry, 26/11.
48.
ಬಾಕಿದೆಲ್ಲ ಡೇಟ್ಸ್ ಕೊಡಿ.
ಹಾ ಸರ್. ಸರ್ ಇನ್ನ 2 ಪಾಸ್ ಓವರ್ ಇದೆ ಸರ್.
ಪಾಸ್ ಓವರ್ಗೂ ಇಲ್ಲ.
ಸರ್ ಅದು ಸೆಟಲ್ಮೆಂಟ್ ಅಂತ.
ಸೆಟ್ಲ್ಮೆಂಟ್ ಯಾವ್ದು? ಅದಾಯ್ತಾ? ಸರಿ ಮಾಡ್ಕೊಂಡ್ರ? ಸರಿ ಮಾಡ್ಕೊಂಡ್ರೇನ್ರಿ ಅದು? ಈಗ ನೀವು ಸರಿ ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಅದೊಂದು ಲಿಟಿಗೇಷನ್ ಆಗ್ತದೆ ಮುಂದೆ.
ಹೌದು.
ಸುಮಾರು ಕಡೆ ಇದೆ ರೀ, ನೀವು ಮತ್ತೂ ಮಾಡಿಲ್ಲ. ಇಲ್ಲಿ ಪ್ಯಾರಾ 4 ಅಲ್ಲಿ ಇದೆ ನೋಡಿ, ಅಪಲೆಂಟ್ ಪ್ಲೇಂಟಿಫ್ ಅಂತೀರಿ. ಪ್ಯಾರಾ 4 ಅಲ್ಲಿ ನಾನು ಫಸ್ಟ್ ನೋಟಿಸ್ ಮಾಡಿದ್ದೆ ಅದು ಅಪಲೆಂಟ್ ಪ್ಲೇಂಟಿಫ್ ಅಂತಿದೆ.
ಎಲ್ಲ ಮಿಕ್ಕಿದೆಲ್ಲ ಮಾಡಿದ್ರೆ
ನೋಡಿ ಇದನ್ನ ಮಾಡಿಸಿ. ಪ್ಯಾರಾ 4 ಅಲ್ಲಿ ಇದೆ ಅಪಲೆಂಟ್ ಪ್ಲೇಂಟಿಫ್ ಅಂತ. ನಮ್ ಕಣ್ಣಿಗೆ ಬೀಳದೆ ಅದು. Third, the appellant and also the respondent are present before the court, and also the respective counsels are also present. The parties have filed the compromise petition under order 2023, rule 3 of CPC. And in the compromise petition, it is stated that the respondent has realized that he has not left any space towards the southern side of his property. He has completely constructed the house without leaving any 5 feet space towards the southern side, and further admitted that the father of the appellant temporarily at the request permitted the respondent oblique plaintiff to keep spouts towards the southern side of the house of the respondent oblique plaintiff. Now, on the intervention of the same, parties have compromised the same, and respondent plaintiff admitted that there is no 5 feet space towards this southern side of his property, and the appellant oblique defendant is in possession and enjoyment of the property abutting to the property of the respondent oblique plaintiff. The parties also understood the terms of the compromise. ನಿಮ್ ಪ್ರೇಯರ್ ಏನು ಇದು? ಮತ್ತೆ ರಿವರ್ಸ್ ಆಗ್ಬೇಕಲ್ಲ? ಈ ಜಜ್ಮೆಂಟ್ ಅಂಡ್ ಡಿಕ್ರಿ ರಿವರ್ಸ್ ಆಗ್ಬೇಕಲ್ವಾ?
ಅದೆಲ್ಲ ಒಂದ್ ಕಡೆ ಬರ್ಬೋದು. ಪ್ಯಾರಾ ನಂಬರ್ 5 ಅಲ್ಲಿ ಬರ್ಬೋದು.
And also in the compromise, it is stated that plaintiff has already removed the spouts kept towards the southern side of his house, and same has been kept as per his convenient towards northern oblique western side of the property, and he has no objection to enjoy the property of defendant abutting to the property of the respondent plaintiff. And respondent has no objection to set aside the judgment and decree passed by both the lower court as well as the lower appellate court as claimed by the appellant defendant. The same is accepted. In terms of the compromise, the judgment and decree passed by the trial court and appellate court is reversed. set aside and reverse set aside involve the compromise and accordingly the RSA is disposed of. ಇನ್ಯಾವ್ದಿದೆ ಮೇಡಮ್? ಸಚಿನ್ BS ಏನ್ರಿ ಬಂದ್ರೇನ್ರಿ?
Sought any direction. They cannot afford my lords. 10,000 rupees.
ಹೌದಾ?
Please. What I can seek is my lords. Only for the period of 1 month. Let me vacate my premises. ಬೇರೆ ಕಡೆ ಎಲ್ಲರೂ ಜಾಗ ಉಟ್ಕೊಂಡು ಇದ್ ಮಾಡ್ತೀವಿ. Because ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 3 ಲಕ್ಷ ನಾವು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದೇವಂತೆ.
ಏನಿದೆ ಅದು ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಆಯ್ತು.
Please, that will be adjusted below my lords. Please.
Heard the appellant counsel and also the counsel appearing to the respondent. And this second appeal is filed against the concurrent finding of the trial court, wherein the trial court is directed to hand over the vacant possession within 90 days and also directed to payment of rent of rupees 36,400. Also directed to pay the rent of rupees 2,500 per month by the trial court, and the same is modified by the first appellate court at the rate of rupees 500 as per the admitted rent. Now the counsel appearing to the appellant would submit that going to vacate the premises within 1 month from today.
That's end of December. End of December.
End of
December.
End of December.
December 30th ಒಳಗಡೆ.
ನೀವು ರೆಂಟ್ ಕೊಡಕ್ಕೂ ಜಾಸ್ತಿ ರೆಡಿ ಇಲ್ಲ. ಏನ್ರಿ ಕೊಡ್ಬೋದಾ?
ಲೇಡಿ ಒಬ್ರೇ ಇರೋದು, ಅವರು ಅಂಗಡಿ ಹುಡ್ಕೊಳ್ಳೋದು.
End of December.
Please, Mr. Oblige.
Going to vacate the premises end of the December. And also submits that not going to seek any further time.
No.
Counsel for the respondent is also present and also submits that the respondent is trying to get the possession from the year 1998. Howda? Yes. And this is a second round of litigation. However, taking into note of the material available on record and also the reasoning given by the trial court as well as the appellate court and parties also, and the appellant is also in the premises from last long period, it is appropriate to grant time till 31st of December 2025 and made it clear that no further time will be granted in favor of the appellant. The rent already deposited.
Undertaking will be filed.
The appellant also file an undertaking affidavit within 1 week from today.
Please.
That going to vacate the premises on or before 31st of December by filing an undertaking affidavit. The amount in deposit before the trial court alla, and the same can be adjusted towards the arrears of rent.
Please. Obliged.
Final hearing ಎಲ್ಲ ಡೇಟ್ ಕೊಡಿಂದಲ್ಲ ಮೇಡಮ್? ಹೇಳ್ಬಿಡ್ಲಲ್ಲ? 48 512 49 ಆಲ್ರೆಡಿ
512 ಬೇಡ, ನನಗೆ ಹುಷಾರಿಲ್ಲ. 2 weeks ಆದ್ಮೇಲೆ
48 2 weeks ಮೇಲೆನೆ ಕೊಟ್ಟಿರೋದು. 512 ಅಂದ್ರೆ 2 weeks.
ಅದ್ರಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಮತ್ತೆ ಅದ್ರ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ರಜಾ. 48 ಹುಷಾರಿಲ್ಲ ಅಂತಂದ್ರೆ ಏನು 15 ದಿವಸ ಹುಷಾರಿಲ್ ಬನ್ರಿ?
ಸ್ಟಂಟ್ ಎಲ್ಲ ಹಾಕಿದಾರೆ, ರಿಸ್ಕ್ ತಗೋಬೇಡ ಅಂತ ಹೇಳಿದಾರೆ.
ಆಯ್ತು, 2 weeks ಕೊಟ್ಟಿದ್ದೀವಿ ಏನ್ರಿ? 48 ಮಧುಸೂದನ್ ರಾವ್ ಅಥವಾ ಇನ್ನೊಂಚೂರು ಜಾಸ್ತಿ? ಅದೇ ಇರಲ್ಲ, ಅವ್ರೇನ ಸ್ಟಂಟ್ ಅಂತಾರ್ರಿ. 13-12 ಸ್ಟಂಟ್ ಅಂತಾರೆ. 8-12 ಆಯ್ತು, 3 ದಿವಸ ಜಾಸ್ತಿ. ಸ್ಟಂಟಿಗೆ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಪ್ರೊಟೆಕ್ಷನ್ ಕೊಟ್ಟು 50 ಚಂದ್ರಶೇಖರ್ PV ರಾಜಗೋಪಾಲ್ 512 want of time. Balakrishna Shastri Giridhar.
Ready, my lords. Just take 2 minutes of the time of this court.
But ಅವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ,
Shorter date, my lords.
Shorter date 512. ಸಂತೋಷ್ ನೆಲಕುದ್ರಿ 512 ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಗ್ರಾಂಟೆಡ್, ಅರ್ಲಿಯರ್ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್. 53 512
54
512
55
For the respondent.
512
56
For respondent, my lord.
512
57 adjourn 58
58 512
59
512
60
60 my lord, I appear for appellate.
ಹಾ ಹೇಳಿ.
8th or 9th my lord, your lordship.
8th ಬಡವಾ?
9th your lordship.
ಹಾ
9th.
12 ಆಯ್ತು.
61.
61 NS Bhatt 512.
Okay, 62.
Nagaralai Santosh.
My lords, appearing for the appellant, my lordship.
512.
We have filed IA for stay, my lordship. We
Yeah,
stand under the temporary injunction. IA for stay of the judgment, my lordship. We
25
stand
matter
under the
ನಮ್ದು?
IA caption, my lords.
ನೀವ್ ಯಾರಿಗೆ?
I am for the appellant, my lords.
ಹಾ ಆಯ್ತು ಕನ್ಸಿಡರ್ ಮಾಡೋಣ 512 ಅಲ್ಲಿ.
My lordship, we will stand under the caption IA, my lords. Because IA is pending, my lords.
ಅಯ್ಯ ಆಯ್ತ್ರಿ ಈಗ ಅಡ್ಮಿಟ್ ಆಗಿದೆ. ಫೈನಲ್ ಇಯರ್ ಹೆಂಗ್ ಆಗ್ಬೇಕಷ್ಟೇ. ಈಗ ಅಯ್ಯ ಹಾಕೊಂಡು ಏನ್ ಮಾಡ್ತೀರಿ? ನೆಕ್ಸ್ಟ್ 63.
For the respondent, my lord.
512 for want of time.
Great.
ಹೇಳ್ರಿ ಏನ್ರಿ ಪಿಪಿ ಆಗ್ಲ? ಹಾ ಟ್ವೈಸ್ ಆಯ್ತು. ನಾನೇನು ಡ್ಯಾಮೇಜ್ ಮಾಡಿಲ್ಲ. 5,000 ಕಾಸ್ಟ್ ಕಟ್ಟಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದೀನಿ. ಹಾ
You are kindly accommodate me tomorrow. I will argue. It's only because of the slaps. I know I am wrong. I could not.
ದಿನಕ್ಕೆ 35 ಅಡ್ಮಿಷನ್ಸ್ ಇರ್ತದೆ. ನಾವು ಅಕಾಮಡೇಟ್ ಒಂದ್ಸರಿ ಮಾಡಬಹುದು. 2 ಸಲ 3 ಸಲ ನೋಡಿ.
ಒಂದೇನಂದ್ರೆ my difficulty I am facing with all, but only
ಏನ್ ಮಾಡೋದು? ಫಸ್ಟ್ ಒಂದ್ಸರಿ ಅಕಾಮಡೇಟ್ ಮಾಡಬಹುದು. ನೀವು ಪಾಸ್ ಓವರ್ ಕೇಳ್ದಾಗ ಕೊಡಬಹುದು. ಎರಡನೇ ಸಲ ಪಾಸ್ ಓವರ್ ಅಂತಂದ್ರೆ ಇಲ್ಲ. ಕಾಸ್ಟ್ ಹಾಕಿದೀನಿ, ನಾ ಓದ್ಕೊ ಬಂದಿರ್ತೀನಿ, ಮತ್ತೆ ನಾನು ಓದ್ಬೇಕು 5/12ಕ್ಕೆ. ನಾಳೆಗೆಲ್ಲ ಹಾಕೋದು. ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಈಗ. ಮೋಸ್ಟ್ಲಿ ಯಾವತ್ತಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಮೇಡಮ್? 512 ಇರ್ಬೇಕು ನೋಡಿ. ಯಾಕೆಂದ್ರೆ ನಾನು ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಡ್ತೀನಿ. ಯಾಕೆಂದ್ರೆ ಓವರ್ಲ್ಯಾಪ್ ಆಗ್ಬಾರ್ದು.
And I know you are lot of
people ಅಂತ ಹೇಳಿ ಮತ್ತೆ ಹಾಕೊಂಡು ಓವರ್ಲ್ಯಾಪ್ ಆಗ್ತದೆ, ರೀಚ್ ಆಗಲ್ಲ.
I know lot of time is spent for reading also by the honorable court.
ಏನ್ ಮಾಡೋದು ಅಲ್ವಾ?
I was wrong. I have to apologize.
ಲಾಯರ್ಗಳು ಓದ್ದವರು ನಾನು ಓದ್ಕೊ ಬರ್ತೀನಿ. ಏನ್ ಮಾಡೋದು? ನಂಗೆ ಈಗ ಫೈಲ್ ಜೊತೆ ತಗೊಂಡೋಗ್ಬಿಡ್ತೀನಿ, ಅದೇ ಕೆಲಸ.
I want to tell that my not
ಮನೆಗೆ ಹೋದ್ಮೇಲೆ ಅದೊಂದೇ ಕೆಲಸ ಓದೋದು. ಹಾ
ಅದಕ್ಕೆ ನಾವು ಯಾವಾಗಲೂ ಹೇಳೋದು, ನೀವು ಓದಿ ನಿಂತ್ರೆ ಸಾಕು, ಅವ್ರು ಓದ್ಕೊಂಡ್ಬರ್ತಾರೆ, ನಾನು ನಿಂತ್ರೆ ಸಾಕು.
ನಾನು ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ನಾರ್ಮಲಿ ಡಿಸ್ಮಿಸ್ ಮಾಡುವಾಗ ರೀಸನ್ ಕೊಟ್ಟು ಮಾಡ್ತೀನಿ. ಅಡ್ವೊಕೇಟ್ ಅಸಿಸ್ಟೆನ್ಸ್ ಕೊಡ್ತಾರ ಕೊಡಲ್ವೋ, ಬಟ್ ದೇ ಆರ್ ನಾಟ್ ಅಫೋರ್ಡಬಲ್ ಟು ಗೋ ಟು ದಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ದಟ್ ಐ ವಿಲ್ ಕೀಪ್ ಇನ್ ಮೈ ಮೈಂಡ್. ಎಲ್ಲರಿಗೂ ಹೋಗಕ್ಕಾಗಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಇವತ್ತಿನ ದಿವಸದಲ್ಲಿ ಕಷ್ಟ. ಹೈಕೋರ್ಟಿಗೆ ಬರೋದೇ ಕಷ್ಟ. ಇನ್ ಮತ್ತೆ ಅಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು ಅಂದ್ರೆ ಇನ್ನೂ ಕಷ್ಟ. ನಾನೇ ಪೇನ್ ತಗೊಂಡು ನಾನೇ ಬರಿತೀನಿ, ಪರವಾಗಿಲ್ಲ, ನಂಗೆ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ನಂಗೆ ಕೆಲ್ಸವೇ ಅದು. ಅದರಿಂದ ನಾನು ಅದನ್ನ ನೋಡ್ತೀನಿ.
ಇದೊಂದು ಕೇಸು ತಾವು ಪೆನಲ್ಟಿ ಹಾಕಿ ನಾವೇ
ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ ಡೇಟ್.
ಹೌದು, ಅದ್ರಲ್ಲಿ ಹಾಕಿದ್ವಿ. ಅದು ನಾವು ನಮ್ ಬೇಕಾದ ಅಡ್ವೊಕೇಟ್ ಕಳಿಸಿದ್ದು ಬಹಳ ಮೊದಲು. ಇದು ನಾವು ಹ್ಯಾವ್ ಟು ಕಂಟಿನ್ಯೂ ದಟ್ಸ್ ಆಲ್.
ಏನ್ ಹೇಳಿ?
ಅಡ್ವೊಕೇಟ್ ಬಹಳ ಮೊದಲು ಕಳಿಸಿದ್ದಾರೆ ಫೈಲು. I have to continue myself. He is my very friend.
ಅದಕ್ಕೆ 5,000 ಹಾಕಿದ್ದೀನಿ.
Very good friend. I have to
5,000 ಹಾಕಿದ್ದೀನಿ, ಜಾಸ್ತಿ.
I'm continue with that.
Second
I leave it to the
second appeal is a luxury. that to
ಇಲ್ಲ ಸ್ವಾಮಿ,
concurrent finding.
ಇದರೊಳಗೆ ಇಲ್ಲ concurrent ಅಲ್ಲ ಸ್ವಾಮಿ.
ಹೌದಾ?
ಅಲ್ಲ
ಏನಾಗಿದೆ?
Divergent
ಆಯ್ತು ನೋಡೋಣ. ಆಯ್ತು ಪಿಪಿ ಆ ಕಡೆ ಎಂಗೇಜ್ ಮಾಡ್ಕೋತಾರೆ ಅಂತಂದ್ರೆ 5,000.
ನಮ್ಗೆ ಏನಂದ್ರೆ ಎಲ್ಲ ಕಡೆ ವಕೀಲರು ಫ್ರೆಂಡ್ಸ್ ಆಗಿ ತುಂಬಾ ಜನ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ನಾವು ಹಣಕ್ಕಾಗಿ ನಮ್ ಫ್ರೆಂಡ್ಶಿಪ್ ಜಾಸ್ತಿ ಇರುತ್ತೆ ನಮ್ದು. ಇದು ಬೇಕಾದವ್ರು ಅಡ್ವೊಕೇಟ್ ಅವ್ರು ಆಫೀಸ್ ಬೇರೆ
512 ಕೊಟ್ಟಿದೀವಲ್ಲ, ಅವತ್ತು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ಹಾ
ಪ್ಲೀಸ್.
ಎಷ್ಟು? 15. ಆಯ್ತು. ನಮಗೆ ನಾನು ಸ್ಟ್ಯಾಟಿಸ್ಟಿಕ್ಸ್ ತಗೊಂಡಿದ್ದೀನಿ.
ಅಲ್ಲ, ತಾವು ಹಂಗ್ ಮಾಡಿದ್ರೆ
ಫೈಲಿಂಗ್ ಎಷ್ಟು ಆಗ್ತದೆ, ಎಷ್ಟು ಡಿಸ್ಪೋಸಲ್ ಆಗ್ತದೆ ಅಂತ. ಡೈಲಿ 10 to 15 ಫೈಲಿಂಗ್ ಆಗ್ತದೆ. ಅದಕ್ಕೆ ನಾನು ಕಾಂಪನ್ಸೇಟ್ ಮಾಡಿ ಇನ್ಫ್ಲೋ ಔಟ್ಫ್ಲೋ ಆಲ್ಮೋಸ್ಟ್ ಅದನ್ನೇ ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
ಹಂಗೆ ಮಾಡಿದ್ರಿ ಕ್ರಿಮಿನಲ್ ಇರುವಾಗ
10 to 15. ಅವಾಗ ಏನಾಗ್ತದೆ, ಜಾಸ್ತಿ ಆಗಲ್ಲ. ಇನ್ಫ್ಲೋ ಔಟ್ಫ್ಲೋ ಮ್ಯಾನೇಜ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಮೇ ಬಿ ಇಟ್ ಈಸ್ ಪೇನ್ ಟು ಮೀ, ಬಟ್ ನೋ ಪ್ರಾಬ್ಲಮ್. ಅಡ್ವೊಕೇಟ್ಸ್ ಅಸಿಸ್ಟೆನ್ಸ್ ಕೊಡ್ದವರು ನಾನು ನೋಡೇ ಆರ್ಡರ್ ಬರೆಯೋದು. ಅನ್ಲೆಸ್ ಐ ಆಮ್ ಕನ್ವಿನ್ಸ್ಡ್ ವೈಲ್ ಪಾಸಿಂಗ್ ಎನ್ ಆರ್ಡರ್, I won't dictate any orders, whether I get assistance from them or not. ಅವ್ರು ಓದಿಲ್ಲ ಅಂದ್ರೆ ನಾನೇ ಓದಿರ್ತೀನಿ, ಅದನ್ನ ನೋಡೇ ಬರಿತೀನಿ.
ಇದ್ರಲ್ಲಿ ಒಂದು ಇದು ತೆಗೆದುಬಿಡು ಸ್ವಾಮಿ, ಪೆನಾಲ್ಟಿ.
ಏನ
ಪೆನಾಲ್ಟಿ? ಲೀವ್ ಇಟ್ ಇನ್ ದ ಕೋರ್ಟ್. ಆಗ್ಬೋದು ಪ್ಲೀಸ್.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಏನಾಯ್ತು ಮೇಡಮ್?
ಅದೆಲ್ಲ ರೆಫರ್ ಟು ಲೋಕ್ ಅದಾಲತ್ ಸರ್.
ಯಾವತ್ತಿಗೆ ಅಂತ ಏನ್ ಹೇಳಿಲ್ವಲ್ಲ?
ಅದು ನೀವು ಅಡ್ವೊಕೇಟ್ ಎಸ್ ಸಚಿನ್ ಅವ್ರು ಯಾರು ಅಪಿಯರ್ ಆಗಿರೋದು?
ಎಲ್ಲ ಫೈಟ್ ಅಲ್ಲ,
ಸಚಿನ್ ಹಾಕರ್ತಾರೆ
ಅದರಲ್ಲಿ ಎಲ್ಲ ಫೈಟ್ ಅಲ್ಲ. ಇಲ್ಲ 4 ವಾರ ಅದು ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ, ಇಲ್ಲ 4 ವಾರ ಬಿಟ್ಟು ವಾಪಸ್ ಬರ್ತಾರೆ.
ಇಲ್ಲ ಇಲ್ಲ ಡಿಸ್ಪೋಸ್ ಹಾ ಹೌದು ಸಚಿನ್ ಅವ್ರ ಹೆಸರು ಹಾಕ್ಬೋದಾ ಆಮೇಲೆ ಇದು
ಹಿಯರಿಂಗ್ ಬೇಡವಾ?
ಇಲ್ಲ ಅವ್ರು ಬೇಡವಂತೆ ಬೇಡವಾ ಅವ್ರ ಹೆಸರು ಈಗ್ಲೇ ಹೇಳಿ ಕೇಳಿ ಇವಾಗ ಕಳಿಸ್ಬೇಕು ಫೈಲ್ ನಾನು ಹಾ 192 ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆ ಅದಕ್ಕೂ ಇದಕ್ಕೆ ತಗೊಳಪ್ಪ ಅದು ಆ ಫೈಲಲ್ಲಿ ಅವ್ರು ಮಂಜುಳಾ ಅಂತ ತೋರಿಸಿದಾರ ಅಂತ ನೋಡಿ ಮಂಜುಳಾ ಬೇಡ ಹೆಸರು ಇದನ್ನ ಇರಪ್ಪ ಒಂದ್ ನಿಮಿಷ ಈಗ ಇವ್ರಿಗೆ ಆಗಿರೋದು